I may be permitted to move an unlisted matter. There is some urgency in it.
What is the urgency?
My lord, you'll also will find this, the petitioner has been working in the institute for long 30 years. He has not been regularized. Now, what they are doing by, they are going to take a contractor to take hold of our cases. My lord, a teacher cannot be construed to be a workman as held by the apex court many a times. Instead of that, my lord, they are saying that they are skilled worker. My lord, the Supreme Court said they cannot be constituted skilled or unskilled in any state. So therefore, the NIT is going to be materialized in Monday, my lord, next. So therefore, the urgency lies there.
NIT,
Beg your pardon.
does it concern this bench?
Yes, yes. It's a academic matter, my lord. So
Okay.
therefore,
At two?
at 2, I'm obliged.
May I please, my lord, item number 66, my supplementary list. This matter was day before yesterday, fixed my lord due to urgency today, my lord, and was a prayer for taking at 2 p.m., my lord. 66. So day before yesterday, it is fixed for today, my lord. There is an urgency, my lord, regarding my lord. The admission session started, my lord, the pharmacy college, my lord, and there is a restriction by the state government for not to give the admissions, my lord. So my lord may kindly be taken at 2, my lord. Obligement.
May I please, your lordship, my lord. My lord, I have a prayer for listing, my lord. I filed one additional affidavit in one of my case, my lord, on 9th of March, my lord, and it was supposed to be listed after 2 weeks, my lord. The matter has not been listed till date, my lord. May I request your lordship, my lord, to list the matter, my lord, after a week, my lord, on my lord, next Friday, my lord, 23rd of my lord, this month, my lord.
Going to be difficult next week. Why can't we have it after the vacation?
Lord, before vacation, my lord, it is necessary, my lord. 26th of my lord, then June, my lord.
Okay.
My lord, available.
May it please, your lordship.
Lordship, I beg to pray for listing of contempt matter, Lordship. Some urgency in our court, Lordship.
What urgency is there?
Urgency is that the dishonorable court passed an order for provincial resolution service of the
After the vacation, after vacation.
May I please, your lordship. My lord, the matter was last listed on January 2023, my lord.
Hmm.
But the business of the court did not permit to take up the matter.
After vacation. After vacation.
My lord, I am praying for IA lordship for listing on Monday lordship.
Why?
My lord, this is a matter relating to non-payment of salary lordship that has already been directed. But some changes, officer has been lordship transferred. We have to implement lordship, some urgencies there lordship
21st.
of my lordship.
May I please, your lordship? Lord, I'd like to mention for listing of a matter in court. So can I have it on 26th of this month?
No. After vacation.
Pardon?
After the vacation.
And please, your lordship, I like to mention for listing on the matter on Monday, your lordship.
Why? Why?
My lord, the service is complete, your lordship. The matter relates to the appointment of a in-charge principal of a higher secondary school, your lordship. In spite of High Court order as well as the settled law in my favor, the authority appointed the private student to that post, your lordship. The school is suffering, you know,
School is suffering.
on 19th, your lordship.
In charge principal has already taken over or not?
Not, your lordship.
27th.
Privilege lordship.
Oblige,
I
your
wish to
lordship.
mention for listing contempt case lordship regarding family bench.
After vacation.
May I please, your lordship, I beg to mention 2 items for listing, lordship.
After vacation.
Much obliged.
May I please, I beg to mention for listing, my lord, one, it was last posted on 1st March 2023.
After vacation.
Item 24, 25, 26, my lord, I've taken the consent of the other side. We are supposed to file one affidavit, additional affidavit. Can it be, my lord, taken up next week, my lord? In the meantime, I will file my affidavit.
My lord, it's a very urgent matter, Lordship. I pray, Lordship, that matter may become on 28th, Lordship.
28.
No, 20, Lordship. 20 June, Lordship. It's regarding Lordship,
Or on a hearing, my lord, on 22.
orders, admission, Lordship. It's an admission matter, Lordship. It's a very urgent.
K. Majumdar, have you given your mention slip? Not yet.
My lord, no, my lord.
Then
Then otherwise, also, my lord, I will have to take time, my lord. When the matter is
let it reach. We'll see.
my lord.
And Lordship, my learned friend supposed to
submit an inquiry, already submitted inquiry report, Lordship. May I pray, Lordship, that inquiry?
Let it reach.
Lordship.
Item 65, my lord, the medical student matter, the lordship has dictated the order. Government is supposed to give the information today. That's 65, my lord, that medical students matter, my lord. Where your lordship has already dictated the order and government sought time for which session it is, 23 or 24.
But, let it be after the motion, my lord. I will place certain regulations regarding that, my lord. He has joined in, my lord, 2009.
Yes.
During the first semester of MBBS, because of some health reason, he could not pursue. Now in 2023, he wants that he should be allowed to take admission in the MBBS course. That seat has already left, my lord. He has joined and thereafter he could not pursue. Maybe, my lord, for reasons, my lord, beyond his control. Lordship will have to examine, my lord, whether he can now be admitted. My lord. I will place certain regulations.
National
Where there is a
Commission has
time
already
frame.
already placed on record, my lord, that there is no bar. Bar has started from 2019.
But it is there, it was there in 2012 also. I will place it. I will.
Okay.
Regulation of MCI.
Let it reach.
After the motion, my lord.
Yeah.
Item one of the list.
Yes. Here, Lordship directed me to verify whether this case, there is appeal pending before the division bench regarding the music teacher, consideration of music teacher, Lordship. And there's an order in this in this case that matter will be released after the after some time later disposal of this division bench matter. So the appeal covers the relief sought hearing by this petition, Lordship, because they have sought their consideration under Lordship this section 4, section 2 and 4. And this particular section has been challenged in that before the division bench, Lordship. So if the division bench interferes tomorrow, Lordship, then this petition will be coming further.
Lordship, my case is there, the petitioner is covered by the, under the rule, by, for the section.
No, that, but that rule is under challenge.
Yes.
Yes, my lord.
4, section 4, subsection 2.
Third MS A. Badru Goyal, Learned Counsel for the petitioner. Mr. SMT Chishti, Learned Standing Counsel, Secretary Education submits that similar matters are pending.
That rule has been challenged under which she has sought the relief, Lordship.
What rule is it?
The Lordship may can turn to page 115, section 4, Assam Education Commissioner of Service, Teachers and Regulation,
Page,
Organization of Education Act,
Page 114.
page 115, section 4, subsection, subrule, subsection 2 and 4. Page 115. 114, this is section 4.
section 4,
Subsection 2, 4, Roman 4,
that rule 4 within bracket 2,
and Roman 4.
within bracket Roman 4 is under challenge before the Honorable Division Bench. And please that this matter.
And the leading case is WPC number 2779/2019.
Please that this matter be listed after disposal of the set
Yes.
with machines. Stop. There is a lot list after 4 weeks. Let's.
So. This matter relates to compassionate apartment, Lordship. The father of the petitioner died on 3/9/2011, Lordship. And he applied on 27/9/11, Lordship, kindly see page 16, the application, Lordship. Within 24 days, he applied, page 16.
Yes,
Then this was forwarded by the headmaster, Lordship, the same 27/9. Lordship, thereafter by DLC dated 21/4/12, Lordship, kindly see page 20. Rejected, Lordship.
yes.
Serial number 25, Lordship, got it? 25, Nitin Bora, so date of death 3/9/11. Here, Lordship, date is wrongly mentioned 9/2/12. It should be 27/9/11, Lordship. Although it is 5 months, Lordship, according to them, application submitted delay after 5 months, Lordship. Then, Lordship, he challenging this, Lordship, petitioner filed a writ petition, Lordship will file page 21.
Then
21, Lordship, I order dated 9/2/2015. Next page, Lordship, page 22. And second para, Lordship, from top, Lordship, 7 line in the middle, Lordship. However, his application was rejected by the district level committee, so and so, on the ground that it was submitted lately
after 5 months, the law in this behalf is settled. The period of limitation for filing on application for compensation ground is 1 year from the date of decease. There is no doubt at the bar that the application for so and so was filed by the petitioner within 1 year from the date of death of his father. Then, Lordship, in the result, respondent number 3 is directed to reconsider the case of the petitioner on merit and dispose of the application according to the law in the period of 2 months, Lordship. That was direction, Lordship. Now, Lordship, thereafter my case was not considered. I filed an RTI application, Lordship. Kindly see, Lordship, page 27. The reply has been given, Lordship, by the additional deputy commissioner by order dated 22/9/2015, Lordship. A reply, Lordship. 3. The application of the petition was submitted after 5 months from the date of death of his father instead of stipulated period of 3 months. As per the guidelines of for opponent so and so, his application has been spent force. Without placing my case, Lordship, the RTI reply has been given to my youngest counsel by whom I filed the RTI application. My case was spent force, Lordship. Since there is a direction from the court, Lordship, to consider my case, but they have not considered, only informed me, spent force, Lordship. I have filed within 24 days, although if the date is, as per them, it is taken, Lordship, dated only within 1 year, Lordship. Within 5 months, I have filed, Lordship.
Was it placed before DLC?
Lordship, there is no specific mention, page 27. Thus, they said RTI application, reply to question number 3. The application of the petition was submitted after 5 months from the date of death of his father instead of stipulated period of 3 months. As per the guideline, so and so, his application is spent force, Lordship. The outcome of the person to the honorable court, so the outcome was not intimated to me. That is why I through an advocate file an RTI application. This was furnished to me, spent force.
When was this first DLC held?
Lordship, first DLC, Lordship, 21/4/12. Page 18, Lordship. 20, page 20, Lordship.
Where's the date?
Lordship, Lordship, page 18, Lordship. This is, I have got through RTI reply, page 18. Page 18, 15 December 14. With reference to subject side, I am to inform you that your proposal for appointment compensation got placed in the DLC meeting held on 21/4/12, but the DLC could not recommend the proposal due to late submission of application, Lordship. That I was challenged, Lordship. I challenged, and the order directed to.
So you got the information in 2015.
Yes, Lordship.
When did you file this writ petition?
Lordship, 23, Lordship.
Why?
Lordship, I have stated, actually, I was expecting that there is a court's order, and they repeatedly told me they.
After this information that you got from the RTI,
Yes, Lordship.
what expectation did you have?
Lordship.
What expectation do you have? You didn't have any expectation. You should have approached this court
Yes, I have.
on time.
Lordship, actually, I was not aware of these things since the officials told me that it will in
You
continuous
approached
process.
this court after 8 years.
Yes, Lordship.
That
And the similarly situated person, those who are, Lordship, waiting their service, they got appointment.
maybe they've got their service, but then
And-
your case is a clear case of delay and lectures.
That's true, Lordship, admitted, Lordship, but the case is, it is their duty to inform, Lordship, as per the.
That they have informed you through the RTI.
Now, I filed the RTI reply, then only the
That's
reply.
why RTI reply was given to you on 22nd September.
Yes, Lordship, then only I came to, I was expecting that my case would be
After
considered.
22nd September 2015, what were you doing?
Lordship, I approached, they told they in turn, all those cases will be considered altogether, Lordship. And-
How did you approach?
Lordship, I have stated, Lordship, page 10, para 8, Lordship. Page 10, para 8, Lordship. And Lordship, the concerned counsel,
So you went to Kerala?
yes, Lordship, I am a
You went to
Lordship.
Kerala enjoying your life.
No, Lordship, I'm the daily laborer, Lordship.
Then
Lordship,
what
So-
happened?
Lordship, I told my concerned advocate to take care of the matter with the authority, but he was not informed in time, Lordship. That is why I delayed some, Lordship. I was expecting.
This explanation is not accepted.
And-
Yes, Saikya, what is?
My lord is absolutely correct, my lord. That is on 22nd September 2015, my lord. Normally mandates of the DLC, my lord, within 2 months, my lord. That is the law, my lord. And my lord,
But they
even
have not
in the
informed-
paragraph number 8, he is saying that he went to the Kerala for searching the job, my lord. That means he has already taken the alternate life development.
But as our High Court judgment, it is their duty to inform the outcome, but that was not informed, Lordship.
That was informed through RTI.
Later on, Lordship. When I
Later on, 2015, at least you were informed.
No, Lordship. No, Lordship.
Yes,
Eh, did-
2015.
Yes, Lordship, 2015, Lordship.
Then after
Last-
2015, you explained the delay after 2015.
Lordship, actually, that was addressed to my counsel, Lordship. He did not inform. Kindly see, Lordship, page 27. Page 20, addressed to so-and-so advocate, so-and-so, Lordship. I filed through him, Lordship. He did not inform me, Lordship. That is not addressed. I throw him, Mrs. S. Khandakar. Through him, I filed an RTI reply, Lordship. That was not, he was not informed by the concerned counsel, Lordship. That is the reason, Lordship, I have stated in page 10, para 8, Lordship. It is not directly to me, Lordship. When again I came to the query, then also this counsel informed me this is the RTI reply. I was not. Then I approached. I have stated clearly, Lordship. Now, Lordship,
Nothing.
at least one chance, Lordship, is a poor
No
person,
chance,
Lordship,
no chance.
equitable.
After 8 years, you are coming, it's too late.
But
I have to dismiss.
Lordship, Lordship, some other, I came to some other cases were faced by this registry, Lordship. Those are regarding delays, Lordship, for consideration.
That I don't know.
Yes, Lordship, day before yesterday, I came to Lordship. Some other cases regarding this completion amendment, those are segregated. Those are different grounds.
What segregated by who?
Some are rejected due to submitted after 1 year of the application. Those cases were required to be considered and registry has directed by Honorable Justice Suman Cham, Lordship, for segregating those
This is
matters.
your case is a different matter.
That delay, Lordship, the one my submission, Lordship, the
I'll dismiss it. There's no other option.
Lordship sometimes may be given, Lordship.
What?
Satisfy, Lordship,
What satisfaction?
after vacation, Lordship.
What satisfaction do you want?
Lordship, some judgment is there, Lordship, I'll show
You
you,
can't
Lordship.
improve, you can't improve your para 8.
No, Lordship, kindly see, I have,
You can't improve on your para 8 now.
and petition also files their representation, Lordship.
Where
That is 11-4 to the request of the Deputy Commissioner to consider a case as per
where
order
that
dated.
representation?
Lordship, that I did not keep,
That you
Lordship.
annex it? You can withdraw and file afresh.
Lordship, I'll file the additional affidavit, Lordship.
On request made by Mr.
S.V. Ahmed.
S.E. Ahmed, Legal Counsel for the petitioner. Is the matter after summer vacation.
May it please your lordship, the matter pertains to de-amalgamation of the petitioner school from that of respondent 7 and 8, your lordship. On the last occasion, the education department was supposed to bring instructions regarding the issue, your lordship. And there's an interim order.
No, we have not received an instruction, Lordship. The interim continued notice of all, Lordship.
Okay, heard MS.
S. Hazarika.
SS Hasarika, Legal Counsel for the petitioner, issue notice. Mr. SMD Chishti,
1, 2,
Learner Standing Council. Secondary Education appears for 1, 2,
5,
5,
6.
6,
but 1 to 5.
1, 2, 5, and 6. Mr. P. Cycle, Learner Government Advocate appears for respondents,
3, 4.
3 and 4.
In number.
Petitioner to take steps for service of notice on respondent 7 and 8.
Hmm?
By registered post ID within 1
One
month.
given
from
second.
date. List the matter after 4 weeks.
Yes.
Interim order passed earlier to continue.
My lord, may I pray our name
Okay,
may be shown in the first list, my lord.
Registry is also directed to reflect the name of the government advocate.
My-
in the first list.
Obliged.
4.
May I please your lordship, the case is regarding compassionate appointment, lordship.
Mm.
The proposal of the petitioner not recommended before the DLC, lordship.
Mm.
This is the case, lordship. Lordship will find application of the petitioner at page 26, lordship.
Mm.
Page 26, lordship. The petitioner filed an application. And at page 35, lordship will find the forwarding at page 35, lordship. The BO Sonitpur forwarded the application to DO Lordship.
Yes.
But in 2022 Lordship, the petitioner belongs to originally Sonitpur district, but in 2016, new district were created as Bishwanath. Hence, under Bishwanath district, the writ petitioner filed a writ petition. That petition, Lordship, the order is at page 36, Lordship. The district of the petitioner was earlier Bishwanath, but now she belongs to Sonitpur. Lordship will find the operative paragraph of the judgment, Lordship, at page 37, Lordship. The page 37, Lordship, the last para, by the said communication dated so and so, the Deputy Commissioner Bishwanath further placed before the court that the proposal of the petitioner had not been submitted before the DLC district Bishwanath, and that since creation of the district Bishwanath in the year 2016. The petitioner filed application in 2015, Lordship, under Sonitpur district. But when new district were created as Bishwanath in 2016, the Deputy Commissioner, Lordship, replied that there is no such type of application before the Bishwanath. Hence, again, Lordship, the petitioner has come before this Honorable Court, Lordship, being a resident of Sonitpur district, Lordship. In earlier writ petition,
Your writ petition was dismissed.
Lordship, because Deputy Commissioner replied that, informed that there is no proposal in the Bishwanath district when new district were created, because petitioner filed the application prior to the Bishwanath creation, Lordship. Hence, being the Sonitpur district resident, Lordship, this writ petition has filed, Lordship. So, Lordship, direction may be sought,
No,
Lordship.
it says DLC Sonitpur did not recommend the case of the petitioner.
Lordship, hence this case, Lordship,
Why?
that the proposal was not recommended before the DLC, Lordship, hence the direction, Lordship.
No, DLC Sonitpur
Lordship,
considered a matter and did not recommend.
Lordship,
Bishwanath did not consider.
Lordship,
Then
Lordship. Lordship, now she belongs to Sonitpur district.
exactly, Sonitpur has already considered your matter. That's why this writ petition was dismissed.
Lordship.
Then how
But-
can you file a second writ petition after this dismissal?
As per instruction of client, Lordship, that she belongs to now Sonitpur, again.
Sonitpur considered you, DLC Sonitpur considered the matter, isn't it, Mrs. Saiki? As per this judgment,
As per page number 38. Last page.
how can you maintain a second writ petition after this dismissed?
Lordship, earlier it was Bishwanath district. And
Bishwanath district did not consider your matter.
Lordship,
TLC Sonitpur considered your matter. Now
Lordship.
you want another direction to the DLC Sonitpur to consider your matter.
now again,
It was
she,
considered by the DLC Sonitpur. And therefore this court found that there was no merit in your writ petition and was dismissed. Now what more do you want?
And-
How can you maintain a second writ petition? Tell me,
in earlier case,
on the
Lordship,
same grounds.
in earlier writ petition, Lordship, the Deputy Commissioner Bishwanath has replied, Lordship, the instruction from the DC Bishwanath. And
Exactly, that was. And what does the reply say?
that the last paragraph, Lordship, of page 37, by this said communication dated so and so, the Deputy Commissioner Bishwanath further placed before the court that the proposal of the petitioner had not been submitted before the DLC Bishwanath,
Above that,
Lordship. And that further the Deputy Commissioner of District Bishwanath by communication so and so apprised the court that earlier the case of the petitioner was considered by the district level for commissioner appointment of Sonitpur district
Stop.
prior to Lordship.
Stop.
Lordship.
So you were considered by Sonitpur.
But when declared in 2016 as a Bishwanath district, Lordship, the
By the time it was declared, your
Declared.
case was already considered.
Already considered.
but the petitioner filed prior to Bishwanath district
That's
declaration.
why prior to creation of Bishwanath
Bishwanath,
district,
Lordship,
your case was considered by Sonitpur DLC.
Lordship,
Now, how can I give a direction to the
Sonitpur,
Sonitpur again after it is dismissed on that ground?
Lordship. But the petitioner
How
thought,
can you maintain a second writ petition? No,
and due to the different district, Lordship,
No.
hence,
it is hit by the
SK Sarkar, Lordship. And some time may be given
No,
to
no.
fresh filing a fresh writ petition if any materials is found, Lordship.
You want to withdraw?
Yeah, Lordship.
Mr. S.K.
Yes, yes,
Sarkar,
Lordship.
Learned counsel for petitioner place for withdrawal of this writ petition.
My lord, in case of withdrawal petition, that observation may be recorded, my lord. Because my lord, again, same issue, my lord, will come, my lord. Otherwise, that is not justified because already his
With
claim has.
liberty to file afresh if a new cause of action are executed.
My lord,
Mr. Cycle,
my lord, I'm correspondent number 4.
Governor Advocate, address to respond number 4, and Mr. G. Biku.
G Pegu, my lord.
Learned
Respondent
standing
number,
counsel, appears for the,
I'm for 1 and 4 minutes, sorry.
2 and 2,
appears
three.
for the.
2, 3, 5, my lord. 2, 3, 5.
Writ petition is accordingly dismissed with liberty as certified.
Highly obliged.
5.
May I please, your Lordship? The petitioners, your Lordship, have applied for the post of grade 4, advertisement page 17, my lord, annexure A. Annexure A, my lord, page 17.
Grade 4.
Great, yes, my lord. That is the advertisement, my lord. Accordingly, the petitioner have applied and calling letters were issued, page 19, my lord. In calling letter, it is specifically mentioned, my lord, there will be 30 marks for written, 5 marks for experience, and oral and viva for 15 marks, my lord. After the interview, my lord, they have published my lord, comparative statement of scores, page 25, my lord. The relevant portion I have mentioned, my lord. They have not mentioned it as a select list, my lord, but they have stated as, published it as consolidated statement of scores. Now, my lord, the petitioner, serial number 21, my lord, sees in her column, my lord, president 32.25, Dr. Anjali Chakraborty 32.25, and all others, my lord, given 32.25, similar, my lord, numbers.
Page 25.
Page 25, my lord.
Oh, where is? Yes.
Page 25, my lord. Got it. Yes, my lord. Serial number 21, my lord. My lord, got it, my lord.
Yes.
Yes, my lord. All have given equal marks, my lord, 32.5, 30.45, my lord, experts were there, my lord. And some average were taken out, my lord, strangely, 32.5. It is the second. Serial number 15, my lord, Krishna Boro. She has given 33, 32, 33, 32, and 32, and 33 by experts, my lord. 6 experts were there, my lord, including college principals. Now, my lord, when this was hanged in the notice board of the college, when the petitioner approached that what is the list is all about, they have informed us, my lord, this is the select list, my lord. Now, my lord, for the select list, there are criteria that 30 marks for written, my lord, 5 for viva, and 15 for 5 for experience, 15 for viva, my lord. Nothing of that sort has been mentioned, my lord. How they calculated these marks, where is the written marks, nothing has been mentioned at all, my lord. Now, as per the information, my lord, I've specifically stated, my lord, the private responses name has been selected and sent for, my lord, appointment, my lord. Nothing of that sort, some strange kind of, my lord, I have never seen in my life, my lord, this kind of, my lord, this kind of list, my lord, where there are 5, 6 experts and marks have been given, where the maximum marks is 50, my lord. They have given 33. Out of what 33, my lord? There is no mention. What is the written marks I have obtained? No mention. So strange kind of, my lord, they have published this select list, my lord.
Yes, Lordship. I am applying for a higher. Lordship, in the rule, Lordship, some college employees pronunciation rule 2010, Lordship.
What is it?
Some college employees pronunciation rule 2010, Lordship. This case governs by this rule, Lordship. And Lordship, there, Lordship, the case is at this stage, it's a premature case. Lordship has also passed a number of orders in this. Because after making a selection by the governing body, Lordship, the next step is to forward it to the director of the higher education. And thereafter, Lordship, director will examine the case and then the passing of Lordship appointment order comes. So here in this case, as per my friend, Lordship, that has been forwarded. No, the director has not taken any steps, Lordship. So Lordship, they let them file a representation before the director as earlier, and the director will not look into it, Lordship. It is clear in the state, the Lordship state it, Lordship. Lordship may come to the rule 5, it says.
Page
496, Lordship. Page 496. Rule 5, Lordship. Sub Rule 2. Rule 5 relates to method of recruitment, Lordship. Sub Rule 2 relates to grade 3 and grade 4. Then, Lordship, Sub Rule 7, Lordship.
Sub Rule 2.
Sub Rule 2, Lordship, Rule 5 relates to method of recruitment. Sub Rule 2 of Rule 5, which, may I read that, Lordship? Sub Rule 2. The process of selection should be there, Sub Rule 2 says, for grade 3 and grade 4. Thereafter, Lordship, Sub Rule 7 of Rule 5, it says, in all the cases, governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. Then Rule 7 also, direct recruitment, in case of Rule 7 below, Lordship. Rule 7 also says that all the appointment, either by direct recruitment or by promotion, shall be made by director on the basis of the recommendations of the governing body, based on the recommendations of the selection committee, departmental promotion committee duly considered. So at this stage, Lordship, they have just selected and forwarded. So there are a number of judgments of this annual report that the director is not the rubber stamp, Lordship. So he will verify, Lordship, let them file a representation along with the Lordship, their petition, Lordship. If they are agreed by the order, then they can again come, Lordship.
My lord,
And a specific time may be given to the director to pass a speaking order. If there is, Lordship, any anomaly.
my lord, yes, I have filed a representation also, my lord, before the director of both higher education, government of Assam and the BTC, my lord. On, my lord, 8th May 2023 itself, my lord. So on 8th May,
Dispose of this, Lordship.
page 27, my lord, see, explaining everything, my lord.
Yes,
Page 27. Page 27, my lord. My lord, on 8th May 2023, my lord, till now, my lord, nothing has been communicated to us,
yes.
which goes to show that, my lord, there may be some malafide intention, my lord. Otherwise, director should have informed us, my lord, that this is the process, you need to wait. Nothing has been till now, my lord. It's more than 1 month. And secretly, perhaps they are moving to appoint, my lord. After that, nothing will remain to us. That's why we have approached the honorable court. We have filed the application before the authority, my lord, the appropriate authority.
May not be appointed, Lordship. There may be observation may be given. Let them file the, let them, Lordship, approach the honorable director.
The whole statement, my lord, how they given marks, my lord. My lord, even then, if director is supposed to, my lord, verify, but there should be some basis of selection of these marks, my lord. Absolutely, my lord, no transparency at all, my lord.
Let him consider your representation.
Yes, my lord, at a time frame, my lord.
Otherwise, this writ petition is premature.
Yes, Lord. There are number.
Director has not taken a decision.
Yes, my lord, at a time limit, that is the assumption and speaking order, my lord, that's
Third, Mr.
D. Sharma, my lord.
D. Sharma, learned counsel for the petitioner. Also heard Mr. A. R. Davilta, learned standing counsel, higher education for respondents.
Lordship.
One,
Yes, Lord.
two,
1, 2.
I'm appearing for 3, 4, and 5, your lordship.
1 and 2,
Lordship, 1 and 2.
and MSS Das.
P does,
B Das,
appearing for
learned standing counsel, BTC,
BTC
appears for
for P
respondents.
Nair. 3, 4, 5,
3 and 4.
3, 4.
Stop. Para. recommended for selection, which is still pending the final decision of the Director of Higher Education. Lordship. Stop. Para. The petitioner alleges that the calculated statement of scores does not indicate the breakup of the marks as indicated in the calling letter dated in the 7/3/2022, and therefore submits some that there may be some malafide intentions on the part of the interviewers to appoint the private respondent. Stop. I don't know, continue. Accordingly, the petitioner made a representation on 8th of May 2023 before the Director, Department of Higher Education, Respond number 2. The said representation is yet to be disposed of by the Respond number 2 till date. Stop. As the Nipara, Respond number 2 is yet to take a final decision in the matter. This writ petition is disposed of, directing the Respond number 2 to consider the representation made by the petitioner dated 8 May 2023. After giving a personal hearing to the petitioner as well as the Respond number 12, and thereafter take a final decision for appointment to the post of grade 4 in the Tangla College. Stop. Let such exercise be completed within a period of
2 months.
2 months from the date of receipt of a copy of the order.
Lordship,
With
as
the
per the,
appropriate observations and directions, the petition is disposed of.
as per the submission made by my friend, Lordship, the appointment has not been issued, but I have not got any clear instruction right now. That may-
I have stated, my lord, till then, my lord, no appointment should be made.
No, let him consider a representation.
Yes, fine.
Oblige.
Six.
My lord, may I please, my lord, item 7 is same, my lord, only the petitioners are different, and for unreserved category, rate 4, unreserved category.
Item 7, where I said reserved category, you put unreserved.
Unreserved.
Rest is same.
Yes, yes.
Oblige.
Obliged.
I'm appearing for 3 and 4, your lordship. BTC.
Same.
Same, your lordship. Give your best.
May I please, my lord? Matter pertaining to my lord compassionate appointment, my lord. The father of the petitioner, my lord, died in 2012, my lord. Hereafter, he applied for, my lord, for post of LP school teachers, my lord. And there is a communication letter, page 25, my lord.
1 minute. When did you make your application?
Within 3 months, my lord, page 25, my lord. Respond number 7 communicated to respond number 6, my lord.
It in 2012.
Yes, my lord.
When did your father die?
Is in 20/07/2012.
Yes. Then
Then, my lord, page 33, my lord, impugn order letter, my lord. I have filed an RTI, my lord, for my lord, submitting, my lord, my application, what is page 33, my lord. Submission of report along with the documents in respect of C. Tikendrajit Gogoi, son late of Jyotish Gogoi in connection with the appointment on compassionate ground. My lord. Last para, my lord. However, it is to your kind information that the proposal before of C. Tikendrajit Gogoi was placed before the district level committee
for appointment on compassionate ground under the Shivsagar district, and accordingly district level committee held on 15 July 2014 for appointment on compassionate ground could not be considered due to requisite percentage of marks for qualification is not covered, my lord.
What is this?
Yes, my lord. I have passed a degree, my lord, BA degree, and HS, my lord. Then, my lord, if they may be selected in grade 3 post or grade 4, if I am not, my lord, requisite, I have not requisite qualification for the teacher post, my lord. I have annexed one, my lord, judgment of this honorable court also, my lord, page 53, my lord. They may be selected in grade 3 or grade 4 post, my lord, other post, my lord. Page 53, my lord.
No, you don't have the qualification for the post of?
I am not qualified for the post of LP school teacher because, my lord, there is 50% marks, my lord, in HS, my lord. That at that time, my lord, that is required, my lord. Page 53, my lord.
Yes.
Yes.
Yes, I can.
Why not? My lord, perusal of the letter, my lord, issued by the district elementary.
Language is not so clear.
My lord.
Is it the percentage is low or does not have the requisite qualification?
My lord. That is true, my lord. That compassionate appointment, my lord, he cannot claim a certain post, my lord.
Yes,
To accommodate as per his academic qualification.
As per his
Academic qualification. And here problem is that no, that DLC is enclosed distribution, my lord. The record of the DLC is also not available with us, my lord. If this part only on the basis of this contention is, my lord, rejected, that is petitioner has good case, my lord. If otherwise other,
due to requisite percentage of marks.
my lord.
In other post, there is no question of percentage of marks, my lord. In grade 4 post or grade 3, my lord, that is LDA. That's as per this order also, my lord, this honorable court order, my lord, 54, my lord, relevant person.
No, that I've seen.
That is,
Yes, my lord, 54. In view of the above, the respondents are directed to place the petitioner's application before the concerned DLC for reconsideration for appointment to any grade 3 or grade 4 post.
You obtained how much?
Yes, my lord, in excess, my lord, I have 3rd division, my lord, 37%, my lord.
3rd division. LP school, the percentage required is?
That is, my lord, in excess, if excess pass 50%, my lord.
So you are not.
No, my lord. And my lord, if at that time the BA passed, my lord, there is no question of mark, my lord. But I have passed, my lord, in 2014 BA, my lord. That is maybe selected in any other grade 3 or grade 4 post, my lord. That is my submission. Not for school teacher, my lord.
What, Mr.
M. Golitam.
M. Colita, learning counsel for the petition. Also heard Mr. G. Bekul, learning standing counsel. For elementary education. Correspondence?
3,
2,
3,
2 also.
2, 3, 6 and 7.
6 and 7. And Mr. P. Saikal and Governor Advocate for respondent?
1, 4, and 5.
1, 4, and 5.
My lord.
Stop. Para. The father of the petitioner, late Jagdish Gogoi, while serving as headmaster of Saurangapam LP School, died in harness on 27th, 2012. Thereafter, Petitioner made an application for appointment on compassionate grounds. No, cancel it. The petitioner passed his HSLC in the third division,
HS.
HSLC
Yes, my lord.
in the third division. From
Yes, my lord.
which college? Which school?
My
From
lord,
Longpatia High School,
yes, Longpatia High School, Longpatia.
Longpatia. Stop. The petitioner made an application for appointment on compassionate grounds to the post of LP schools teacher on time, which was forwarded by the Deputy Inspector of Schools, Charaidio Sonari, on 8/10/2012 to the District Elementary Education Officer. Thereafter, as there was no information with regard to his consideration, with no regard, as there was no information whether the case of the petitioner has been considered by the PLC concerned, petitioner made an RTI application, correct?
Yes, my lord.
And in reply, petitioner was informed on 31/3/2023 that his case could not be considered as due to lack of requisite percentage of marks. Stop. For if the case of the petitioner could not be considered due to lack of requisite percentage of marks for the post of LP school, the PLC concerned should have considered the case of the petitioner for appointment to either a grade 3 or grade 4 post, which has not been done. Stop. In view of the above, the matter is remanded back to the concerned DLC to reconsider the case of the petitioner on merits to any grade 3 or grade 4 post commensurate to his educational qualification. Stop. Qualification in its next immediate city. Stop. Consequently, the DLC meeting minutes, the minutes of the DLC held on 15/4/2014 is set aside in quashed insofar as the petitioner is concerned. Stop. With the above observations and the petition is disposed.
My lord, instead of HSLC, my lord, he has passed HS in 2008, my lord.
Huh?
HS, my lord, higher secondary, page 21, my lord. And degree was completed in 2014. That was not covered, my lord, but my lord, page 21, my lord.
For grade 4 post, my lord.
Grade
How
3 or
my
grade.
lord is
Yes, my lord. HS has passed,
What HS?
my lord, to page 21, my lord. Higher secondary, my lord. HSLC in 2006, my lord.
They will consider my lord as per his academic qualification.
Oh, he passed his HSLC.
Yes, 2006 and
Oh.
HS in 2006, my lord. 2008, my lord.
Where?
Yes, page 21, my lord. There is certificate, my lord.
21 is your HSLC,
Yes, my lord.
correct?
Yes.
Then
And HS also completed, my lord.
where's that HS?
Higher secondary, my lord.
My lord, that will
That is, my lord.
taken care by the concerned DLC.
Yes, my lord. Page 21, my lord.
Correction again, again. Correction, order correct.
Grade 3, 7.
What did he say on top? He said he passed his HSLC in the 3rd division, correct? In the year 1990. And higher secondary education in the 3rd division in the year 2008.
2008, and HSLC in 2006, my lord.
Yes, I believe this mentioned.
Obliged to pass. Much obliged.
May please, your lordship. I'm a student of MA, your lordship, in history. I was rusticated from the Dibrugarh University due to ragging. And I challenged the order. May, your lordship, may kindly peruse the page 36.
Yes.
This was the FIR, your lordship, may I read? Respectfully, I would like to inform you that yesterday night, some ex-students and senior students, namely so-and-so Rahul Shetty, Dibbolti Gogoi, Subhojiti Borua, Niranjan Thakur, Kalyan Datta, 3rd semester department of history, and several others of PNGBCN of Dibrugarh University started ragging my son, see Anand Sharma, a student of MCOM 1st semester, Department of Commerce, Dibrugarh University. They looted his money and snatched away his mobile from him after torturing him mentally and physically by scolding him in the name of his caste and community in whole night. When he made complaint before the warden, then they become more aggressive and hostile against him and other junior students. So this case, your lordship, I will not read further. This case was registered under section 120B, 341, 395, 307, 143. Now, your lordship, thereafter, some students were expelled from the hostel. Page 43, your lordship, may kindly peruse. Page 43. My name, your lordship, the present petitioner name appears as Pope. May I read, your lordship? Further, the order under so-and-so, ragging so-and-so dated, strict order is passed for prohibiting entry of the following students into the university campus along with the suspension from attending classes and academic privileges with immediate effect until completion of the ministerial level and institutional inquiry in full. My name appears at serial number 4, your lordship, Kalyan Datta. Then, your lordship, may kindly peruse page 59. This is the notice which was issued upon me, your lordship, on 10/3/2023 by the chairman of anti-ragging committee. May I read, your lordship? The anti-ragging committee, Dibrugarh University, had received complaints of your involvement in ragging, and you are hereby being informed of the allegation leveled against you. The charges leveled against you are enclosed in Annexure 1 here 2. The statement of imputation of misconduct are enclosed in Annexure 2 here 2. You may request for inspection and complaints and the statements of witnesses during the office hours. You are hereby requested to file your reply to the allegations and the evidence against you by 5 p.m. on 14/2023, failing which it will be presumed that you may have nothing to say to the allegations. Your reply should contain all evidentiary materials that you would like to depend upon and also your written statement. In case you desire to be heard in person, the request should be contained in the reply itself. Upon consideration of the reply and the request, an opportunity of personal hearing, if deemed necessary, will be given within a short time. Then I will skip, your lordship, to 62, page 62, your lordship. That was my reply. I denied everything, your lordship.
Yeah.
Page 62, your lordship. May I read, your lordship? With reference to your notice dated so-and-so mentioned above, I respectfully submit my written statement, so-called reply against the charge leveled against me as per Annexure 1 under Article 1 and imputation of misconduct as per Annexure 2 of the notice for your kind and favorable consideration. That I specifically deny the charge under Article 1 that I have repeatedly indulged in the activities which have been defined to constitute ragging as per
Regulation 3A, B, C, D, G, and I, and Regulation 9 of the Dibrugarh University Regulation for prohibiting ragging and anti-ragging measures, and thus has incurred liability to suffer penalties described at clause 7B of the Dibrugarh University Regulation for prohibiting ragging and ragging measures. To your lordship, that I also specifically deny the imputation of misconduct as per Annexure 2 level against me. It is submitted the name of the student was not being mentioned who brought complaint while later dated so and so. But nevertheless, I have never subjected any student to ragging within the hostel premises, which comprise both physical and mental torture. The allegation that has been charged by the victims are false. I would like to state that I myself belong to a family of below poverty line. I was not able to afford a private hostel and remain in the hostel. I know the conditions of the hostel dwellers belonging to a poor family and resist myself to such kind of any activity in the hostel. I was paying half mess dues during the first year in the hostel. That I also specifically denied the imputation of misconduct as per Annexure 2 labeled against me. It is submitted the name of the student was not been mentioned who brought complaint by later dated so and so. But nevertheless, I have never indulged in ragging junior boarders since the beginning of the FLC. I have denied everything, your lordship. Then your lordship, page 64. This is the second so-called notice issued to me, your lordship. I'm reading the conclusions of the anti-ragging committee, your lordship allows me. The ARC in its meeting dated so and so had resolved to consider the incident of ragging, the allegation labeled by the victim and the explanation given by the accused students, and to take a final decision in a short time. The members have gone through the statements of the victims and also explanation offered by the accused students. It is seen that an incident occurred in the night intervening 26/11/2022 and 27/11/2022, where 5 students have been physically assaulted and mentally tortured by some senior students and ex-boarders of the hostel in the bid to identify persons who have given complaints regarding ragging to the administration. It is further seen that 3 of the victims had given their statement to the ARC on so and so. Victims had been taken to Assam Medical College and Hospital, and 1 victim had to undergo surgical procedure for injuries that he received to his spine in his bid to escape from the clutches of the perpetrators, along with a statement for injuries received during the ragging episode. Now, I would like to pause for a moment, your lordship. My instructions are very clear. This boy who had received injuries, he was trying to escape from the hostel through the window, your lordship, and he fell down because the pipe broke, and then he received the injuries. It was not because of ragging, your lordship. Then may I read, continue, your lordship. The victims have identified Sri Kalyan Datta as one of the person who had stabbed the victim and inflicted mental torture upon them. In fact, from the statements of the victims, it appears that Sri Kalyan Datta was present during the entire incident. On an evaluation of the reply given by Sri Pranjit Borua on 2 occasions to the anti-ragging committee, it is seen that he has stated that as he was present in the hostel premises during the night intervening 26/11/2022 and 27/11/2022, and he had also made Rahul Chetri. He has stated that there was chaos in the hostel that night. He has denied his involvement in the incident of ragging. The statements of victims corroborate each other and thus appears to be correct. The victims of ragging have brought in specific allegations of physical assault against Sri Kalyan Datta, and the committee does not find that such allegations are either mela fide or false. Thus, the anti-ragging committee is of a unanimous view that an incident of ragging had occurred in the hostel premises on the night intervening so and so, where at least 5 students were harassed mentally and physically, slapped by a few senior students and ex-boarders of the hostel. Sri Kalyan Datta was one of the perpetrators of ragging as per the statements of the victim. Sri Kalyan Datta has denied involvement in the incident of ragging. He has not explained his identification by the victims. Sri Kalyan Datta has been allowed to go through the statements of the victims. He has not led any evidence in his defense. His reply to the so-called notice does not inspire confidence of the committee, and on the other hand, the version of the victim appeared to be true and correct description of the incident which took place in the intervening night of 26/11/2022 and 27/11/2022. Lordship, may kindly notice this, that my statement has been totally disregarded and their statement has been taken as the gospel truth, without allowing me to cross-examine all those victims, the alleged victims, your lordship. Totally disregarded. Then, your lordship, therefore, the ARC in its unanimous view that the charge level against Sri Kalyan Datta that he had committed offense described in Regulation 3A, that is handling with rudeness, a fresher, 3B, indulging in acts of indisciplinary activity which cause hardship, physical and psychological harm and raise fear, asking a student to do any act which has the effect of generating a sense of shame, act by a senior that prevents disturbs regular activity, academic activity of a fresher, an act of physical abuse causing bodily harm, and an act that affects the mental health and self-confidence of a fresher. Accordingly, the ARC finds that Sri Pranjit Borua, it is a typical error, it seems Kalyan Datta should be there, is guilty of committing the offense of ragging.
The committee then discussed the issue of punishment to be imposed upon Sri Kalyan Datta for committing the offense of ragging. The committee has observed that Sri Kalyan Datta had been taken to police custody. He was drawing the benefit of scholarship or fellowship. Withholding of results or debarring from representing the institution does not commensurate with the offense. He is already expelled from the hostel pursuant to the orders passed in an earlier incident of ragging involving him. He has not assailed the same. Imposition of monetary fine or imprisonment is to be decided in the appropriate court of law where the police case is pending. Therefore, the ASC is of the view that the imposition of a punishment of cancellation of admission to the PG course in the university would suffice the requirements with regard to the gravity of the offense found, proved, resolved accordingly. So, Your Lordship, thereafter, unless I had replied to the so-called notice, I have denied everything, Your Lordship. If Your Lordship peruse page 67, I'm reading from the second paragraph, Your Lordship. I specifically and categorically deny that the allegations that I had slapped and inflicted mental torture upon the victim. I further submit that although it is stated in the second so-called notice dated 6/4/2023 that the victims of ragging had brought in specific allegations of physical assault by me, and the anti-ragging committee found that the statements of the victim were correct and are neither mela fide nor false. However, anti-ragging committee had neither provided me an opportunity to place the facts nor confronted me with any material which is proposed to be relied upon by the anti-ragging committee for taking action against me. I herein submit that on 23/2023, I was directed to appear before the anti-ragging committee, and on my appearance, I was questioned as to whether I was present in the hostel on the day of the incident, and secondly, whether I was involved in ragging of any student. These are the two questions, Your Lordship. I specifically and categorically stated before the anti-ragging committee that I was present in the hostel on the day of the incident, but was not involved in ragging of any student. Your Lordship may kindly notice this. I further stated neither the copies of my statement made by the complainant witnesses victims, nor any documents, electronic records were provided to me by the anti-ragging committee. I am not aware as to who is the complainant and who are the witnesses victims of the incident of LS ragging and what they had deposed against me before the anti-ragging committee. I herein state that there is no material against me which could form the basis of guilt of ragging against me. I also respectfully submit that I am not guilty of committing the offense of ragging, and punishment of cancellation of admission to the PG course in the university may not be imposed upon me, as the same will cause great prejudice to me and will ruin my career. I was expelled from the hostel only on the basis of suspicion after the incident of LS ragging. Further, I was also arrested in connection with Dibrugarh PS case number under section so-and-so of the Indian Penal Code merely on the basis of suspicion. I respectfully submitted after the completion of the investigation of the case, there is every possibility the honorable court may discharge me or acquit me. Then, Your Lordship, page 70, the notification. May I read, Your Lordship? 28/4/2023, whereas the anti-ragging committee in its meeting dated 28/4/2023 had come to the conclusion that Sri Kalyan Datta, student of the postgraduate program in the Department of History, Dibrugarh University, has been found to be involved in an act of ragging. And whereas the anti-ragging committee has passed orders for imposition of punishment of rustication of Sri Kalyan Datta from the university for the academic session 2023 and allowing him to continue the program from the session 2023 to 24. Further, he is also debarred from availing hostel facilities of the university. Now, therefore, Sri Kalyan Datta, son of Sri so-and-so, is restricted from Dibrugarh University for the academic season 2022-23. However, he shall be allowed to pursue the remainder of the program from the next academic session without availing hostel facilities of the university. We had challenged this order. I had challenged this order, Your Lordship, and by order dated 12/5/2023, the said writ petition was disposed of by this honorable court. Your Lordship may peruse. I'm straight away going to paragraph of page 76. May I read, Your Lordship? 76.
Yes.
Accordingly, Your Lordship, the second paragraph, the third paragraph, accordingly, starts from accordingly. Your Lordship, accordingly, this writ petition is disposed of by directing the petitioner to approach the Executive Council, Dibrugarh University, for filing an appeal against the order dated 28/4/2023 in terms of the provision of section 7C of the regulations for prohibiting ragging and anti-ragging measures. If the appeal as directed is filed by the petitioner within 10 days from today, then the same shall be considered within a further 15 days from the date of receipt of the appeal, along with a certified copy of this order. The Executive Council, before passing any order, will also give personal hearing to the petitioner. Any order that is passed on the appeal that may be preferred by the petitioner, a copy thereof be served to the petitioner. In view of the submissions made by the learned counsel for the petitioner, that the person filing up of forms and other particulars for the fourth semester examinations commence and is likely to be over shortly, the petitioner shall be permitted by the university authorities to fill up such forms and particulars for the fourth semester examination in history. The petitioner is so permitted as in the event of any order that will be passed by the executive council interfering with or modifying the order dated 28/4/2023 passed by the ARC. The petitioner will not be compelled to lose his academic year. However, it is made clear that the permission to file the forms and particulars for the fourth semester examination in history is only till the final decision is rendered by the appellate authority, that is executive council. This shall not be considered to be a right conferred on the petitioner in the event of executive council decides to uphold the orders of the ARC passed against the petitioner. The writ petition stands disposed of in the terms of above directions. Now, your lordship, then I had filed an appeal, page 80. I will not read, your lordship. This is a letter, page 80, 22/5/2023. I filed an appeal. Thereafter, your lordship, you kindly peruse page 82. This is a letter to the registrar of Dibrugarh University. With most respectfully, I would like to state that I have completed the necessary registration process for the fourth semester examination, which is going to be held shortly, as the Honorable Guwahati High Court allowed to do so till the final decision is rendered by the Executive Council. The Honorable Guwahati High Court have stated in one of the para in so and so. This is reading here, last para, your lordship. Here, by I am writing to request the issuance of an admit card for the upcoming semester examination. I will appreciate your attention to this matter and your prompt response. If there are any other further instructional documents required from my end, please inform me at your earliest convenience. Then, your lordship, page 83, the exam schedule. Today is the last day of my exam, your lordship. The exams are already over. It started at 6 and it will end today at 16/6, your lordship. Then, your lordship, page 84. This is a letter that I wrote on 6/6/2023, where I had prayed that I may be allowed to appear in the examination. They did not allow me to do so. Finally, your lordship, may kindly peruse page 85. The notification. May I read, your lordship? Whereas pursuant to the order passed in WPC number 2611/2023, Sri Kalyan Datta so-and-so had preferred an appeal dated 22/5/2023 to the Executive Council, Dibrugarh University, against the notification dated 28/4/2023. Whereas the Executive Council, Dibrugarh University, in its meeting held on 31/5/2023, your lordship may kindly note the date 31/5/2023, gave an opportunity of personal hearing to Sri Kalyan Datta. Whereas in the said meeting, the Executive Council, Dibrugarh University, did not find any ground to interfere with the decision of the anti-ragging committee, which led to the notification dated 28/4/2023. Now, therefore, the penalty of rustication of Sri Kalyan Datta from the university for the academic session 2022-2023 and allowing him to continue the program from the session 2023 to 24. Further, he is also debarred from availing hostel facilities of the university, remains unaltered and continue to be enforced. Before proceeding any further, your lordship, one thing I would like to respectfully submit, your lordship. The meeting took place on 31/5/2023. The examination started from 6th. They could have informed me about the decision on 2nd or 3rd. They took 6 days. On 7th, that is after my examination started, they had passed this order, and I was informed about this order on 8th of June, your lordship. I'm not on the order, your lordship, but this was, in my respectful submission, I should have been allowed to, the order should have been passed prior to 7/6/2023. Then, your lordship, the facts, only some victims, only some students are alleging that there was an act of ragging. We were not given an opportunity to cross-examine those victims, your lordship. If we are not being provided that opportunity, then how is that it is to be taught that those persons who are stating or alleging anything against me are speaking the truth? And how is that the university came to a conclusion, especially the anti-ragging committee and thereafter the council, your lordship, executive council, came to the finding that what we were speaking was not the truth and what they were speaking was the gospel truth, just because an incident took place, your lordship. Yes, I admit an incident took place, and I admit a student was injured, he was hospitalized, and in that process, another student was also injured, your lordship. But are we involved in ragging, your lordship? This is a stigma on us. We have been rusticated from the university. They did not give us any proper opportunity, Your Lordship. Without providing us any proper opportunity, they have rusticated me from the university, Your Lordship. Not only me, the other four petitioners, Your Lordship. And I ask a question to myself, what will happen, Your Lordship, if tomorrow we are acquitted or discharged in the criminal case, Your Lordship? The criminal case is also pending. And only on the merely on the basis of preponderance of probability, Your Lordship, without going to the real facts, we have been rusticated. They could have given us any other punishment, Your Lordship. We are already debarred from the hostel, but took away, they rusticated us and they stopped us our 1 year, Your Lordship. Now we are debarred.
Majumdar?
But at this stage, if Lordship issues notice, I have received the documents, all the records of all the 5 repetitions which are now before this honorable court. Madam, two things here, two things I would like to clarify as of today.
Examination is over.
Examination is over as of today, my lord, that part is done. Secondly, my lord, the assertion that a cross-examination is necessary in a proceeding under the anti-ragging committee or by the appellate authority, but the Supreme Court has gone totally against it. Supreme Court has said nothing, no opportunity of cross-examination is to be given. At best, he will go through the complaints, give up his defense, and the matter is to be decided. It is not the case that he was not given a personal hearing. It is not his case that he did not have an opportunity of going through all the records. I've gone through the records, my signatures are there where every complaint had been given, a copy of every complaint had been given to him. He was given all opportunities. There are hundreds of students, so far as only some students are making an allegation against him. My lord, some students are making allegations on only some of the students, not the entire of the university. Lordship will find even in the order, it is recorded that this is the second incident of ragging in which he is involved. This is not the first incident. The penalty which was given by the ARC of cancellation of the entire admission, taking into account the future of the student, has been brought down by the appellate authority to a rustication for only a year, where he is allowed to continue the same course from the 3rd term on the next year itself. 2022-2023, he loses out. 2024, he can appear in the examinations again and complete his course. There has been as much of my lord leniency that could have been provided to a group of students individually who had taken part in an ragging incident not only once, twice. If Lordship will kindly have page 43, my lord. I'm sorry, my lord, not page 43, page 41. Remember, the FIR Lordship will find was lodged on 27/11/2022 at page 36. That's the person, this boy, was subjected to ragging on 26/11. Lordship will kindly have page 41. In pursuance of the recommendation of the anti-ragging committee in its meeting held on 18/11/2022 and adjourned meeting held on 21st of November 2022. And considering clause 7B of the Dibrugarh University Regulation for prohibition of so-and-so, the following students and boarders of this university are hereby served the notice of expulsion from the hostel. So what they did prior to 18/11/2022, they were only punished with an expulsion. On 26/11, they repeat the incident to an extent where, my lord, our records show 2 students have lost their hearing due to slaps. And 1 student, out of fear, had tried to escape the hostel, correctly he has said, tried to escape the hostel, pipe broke or he slipped, fell down, broke his backbone. He has started attending classes from last month. For 5 months, he was bedridden. And this is the only action the university is taking. We debar you for 1 year. At this stage, my prayer would be, let a notice go, let me produce the records, let me have my affidavit on account. The earlier incident has not been referred to in the writ petition. The earlier inquiry has not been challenged anyway when they were first expelled from the hostel. This is a second incident involving the same victims, the same culprits. If I may use the word, but I do not like to use that word. But had it been a case where perhaps
that was fun, that was heat of the moment, that was a group activity. It's a different issue, my lord. What happened on 1811, the expulsion? Expulsion orders were unfortunately passed on 2011. But that inquiry, when they had in mind, it was pursuant to that inquiry that these boys were targeted to find out who had made a complaint. The statement of the victims will show mobile phones were checked as to what messages were being sent to the administration regarding who sent that complaint that a ragging is going on. And then it was a vengeful act. And therefore, this drastic step, bringing down a cancellation of the entire admission to a stage of only debarring for a year.
Okay.
May I reply, Your Lordship? A brief reply, Your Lordship. What my learned friend has submitted before Your Lordship as on date is that this particular proceeding, the first proceeding, that the incident of ragging took place on 2111, Your Lordship, right? That in that case, Your Lordship, we were not named. So we were subsequently expelled from the hostel.
Okay.
That is the only thing, Your Lordship.
I'll issue notice. But Mr.
T. Dury, Your Lordship.
T. Theory, let me contact. Issue notice. Mr. R. Majumdar, understanding counsel.
Respondents.
Appears on behalf of
All the
respondents.
respondents.
On behalf of all the respondents. Notice and respondents. However, extra copies of the petition information. Respondents are not the contract. List of the 4 weeks.
2 weeks, Your Lordship.
That would be
So
within the
it's
vacation.
the same thing, you go to vacation, so 4 weeks.
Oh, may I point out one more thing, Your Lordship? One more thing, Your Lordship. With respect to the petitioner item number 10, Your Lordship, 9, so Dibjyoti Gogoi, Your Lordship. His examinations had started today, 16/6/2023. So may I pray if Your Lordship may allow him to appear in the examinations? 16/6, Your Lordship. Dibjyoti Gogoi, Your Lordship, read petition number.
Not at this stage, matter. He misses today's examination. In any case,
Yeah, in any case, he has
he
missed
misses
his
today's
exam.
examination, he has to wait for the next.
Same order in item.
Your Lordship, 8, 9, 10, 11, 12.
Same order.
Advise, Your Lordship.
Obliged.
May I please address? My lord, matter pertains to my compassionate appointment. My candidature was rejected by the SLC. It is minus dated 26/8/2022 at page number 43, my lord.
SLC,
SLC minus, my lord. Page, start from page number 39, my lord. Uh,
26 August 2022.
Yes, my lord. My name is at page number 43, my lord. Rajiv Pukon, CL number 11, my lord.
What is non-availability of norms?
My lord,
What is non-availability of norms?
my lord, as the candidate applied after 1 year. After 1 year. That is my case, my lord. I'm not denied, my lord. Some delays taken place, my lord. Oh, when my father is died, my lord, at that time, my lord, the 1 year period is not mandatory, my lord. As per office memorandum dated 1983, my lord. Yeah,
When did your father die?
my lord, in 2001, my lord. 2001,
When did the new office
I-
memorandum?
my lord, 2015, my lord. They have invoked the 2015 OM, my lord. Even assuming, my lord, 15 OM is applicable to me, my lord, then also this honorable High Court held that this is, my lord, not a mandatory, my lord. Director in nature, my lord. I have the judgment, my lord. Lordship may go through it, my lord. Para divorce. I have a market. Mandatory. Followed by these are document malot. This honorable court pass. This order also malot. 8 para 10 and 11 malot. By following the judgment malot. Para 10 and 11 malot. In para 10 the judgment quoted.
You're delayed by how many months?
Malot 2 months.
Yes, I can.
My lord.
Humble sir.
My lord, the ground of rejection is very logical. my lord. Because my lord, initially, my lord, for completion of appointment, my lord, there is a time frame from three months, my lord. Ashut Ranjan said that time for 3 months, accordingly on the basis of the Ashut Ranjan, my lord, in 2009, a notification issued by saying that within 3 months, the concerned person have to be file application. Subsequently, that has challenged before this honorable court, and Posiron Nasa, my lord, that has modified the notification status saying that within 1 year, the candidate have to be filed his application, my lord. And it is also apparent from this office notification, my lord, that within 1 year, my lord, petitioner have to be file application.
That is there.
This is the very logical, my lord, and there is no any apparent illegality in this, my lord, findings of the.
My lord, by humble submission also, my lord, another point. At that relevant point of time, my lord, this notification was not enforced, my lord. At that time, my lord, 1980 poem is there, my lord. I have annexed this poem, my lord, at page now 54. Page number 54, my lord.
Because my lord, this notification is applicable because under this notification, my lord, his consideration is there, my lord. MC Gupta case, my lord, Honorable Supreme Court has cleared it, my lord.
Yes.
Yes, my lord. This is the office memorandum applicable to me, my lord. At the relevant point of there is no such provision I find, my lord.
83 was in operation, isn't it, when his father died?
Yes.
My lord, that was also discussed before the Honorable Supreme Court, my lord. Honorable Supreme Court said in NC Santos case, my lord, that when rule will be prevailed, that rule will be applicable, my lord. And therefore, my lord, each and every cases, my lord, now considered under 2015 rule notification, my lord, because all other order notification that are suspended by the 2015 rule, my lord. And page number 64 is, my lord, very clear, my lord. And even, my lord, honorable court judgment, honorable high court judgment in the Posiron is also very clear, my lord. Instead of 3 months, you have to file within 1 year, my lord.
That is all right. What about this judgment?
My lord.
Monitor not Konwar.
Toilung Kotan.
Because that matters.
Munindranath Pramod.
Anyway, my lord, my humble submission at this stage, my lord, matter may be refunded back to the SLC, my lord, for fresh consideration, my lord, demonstrating this pool of. That is my prayer, my lord. They will decide, my lord, their own merits.
Yes. But next time.
My lord, D go.
My lord, in this case, my lord may issue notice, my lord, we will come on.
I'm
evidence
disposing
because-
of
My lord,
the
instead of no.
letter.
My lord, because my lord, these will be the principles, my lord, applicable in each and every case, my lord. It will be create a floodgate, my lord.
Have you seen this, have you seen this
My lord,
case?
we will, my lord, appreciate all these, my lord, judgments and these office memorandum, we will find it. My lord, may issue notice.
Have you seen
This is-
this case?
My lord, this is the
Very clear, my lord.
first day, my lord,
Trilokya Nath.
my lord. My lord, this is the first list form 2001, my lord, is stated over the matter, my lord.
No, no, my lord, there is process, my lord. I have seen.
My lord, may issue notice. my
Process,
lord,
only the
because it
process.
is old matter, my lord, and there is a scheme also said, my lord, within
My
2
lord.
years, my lord.
Already, my
And
lord.
we'll come up with an affidavit, my lord.
What
Suitable time, my lord. What
affidavit
paper?
you
My lord,
These are law point,
regarding
my
the
lord.
applicability of the judgment and their office notification, applicability of office notification as a Ashut Ranjan case, my lord. Because my lord,
Then-
each case,
then-
my lord, facts is different, my lord. There is a concession in maybe,
Then you take
on regards to
instructions
the
and
facts
come
of the
back.
matter,
I'm not
maybe.
issuing notice.
My lord,
My lord.
I'm not issuing notice. You take instructions and come back.
my lord.
Take over level part, but for the position. Mr. Recycle and government is allowed 2 weeks time to receive instructions. This after 2 weeks.
My lord, before vacation, my lord.
Cannot,
Master.
cannot be before.
Deeply blush.
Lordship, letter may be faxed for time being.
Why?
Lordship, my senior on dates, Lordship.
Sixty-four of supplementary days. Most of them.
My lord, petitioner is disabled person, my lord, with benchmark disability, my lord. Pursuant to an advertisement, my lord, noted by the government, my lord, he applied for the grade 4 post for disabled person, my lord. And thereafter, my lord, he got selected. By appointment order was also made, my lord. Annexure I, page 37, kindly see, my lord.
Position kind of positions.
Appointment order is there, my lord. Kindly see, my lord, the terms and condition, last condition, my lord, 8. The appointee shall have to join in their respective place of posting from 1st June to 15th June 2023, positively without fail. So thereafter, my lord, on next, kindly see page 38, my lord. By order dated 30/5/2023, my lord. Issued by respondent 4, my lord. The order, my lord, kindly see. Posts are hereby kept on hold till a final outcome is received regarding their credential status of disability,
the candidates will be allowed to join in their respective places of posting only after clearance from the government in personnel department or something. So my lord, as per Rule 18(3), my lord, of the right of persons with disabilities, rules 2017. Rule 3 says, my lord, the medical authority shall, after due examination, issue a permanent certificate of disability in cases where there are no chance of variation of disability over time in the degree of disability. So, my lord, there is no any chance of variance, my lord, for disability, my lord. So, my lord, in this case, my lord, clearance from government in personnel department is nothing, no required, my lord, in this case.
Yes.
Here also I have to take instruction regarding this, and so far he has participated and
That is undisputed.
yes, noted. And
He was
so far,
participated, he was selected, he was appointed.
yes, noted. Whether he has submitted his documents is a valid document
After
or
he
not.
has been, where is your medical certificate?
Yes, my lord.
And moreover, Lordship, the other person might have already been joined, Lordship. They were not.
Page well 24.
Now he is.
Disability.
That
It's
Page
not a-
24, my lord.
It's not a question of other person doing it. They've been.
Page 24, my lord, kindly see.
Yes. Who issued this medical certificate?
Yes, my lord, the medical board is, my lord.
It's a medical part. Lordship, it was issued by the joint director, Lordship. And this was only a 40% Lordship and low vision. Lordship, and this certificate was dated 1/10/2013. So that's why, Lordship, there was a subsequent, Lordship, at page 31, there was a board. And they were asked to appear, Lordship, on 18th May.
31.
Page 31, Lordship, there was a there was the notice. And the petitioner appeared, Lordship. Now, this is only apprehension that he might not be eligible for that PWD section. And similar matter, Lordship, he appeared on 14th, it came, Lordship. The similar matter will be coming up on 19th, Lordship, in Court 5, Lordship. And today also there is one similar motion matter. It was listed before Court 5, Lordship. So I'm taking instruction. Let this writ petition come up on 19th, Lordship. I will get the instruction what happened to the outcome of this.
Monday?
Yes, Lordship. WPC 3324 of 2023. It was listed on 14th. Same petitioner, Lordship.
Same petitioner?
No, not same.
No,
petitioner, the same council, Lordship. So
But he, in that case, my lord, he was not appointed, my lord.
But he also
Yes.
appeared, and so I'll get the list who are eligible, Lordship.
Okay, what, Mr.
R.S. Chauhan.
R.S. Chauhan and counsel for the petitioner, Mr.
Lordship, I am D Upamanna for 2, 5 and 6. Standing council,
Standing council,
Health and Family Welfare Department.
Health and Family Welfare shall receive instructions in the matter. List on 19, 20, 21,
19th.
19.
Along with the writ petition. Obliged, Lordship.
Obliged.
65, admission.
Google. In this case, your lordship has already recorded the order. That day your lordship has passed the order.
Just think,
Yes.
let us see what the other side
Yes.
says.
Because 2007, my lord, there is no bar for completion of the MBBS. Well, in 2019, that bar has come. And that at the time when the law was in prevalent, my lord, there was no bar. My lord, in one or two cases, I find, my lord, from the
Yes, yes,
newspaper.
that part is correct, my lord. That part is correct, my lord. Initially, my lord, I am representing the NMC, my lord. When he has joined, my lord, that part, there is no bar at all. Subsequently, bar has been created. It was for only for 10 years he has to complete, my lord. But when he joined, there was no as such bar. So he was governed by the earlier notification, my lord, 2000 GMR, my lord, 1997. And during that time, there is no bar. But subsequently, bar has been created. That is on 2019, my lord. That has, Lordship, I have, there has been notification I have already provided. But the only question is that now, probably they can answer the whether he was admitted. Because that the question of his admission is also a matter to be seen. When he was admitted,
Admission was done.
that as per the
But,
record of the university,
He
there is
does,
no record as such that he was actually been admitted.
so the registration card could not be given. Since
Guwahati University could not give any not information because he did not appear in any examination.
that's why.
Your lordship has recorded. At that point of time, 2007 notification was there. His admission is in the year 2009. There is no bar for completion. And I find, my lord, one newspaper item I find, my lord. One, he was in jail for about 10-15 years. Then thereafter, he completed his MBBS course. But that paper, I think I have given it there.
We are not
Newspaper.
disputing that part.
Huh?
We
No,
are
no,
not
I'm just
disputing.
saying, I'm showing.
There is no bar as such at that relevant.
This boy is very keen to complete now, because after suffering all these things, man, I will have to leave it to your lordship now. Subject to what Director Medical says.
The admission part.
Well, I will place the regulation of 2012, my lord, of then, my lord, MCI.
But his admission was 2009, madam.
On 1997, take it.
এইটোত পাৰা নাই, এইখনত পাৰা নাই।
But even then, my lord, may I submit, my lord, that's what well, may I make one submission, my lord? My lord, the procedure for admission in MBBS school, it's, my lord, presently, just call me is, my lord, by appearing in NEET exams. At that point of time in 2009, there was a state level examination. Now it is national level. Be that as it may, my lord, he participated in the selection after completing his, my lord, 10+2. And he got a seat. But he pursued it for a few months. Thereafter, my lord, because of some health reason, which is beyond his control, he could not pursue it. Now he expresses his mind that now he wants to, my lord, pursue the same course, my lord, after say about 12 years or 13 years now. Now, my lord, whether a candidate, the course is, my lord, 4.5 years, 1 year internship, so it is 5.5 years. Now, my lord, a candidate by getting admission in a particular course, be whatever course, my lord, can he hold in lien that particular seat, my lord, for 13 years, my lord?
Yes, proceed.
Now, my lord, regarding this, my lord, my submission will be, my lord, can he hold in lien a particular seat even for 13 years? Now he is, it's a different thing. For health reason, he could not pursue it, but can he, my lord? And for, my lord, all these 13 years, whether, my lord, he was in touch with the study materials or not, my lord. Because he will have to, my lord, pursue the MBBS course, my lord. It's not an easy course. It's a different thing, my lord. He competes now, my lord, get his, on merit, he gets the seat by appearing in the NEET or any examination. That's a different thing, my lord. Age cannot be a bar for education, my lord. But, my lord, after 13 years, he now wants a seat, my lord, so that he can pursue. Whether in these 13 years, my lord, whether he was in touch with this curriculum or not, my lord. Whether he can now do that, my lord. It's not a general course of any, my lord, general, my lord, arts or commerce or science.
Yes, Vidhi, that
That what you will have to think into. Another point, my lord.
Considered.
Another point, my lord. Now, my lord, if we are to admit him, my lord, one candidate who is otherwise, my lord, aspiring for this seat, my lord, he will be deprived, my lord. A new, my lord, pass out, my lord, high secondary pass out student, my lord, who will be participating in NEET, who will come in the merit list. He will be deprived, my lord, because the seats are limited, my lord. We cannot create a seat for the petitioner. It is as per the, my lord, at that time it was the MCI, now it is a National Medical Commission. They approve and accordingly we can increase the seat. It's not that, my lord, we can increase it on our own. We'll have to give admission to the petitioner in a seat, my lord, which is available to us. And by doing that, a candidate who, my lord, aspiring candidate who has passed out higher secondary now, who participates in NEET, he will be deprived. So this part, lordship will have to examine. My lord. For 13 years, one is without any, my lord, task with the curriculum. He suddenly, if he now, my lord, at this age, he wants to pursue, whether that part can be given without there being any such examination. And the medical issue is there on top of that. And my lord, this particular regulation, what I could find, my lord, from the Director of Medical Education. Here, my lord, it says, my lord, that four times are given, my lord, for completing a particular semester.
What you are trying to say is that now he has to compete in the net.
No, that I'm not saying. Well, if you want to pursue, you have to participate in the, my lord, NEET selection.
That's what I.
Yes, he cannot hold in a seat, my lord, for 13 years. He, my lord, left the particular course in 2009 itself. And the course is 5.5 years. Now, after 13 years, my lord, if he is allowed to join, where he will join, my lord? It's not a post like him, my lord, in employment. That he took medical leave, then now he wants to join. Not that if it's a medical course, my lord. And tomorrow you will have to serve the public, my lord. Whether such a person, just because, my lord, we have sympathy, my lord, like this on our court or the other side, my lord. But whether that part, my lord, public interest, my lord, will have to see. It's more than 30. Age cannot be a bar, that part, that's the different thing. For education, we cannot stop someone. But, my lord, you will have to compete. How we can assess, my lord, whether he will be, as on that he is fit for that, for the court. That part, my lord, some, my lord, the petitioner will have to give some assurance to that effect, my lord. That's what he was doing all this year. 30. So 13 years, 9. Nor he, my lord, submitted some application before the authority. And, my lord, a particular, my lord, disease, whatever it may be, 13 years is too long a period for recovery, my lord. Tuberculosis and all, my lord. 13 years, my lord, I have not found, my lord, how and what he was doing all this year. So, my lord, this part, my lord, what he was doing all these 13 years, without that disclosing that, and also, my lord, we'll have to see the aspect that, my lord, whether he is eligible now, my lord.
Okay.
That lien part, my lord, whether he can hold in lien for 13 years. It's not a service matter, my lord, it's regarding education. And that aspect, my lord, that what will happen to the aspiring candidate who will be otherwise deprived. So on that point, my lord, probably, my lord, some hearing will be required. Cannot be that, my lord, can be straight away given, my lord, out of sympathy. Some additional affidavit on behalf of the petitioner indicating all this, what he was doing.
I have given it in the writ petition, my lord. I have not denied that.
The recovery part he has mentioned, but what he was doing, my lord, that. Thank you. My lord, will see para 15 page 8 man of the repetition. Para 15 and 16 man. No,
Yes.
And at para 15, that after recovering from the injury, the petitioner was granted permission by the respondent to resume his studies from 2012. That though the petitioner got a chance to resume his studies, he could not do so as the petitioner developed psychosomatic disorder and was compelled to undergo treatment from so and so to 2019. So, my lord, it's not that opportunity was not given, my lord. By till 2012, that, my lord, 4.5 years was not over. So probably, my lord, the authorities have considered, but this cannot continue, my lord, for 13 years. Whenever he will feel, my lord, that he wants to now pursue, he will come and, my lord, approach this court and he'll get an order and he can join, my lord. That seat has gone left, my lord. It has gone west. Of course, my lord, not at his own volition, my lord, because from some condition which he could not avoid. But, my lord, now he cannot, that's why I'm saying, my lord, he cannot hold in Lian a seat, my lord, for 13 years.
Lord, your lordship has said, Malad, this is an exceptional case. Normally, this kind of cases, your lordship will not get to see. Neither we can see it, Malad. If he is allowed in the year 2012, what happens to the seat, Malad? Seat, Malad, in this kind of situation, in the absence of the rules, one is, Malad, one gets a chance. Because these rules came Malad, when somebody says, Malad, you can complete it within 10 years. So within 2 years, he is absent. For whatever reason, maybe sick, maybe accident, maybe medical reasons, whatever reason, 3 years one is absent. What will happen? That's it. Same thing, same situation is here, Malad. After some time, Malad, in the absence of the rules, you are liable to consider him because, Malad, there is no bar for allowing him to continue. And the situation is same as that of in the year 2012, when he was allowed to continue in service. What happens to that seat? He will get a new seat. Because this kind of situation arises and this kind of situations are dealt with. Here, my lord, a bar has come now in the year 2019 that you will have to complete the seat process within a period of 10 years.
That is with regard to new admission.
New admission. So now, my lord, this has come because of authority thought, my lord, this medical things has to be completed within a period of 10 years. And for whatever reasons, my lord, if it is not completed, my lord, then, my lord, he will not get any chance. That is the maximum thing after 2019. But before that, 2007 rule was applicable. 2007 rule was applicable. There is no bar. So in that circumstances, my lord, he can claim his continuation provided he is fit to continue, my lord. What he can, my lord, authority can do is whether he is fit to continue because of his sickness. That he can try. So therefore, my lord, if the situation in the year 2012.
Now this issue is one thing which this court has to consider now.
My lord.
Is if we allow you to join today,
Yes.
then we will be depriving somebody.
No, otherwise also, my lord, if I am allowed to continue in the year 2012, I'll have to deprive somebody. 2012, if you have allowed me, I am not going to get that seat, my lord, and continue with me. They will give me a new seat to continue from the first year. So they are also first, but because this kind of situation arises, my lord, in a very exceptional circumstances. It is not that the authority gets it. And if they start getting three, four, they will make a new rule. So 2012 situation continues up to 2020, 23. Same situation, my lord. They will have to, because in 2012, when if they have allowed me to continue, that means what? That means they are going to give me a new seat. And 2023 also, my lord, same thing. They will have to give me a new, and this kind of new seat is not deprivation, my lord. Okay. He's entitlement, my lord. Otherwise, normally we find, my lord, some of the candidates of this nature, they give up. So we are not continuing. But this is an exceptional seat, exceptional, my lord, situation where a student is he wants to pursue his thing and complete his MBBS. And the director at best may see whether he is medically fit to continue. Not beyond that, man. In the absence of the rules, 2007 rules was operating. So therefore, my lord, the same situation, even after, my lord, 10, supposing, my lord, 2009, and if I am, my lord, medically unfit for 2 years, I come in the year 2011, what will happen? They will have to give me a new seat because I am not continuing with that seat. There is no lien question. Lien is a different concept altogether, which is applicable in service matter, not here, my lord. So therefore, I pray, my lord, that the submissions made by the my lord, government advocate, my lord, is not reasonable, and that it doesn't meet the provisions of law. Your lordship,
When is the last date?
my lord?
Last date of admission?
No, 23-24 season you will get it. Session will get it.
When is this starting?
Starting, my lord, NEET result has come out yesterday.
It has been declared
So-
yesterday.
Yesterday,
will take
so
some
within
time.
10-15 days or maybe a month, things will start. They will have to give me a new seat in the site. This is very rare situation. It happens, my lord.
You did not appear in the NEET.
No, I did not.
But Mr. B.T. Das, then the senior counsel. Assisted by Mr. R. M.S. R. Decker, then the counsel for petitioner, also heard Mr. P. Google, then the standing counsel health department. Prabhu Navasam, correspondence 1, 2, 3, 5, and 6.
My lord, yes.
Government advocate. Guwahati University. PG Cycle was appearing.
Here, they have appeared already.
PG Cycle and council. Guwahati University, correspondent number 4, as well as Mr.
Respondent 7, my lord, senior counsel, Mr. A.M. Bora, assisted by D.K. Boito, my lord, for the
Also
NMC.
heard Mr. M. Bora. then the senior counsel.
Sir, respondent 1 is the education department.
Delete question.
Respond number 7, oblique National Medical Commission. Respond number 1, who's respond number 1?
My lord, in my book, in my petition, it is my lord, the commission, secretary, education department.
Oh,
It has been stuck off.
SMT Chishti.
It was struck off, Lordship, what my learned has said.
Yeah, that has been struck off.
Yeah.
Okay.
Deeply obliged. Your lordship has already earlier, my lord, facts have been noted.
Yeah,
Today,
just a minute. We'll get your judgment by Monday or Tuesday.
deeply obliged.
Obliged.
15 of daily list. Selecting application.
Judgment. Earlier judgment was like on the 100.
May I please, your lordship?
Yes.
We have filed an interlocutory application.
Just a minute, my brother. Before my learned friend starts, let me just indicate one thing. They have come up with an application for vacating the stay. And here is a case. If the stay is vacated, the whole matter will get in fractal. I think my learned friend will also admit that.
But
So
even
it-
if
it's-
stay is allowed to be continued also, you will get some unwanted my lord benefit. That is also there, my lord. Because
that
of
is
this
there.
stay, though his tenure is over, as per our contention, he's continuing last 6 months, my lord. Because of this stay, but his tenure is, as per us, is already been over. On December, 31st of December itself. And because of the stay operating, is now continuing. So that is the point, my lord.
Well,
Whether
if
we
that-
can allow him to continue again, my lord.
If that is so, I have continued for 6 months. Let me continue another 2-3 days. Let it be heard on next Thursday. We are here to argue it out. And I'll lodge
Then let-
file
let-
prima facie.
Yes, yes, I'm no objection about that. Let it be
It's
finish
really-
it off.
It should be hard. That is what my question is.
Okay, we are not
Yeah,
objecting to
yeah.
your that prayer, my lord.
But, Mr.
So my IA should be treated as an affidavit in opposition, ma'am.
Yes, we have already filed the reply to it. That will cover.
Okay.
The pleadings is covered.
Heard Mr.
A.M. Bora, madam.
A.M. Bora, then the senior counsel for the applicant in the IA. As well as Mr. K.K. Mandal and senior counsel. Assisted by M.S. A. Begum, then so and so, assisted by A.
Patwari.
Stop. After hearing the parties, this court is of the considered opinion that the main writ petition should be disposed of instead of considering the present IA. Stop. Accordingly, the present IA will be treated as a counter affidavit in WBC 8310 of 2022. Stop.
Yes.
Please, this matters for admission hearing. When?
Well, let's just convenience, well, earliest. Before vacation? No difficulty. If not, then
Before vacation, my lord.
if possible, before vacation. Second, right?
27. On 27, my lord.
Okay. 27.
27, we are having some other methods. 27 may be difficult, my lord, we are having some other methods. On 29th,
29th is a
It will be
holiday.
last day, my lord, that will be.
29th is a holiday.
yeah, holiday.
26. 26, man.
Okay.
Yes, it will be
26.
26, Monday.
26.
Oblige.
What to say?
16,
Public.
May I please, Your Lordship? Lordship, in this case, we are led by senior counsel, Mr. Yukanaya sir, and he's on legs before the court number 1.
But here also I have received the record just now, Lordship. I couldn't go on through the record, Lordship.
Lordship may take up the matter at 2.
2 or Friday, Lordship, whatever. Because I couldn't go on through the record, Lordship. I had to receive it just now, Lordship. The record. Today is, I think,
Third MS.
A.M. DeCosta.
And
on Monday,
A.M. DeCosta.
Monday, Lordship.
Costa, then counsel for the. You're the applicant
Yes, Your Lordship.
for the applicant. So also heard Mr. PG Cycle and his senior counsel. For the writ petition. For the writ petition, opposite party number 1, I think.
Yes, in IA.
Opposite party number.
1 in IA.
Lordship, I am appearing for respondent number 6.
I am 1 minute. Opposite pet number 1.
Opposite party number 1. Stop. On request made by Assistant Chief Justice, then it's
Monday next,
standing counsel,
secondary education.
secondary education. Monday,
Monday. No, Monday go to.
on 19th. 19th is.
Eh, koi jabo lagbe koi record ache.
Oblige, Your Lordship.
May it please your lordship. Lordship, in item number 15, there was an interim order that may be continued. Lord.
Interim order possible to continue in the. writ petition.
Much obliged.
Next week.
17, implement of party.
This is a contempt petition.
Hmm.
So my prayer is that to implement the newly who are now presently holding the post of director and principal of the police.
Have we given notice?
My lord, implement, my lord, the contempt petition is pending, notice was issued. And affidavit also filed by the earlier school principal of the college. Now, my lord, new principal has come and the order has not been complied with, and director also new director. So she has submitted the representation before the principal and director for full compliance of the order of this honorable court.
New principal and new director.
Director, that page 7, my lord, I have details stated. And both they may be added at 3 and 4. Page 7, page 6, para 7, my lord.
Okay. You are appearing for?
My lord, I am appearing for respondent number 2. In charge principal of that college.
In the IA or
He is no more principal. Right?
In the contempt petition, my lord.
okay. Hot Mr.
Yes, no.
Yes, not legal counsel for the applicant. Stop. By this application. Applicant is praying for implement of who?
Respondent page 7, my lord, 3 and 4.
Implement of page 7. Eh? You just don't put the serial number. Just of as party respondent number
3 and 4.
3 and 4 in contempt case number
510 of 2020.
510 of 2020 on the ground that the earlier incumbent, namely respondents 1 and 2, have been transferred out, and the newly and the proposed incumbents are presently holding the post of director and
Principal.
and principal. Stop. After hearing the parties, after hearing the learned counsel for the applicant, the prayer for implementation is allowed. Stop. Or, I use disposed. In the contempt, you say in view of the order passed today, nine number so and so, let so and so be imputed as party respondents, 3 and 4 in the present contempt petition. Registrar is directed to do the needful. Petitioner to take steps for service of notice on the newly imputed respondents 3 and 4 by registered post AD within 1 week. Please
Deep
start
level.
to 6 weeks.
18, 19, and 20 admission.
Lordship already heard the matter regarding Lordship the selection of principal of Boroma High Secondary Schools, and he has obtained a BEd degree from a school without taking any leave, where 80% attendance is necessary. And already we have approached this court, and the BTC authority has passed a speaking order that he has attended the class without permission. But Inspector of Schools report has already revealed, which I have pointed out, that he has not taken any leave without taking permission. He is a regular teacher of a school, and he has undergone the course and completed a BEd course. So 80%, NCT has already filed affidavit that 80% attendance is compulsory for obtaining a BEd degree. And he is a regular teacher of a school. And that speaking order I have challenged by filing this petition, as well as his selection to the post of principal. And Lordship has already heard the matter, and Lordship has kept the matter pending only because of the Lordship, the Guwahati University was not present on the date. And that is why Lordship has given an adjournment and fixed the matter today, Lordship, for disposal.
Who?
Mr. PJ Fukun. And in fact, Lordship, Guwahati University is a formal party. So as per section 5(4), they have to delete the degree of the BEd degree. That is their concern, Lordship. Because already I have challenged, NCT has already filed affidavit, because NCT has specifically the main party. NCT has already filed affidavit stating all the things that he has completed a course without attending the class. And college authority also filed affidavit that there is no attendance of the private respondent in the BEd course. And it is a day shift course, and the speaking order has been passed on the ground that it is as per notification, night shift is allowed. Admittedly, he is undergoing the day shift course, and the Lordship has already recorded the statement of the council representing the college wherefrom he has undergone the BEd course. So my submission will be, Lordship, and BTC authority has also admitted in last occasion that the speaking order should be set aside, and Lordship has only because of the standing outside the Guwahati University, Lordship has kept the matter pending today.
Yes.
He will answer how the degree is valid.
Where is he now?
Port number 10.
Okay, let's take it up after some time.
It may be taken up at 2, my lord.
At 2, I fix about 2 or 3 pieces.
Twenty-four, 25, and 26.
My lord,
Same one. Or? Okay.
my lord, in this case, Lordship,
Senior French start. Lordship Council B Kuku is on reg number 7. Can it be taken after some time?
No,
My
he wanted some time to file
Yes.
counter affidavit.
Yes, Lordship. In the morning, he has mentioned, Lordship. I pray, Lordship, that matter may come up on 20th, Lordship. 20.
What was his prayer?
Lordship, Lordship, they submitted an inquiry report against me, Lordship, by filing some inquiry report also. And the Honorable Single Judge has asked them to file their affidavit, Lordship, on that, Lordship. It's relating to the affiliation of pharmacy, Lordship, college, Lordship. So with all respect, since they are filing, Lordship, they should have to file it on before 28th, Lordship. And in the meantime, let them supply the copy of the inquiry report, a Xerox copy, Lordship. I pray so that I may be able to demonstrate before this honorable court about the background of that, Lordship.
Let Gogoi come. First,
Much obliged. He has also mentioned, Lordship.
let him come.
27.
Lordship, my senior is in next. Matter maybe pass over for timing.
Who's your senior?
SCKL Lordship.
May I submit lordship? It will be better lordship may fix another date, short date.
Okay. FZ Mazumdar, Learning Council for the petition. Short date will be after vacation only.
Immediately after vacation.
On request made on behalf of Mr. SCKL Leonard. Standing Council,
Of Assam University.
Assam University. List the matter immediately after the summer vacation.
Lordship may submit on. In fact, they are supposed to obtain instruction as per the last order. So they may place the instruction before.
On which date? Instructions out for by this court shall be placed. Instructions shall be placed before this court. Appropriate instructions shall be placed.
Lordship.
28.
Well, this matter pertains to provincialization of service of a dropout teacher in a venture high school. I am instructed that there is a division bench that special bench is constituted for dropout teacher. Otherwise, a short issue.
Yes, you
Regarding the provincialization matter, a special bench is constituted by the Honorable Chief Justice. So my lord, kindly after 2 weeks so that we can.
Or it may be listed before that special bench, and then it will be considered on 26, I think.
That has not been constituted.
It-
Let us wait.
Yes.
Third, Mr. BK Kuswami, Learned Senior Counsel assisted by MS
Ember.
Mbora. On request made by U Sharma, Learned Standing Counsel,
For secondary education.
Secondary Education, is the matter after
2 weeks or after vacation,
After
in the
vacation.
meantime.
after the summer vacation.
Deeply obliged, man. Deeply obliged.
29.
May please, may please, Lordship. I am on behalf of responded Lordship. Password for the pending Lordship.
Why? All cases are getting passed
Yes,
over.
Lordship, matter is very simple. Lordship. Matter relates
My
to
senior is
provincial.
left out just.
So without affecting his rights, Lordship, the matter relates to provincialization. Lordship. So matter may be referred under section 14, Lordship. The authority may, because disputed question of facts are involved. So my grievance is that, Lordship, I was appointed earlier to him. Thereafter, Lordship, after retirement of the earlier headmaster, my service has been upgraded and I am teaching language, Lordship. So for the respondent number 6 is all concerned, he is also teaching language, but he is junior. So disputed question of facts are involved. So by recording the statement of both the parties, matter may be referred to the authority, Lordship, under section
Yes,
14. Within a time frame, Lordship, they will consider the matter, Lordship.
Yes, ma'am. Letter may be
Yes,
under section 14 of.
There's a dispute on your seniority.
yes, Lordship. In fact, Lordship, there is a direction to file additional affidavit, but in this case, I am newly engaged, Lordship, but already there are 2 additional affidavit filed, Lordship. That may be considered. Specifically, the affidavit filed on 16th of 11, Lordship.
By you.
Yes, Lordship, additional affidavit to bring some document, relevant document. The documents are relating to the report of the Block Elementary Education Officer. The Lordship will kindly come to page 40. The second affidavit filed by the petitioner on 16th of November,
But
2020.
Dekha, if I'm going into the
Yes, yes, Lord.
under section 14,
Yes.
I don't need to go into all this.
So after hearing all the parties, the authority may pass a speaking order.
Yes,
Good.
that's better.
Okay, I have already filed affidavit.
Yes, that's your fault. What is your case?
Lordship, I was appointed, in fact, Lordship, the synopsis something, I was a the assistant teacher, Arabic, Lordship. So for the respondent number 5 and 6 is concerned, Lordship, they were appointed on 11/6/1985 and 1/1/1993. But after the death of the earlier headmaster,
11,
uh,
11, 6.
11/6/1985. So for the respondent number 5, as a Hindi teacher. And so for the respondent number 6, he was appointed on 1/1/1993 as a sectional teacher. But here, let's see what happened. The respondent number 5 He already Lordship retired from service.
This one number.
Response number 5. So therefore, also there is no grievance against him, Lordship. But so far, the response number 6 is concerned, Lordship, since he is a junior than me, teaching language, Lordship. So my service should be considered, Lordship. That is the.
He was
Lordship.
appointed on 1/1/1993.
Once response number 6 was appointed on 1/1/1993, but
Right.
I was appointed on 1st of June 1985
Yes, sir.
as an assistant teacher Arabic.
No, you, respondent.
Or response number 6 as a sectional teacher, Lordship.
Sectional teacher
Lordship.
in the same school.
In the same school, Lordship, Nabamilan,
What school is it?
Lordship. Lordship will take up the affidavit, it is a second additional affidavit that is there, Lordship. File on 16/11/2022. Lordship will find at page 40.
1 minute.
It is flag as a B, Lordship, flag B. That is the second affidavit.
Yes.
Here, Lordship, I have annexed the report of the block elementary education officer as well as the district elementary education officer. Lordship, kindly come to page 6. Page 6 of the second additional affidavit. This is the verification report submitted by the block elementary education officer, so and so. Here, Lordship, there is a particular report of the committee that Lordship will find at annexer 8. That everything is given, Lordship. Lordship, in the bottom, Lordship, page 8.
Hmm.
This is the format for report of Govardhana block. The heading is, Lordship, the teachers who are eligible for provincialization. That so far the petitioner is Lordship Mafizuddin Ahmed. Lordship will find at serial number 1, 2, 3, 4, 5. 5 is the petitioner, Lordship. There is this shown, Lordship, assistant teacher. Then, Lordship, number of students are given. And the response number 6 is serial number 8, Lordship, Rafiqul Islam, section teacher.
Respondent 5.
Response number 5 is Lordship Mizanur. Sorry, I'm sorry. Response number 5 is Muhammad Sanmia. Muhammad Sanmia, his name at Lordship Finance. 1, 2, 3, 4, 5, 6. 6 is Muhammad Sanmia, but he already retired on 28th of February 2022, Lordship. In fact, Lordship, all the above teachers are now retired. Lordship,
February
22.
2022.
Response number 5. Now my only grievance remain against the response number 6.
Then the district scrutiny committee.
Yes, this is a recommendation of the district report of the district block elementary education officer for consideration, but this was not considered. Again, this report has been forwarded by the member of secretary of the district scrutiny committee that Lordship will find at annexer 2, page 10. This is the report of the district elementary education officer to the director of elementary education for consideration. But my case is not still considered, Lordship.
By the district scrutiny committee.
Yes, Lordship, because he is the member of the district scrutiny committee, the DO, district elementary education officer. He is
Then
the-
what appeal can you file?
And the Lordship can file a representation after provincialization, the response number service of the response number 6. I prefer the representation that may be considered an appeal under section 14. Lordship.
No. There's no decision taken yet, isn't it?
Actually, Lordship, this is a recommendation from the DO, Lordship, but my
The district scrutiny committee is
No,
not taken a
not
decision.
taken this one.
Then the question of appeal does not arise. You may have to make a
Because
representation.
it is a report of the DO to the forwarded to the director for consideration.
Hmm.
Annexer 2, page 10. 3rd of August 2020, submission of modified field verification report regarding provincialization of service of teachers so and so. With reference to the subject cited above, I have informed you that the field verification report has been submitted to you by this office letter number as stated under reference, but some mistakes have been notified while filling up the prescribed format. Therefore, after correction of the information, a fresh copy of the report. So this is the report of the district elementary education officer. Now, since this is pending before the director, so director will consider this report, whether I am entitled or he is eligible. So this is the report of the DO.
So till now, no decision has taken.
Yes, Lord. No
Then
decision.
What grievance do you have against respondent six also?
Because,
What grievance do you have?
because from this report, it is
Even respondent six has not been provincialized.
his service already provincialized.
Already provincialized.
Yes, already provincialized. He's provincial, he is serving Lordship. Restaurant number 5, service of the
District
restaurant.
scrutiny committee has.
District Scrutiny Committee has recommended the service of the restaurant number 5 as well as the restaurant number 6. So accordingly, Lordship, they have been Lordship serving. But in February 2022, the restaurant number 5 expired, Lordship. Sorry, retired. And so far, the restaurant number 6, he is continuing, Lordship.
Okay. So your case has not been considered by the district.
District Scrutiny Committee, Lordship.
But respondent six has been considered by the.
District Scrutiny Committee as well as by the state level scrutiny committee.
Okay. That's. Okay. So it will be before the state government.
Yes, Lordship.
But Mr.
Dekal, Lordship.
Dekal and his council petitioner. Also heard Mr. A. Dapilda, standing council.
Elementary education, my lord. Respondent number 1, 2, 3, 1, 2, and 3, my lord.
Mr.
Respondent number 4, my lord. Sogia.
P cycle and government for respondent number 4. And Mr.
A
A for respondent number
number 6.
6. Stop. Para. The petitioner was appointed as assistant teacher within bracket Hindi, correct?
Lordship.
No. As assistant teacher within bracket Arabic.
Also for the petitioner is Arabic.
Arabic. On
1/6/1985.
1/6/1985. In the, what's the name of the school?
Lordship.
Nava Milan Emi
Yes.
Madrasa. Under Gobardana Educational Block,
Borpeta district.
Barbita District. Stop. The respondent number 5 was appointed as a Hindi teacher. Assistant teacher Hindi
Yes, assistant is a within bracket Hindi
in
teacher.
the same school on 11/6/1985. And respondent number 6 was appointed as section teacher in social science on 1/1/1992. Stop. Drafter, comma. When were the provincialized?
Provincial that order issued on 5th of February 2021. In fact, I have not annexed the order of the provincializing, but on the same day, the authority has issued this order, 5th of February 2021.
That is by the SLC,
Lordship?
by the SLSC. States Level Scrutiny Committee.
Yes, Lordship.
Drafter, comma. The case of the respondent number 5 and 6 were provincialized in the year 2021, correct?
Yes, 5th of February. I know the 5th of February
I
2021.
5/5/2021. So, however, case of the petitioner is yet to be considered for provincialization by the district scrutiny committee
Right.
till date.
And the service of the petitioner is updated after retirement of the earlier headmaster. That was done on
In the
31st of May 2020.
In the meantime, the post of the service of the petitioner has been upgraded from assistant teacher to
Assistant teacher, but he is allowed to teach social science and English
has been upgraded to teach social science
and English.
after the retirement of the then headmaster of the said school.
Good.
Para.
Then report submitted by the DU.
The district elementary education officer
Annexure to page 10.
by a letter dated 3/8/2020, addressed to the Director of Elementary Education, Assam, submitted the field verification report for considering the case of the petitioner, correct?
Yes, Lord.
For provincialization. Under the Assam Education within brackets provincialization of services of teachers and reorganization of educational institutions, close bracket Act 2017. Stop. However, till that, the district level scrutiny committee is yet to consider the case of the petition. The other grievance of the petitioner is that he is senior to the respondents. Respondents 5 and 6.
Yes, Lord.
In as much as petitioner was appointed earlier to them as assistant teacher within bracket Arabic on 1/6/1985. Stop. Para. Subpara. At this stage, learning counsel for the petitioner submits that the respondent number 5 retired on 28/2/2022, and as such, he has no grievance against respondent number 5. So, para. Rule 14 of the Act of 2017 provides for an appeal before the state government if against any orders, against any recommendation made by the state level scrutiny committee. Accordingly, para, this writ petition is disposed of, directing the petitioner to file an appeal under section 14 of the Act of 2017 before the
Secretary, Lord.
Secretary
Administrative head is.
Education Department, isn't it?
Yeah, school education, Department of School Education.
Department of School Education. Within a period of
Also, 15 days, Lord.
15 days.
Yeah, after they will take a decision.
With effect from today. So, thereafter, comma, the Secretary School Education Department shall consider the appeal filed by the petitioner by giving an opportunity of hearing to the petitioner as well as the respondent number 6,
And if necessary, the field level officer also, Lord.
as well as the field level officer.
The block elementary education officer and district elementary education. Field level officer that.
And any other concerned officials, if deemed necessary, and dispose of the same by speaking order and in accordance with law within a period of
60 days, 2 months.
2 months from the date of receipt of the appeal. So they have proceeded observations and directions to dispose of.
Complaint.
24, 25, and 26.
Lordship, we will supply them with the affidavit as requested by,
But Mr.
K. Majumdar Lordship.
K. Majumdar, learned counsel for the petitioner. Stop. On record, Mr.
M. Bhuyan, Lordship.
M. Bhuyan, the standing counsel had
No, Lord. On behalf of P. Google, Lord.
appearing on behalf of Mr. P. Gogol and the standing counsel health department. Is allowed, how much time you require?
On 20th, he is saying the
By
Lordship.
20th, it can come. Will
20 Lordship.
by Friday, next Friday.
Yes, Gogol,
Well, the affidavit is otherwise ready, man. We can file it by Wednesday, we can. So let it be, man, if convenient to the honorable court on Friday next, man.
Lordship, I pray Lordship, that may be, I will be
Or my lord, after filing an affidavit, he will require some time to file the
No,
reply.
Lordship, I think Lordship, what my learned friend, I pray Lordship, it may be on 20th Lordship. Since his affidavit is ready, because I will be out of station from 26th Lordship.
Okay, cancel the order. Mr. D. Google, then the counsel for the London Standing Council Health Department submits. That affidavit is ready and he'll spend the same within a short period of time. Accordingly, list the matter on when.
20 Lordship,
No, 20 it will be, because I will have to send it to the department.
21st Lordship then.
22nd.
22nd.
22nd. I pray Lordship, one thing Lordship, let my learned friend maybe ask for copy of the
That,
inquiry.
otherwise it will be annexed with the affidavit.
Lordship.
I can.
Lordship, he may be provided the same Lordship.
He's annexing it in the affidavit.
Lordship.
Isn't
Yes,
it?
that is the order, last order.
Only order he is annexing, entire inquiry report is needed for, because he has placed this document Lordship
No,
on
no,
that
that
date.
my lord, entire report, I will place it in the affidavit. There are several documents. sir.
Okay.
30,
Maybe. This is similar to one advance increment for the teachers Miller who are working as a teacher in high secondary schools. And in this similar, we have earlier filed petition, we have Miller working, we have got it Miller. Kindly similar order dated Miller 25/6/21 passed by the department Miller, can page 51 Miller.
Yes.
In this order, Miller, by this order, Miller, we have been Miller granted Miller the one advance increment. We are getting for some time. And after Miller, without any Miller reason, again Miller the same is rejected, cancel Miller. Cancel the next page Miller, page 52. In presence of the so-and-so, letter number so-and-so, Miller, as to the school shown below, who were allowed to draw one advance increment by this official order, memorandum, earlier order Miller, on 25/6/21 is
Yes.
hereby cancelled.
You shall.
Yes, my lord. My lord.
And for last 1.5 years, they are taking training for inspection.
Acquiring B.Ed degree was 10/7/2012.
What is it?
Cut-off date of B.Ed degree. Now it is thereafter, my lord, B.Ed degree is essential qualification.
File your affidavit,
that-
then why are you not filing your affidavit?
Yes, we have received the instruction, my lord.
1.5 years.
Okay, Mr. Hurt A. Roshit, and the council for the application.
Other similar teachers, they are getting Miller. Only Miller, we 4 persons are Miller.
Mr. U. Sharma, then the standing council.
For secondary education.
Secondary education, Mr. Lord, how much time? Submits. That he has received instructions and prays for,
4 weeks time, my lord.
what 4 weeks?
3 weeks, my lord, after vacation, my lord.
Prays for 3
1.5
weeks.
years.
File county after.
Yes,
Praise the
acquired the B.Ed degree 13/11/2019.
List
my
the
lord.
matter after 3 weeks.
Oh, it made me 2 weeks Miller, a long time they are taking. 2 weeks.
2 weeks also will come summer vacation.
There
3
is a
weeks
will-
also summer vacation.
31 and 32.
In this case also, my lord, respondent has not filed affidavit. my lord.
Time to file affidavit.
Affidavit is required.
Third year, but real and a council for the. On request made by Yas Abdullah, and standing council. Elementary.
Elementary.
How much time? 3 weeks time is enough to file.
I am for respondent number 4, my lord. That may be fixed, my lord, after application. my lord.
2 weeks. Not now, not now.
Obliged.
33,
This matter relating to provincialization of service, my lord. As the special bench has been constituted. Otherwise, my lord, your lordship, similar order is there, my lord.
Heard Mr.
K Uddin, my lord.
K. Udin and the council for the petition. Who appears?
I am appearing.
On request made by U. Sharma and the council, then a standing council. Secondary education, list the matter after 3 weeks.
Obliged.
34, 35 and 36.
Lordship, arguing council, Mr. J. Mudumdar is in Lux. It may be taken after some time.
I'm having a lot of other cases after some. We'll fix a different date. On request made on behalf of Mr.
J. Laskar.
J. Laskar, Leonard Counsel for the petitioner. Is the matter after 2 weeks.
37 and 38.
May please all watch it. Also, in the item number 37, my lord, I appear on behalf of Mr. P. Monto for the Bar Council of India, my lord. If your lordship praises the last order, his name was to be reflected in the cost list. The same was not done, my lord, because of which we have finished the matter today. Anyway, my lord, we have sought for some instruction from the Bar Council of India. We wish to file a affidavit against the petition, my lord. So I the matter may be taken up immediately after the vacation, my lord. In the meantime, we will also file our reply.
Hello, this is the last time, my lord. Otherwise, for a long time, my lord, I am.
Mr. P. Mahathir. On request made by Mr.
R.B. Gohai on behalf of Mr. P. Mahanta, my lord.
R.B. Gohai, Leonard.
Both sides
Counsel,
team on
appearing on behalf of Mr. P. Mahathir, Leonard Counsel for respond number.
4, my lord, Bar Council of
Four.
India.
How much time?
Immediately after the vacation, my lord.
3 weeks time. is
Lordship.
allowed to
On
file
that, maybe
UGC. Counter affidavit. Mr.
B Das on behalf of his
B. Das.
UGC.
Leonard Counsel appears on behalf of the UGC. So, this the matter after 3 weeks.
My lord, if it is possible, not get me, my lord.
Difficult.
After it's a long time, my lord, I am, my lord, struggling this case, my lord. That is why, my lord, praying.
No, you can.
Because
make a-
my time for the, my lord, applying also it is running out. So this
You
is. the-
can make a mention immediately after the vacation. I'll give you a
My lord, I have a small family. The registry may be directed to reflect the name of Mr. P. Monto for the respondent, my lord.
Registry is also directed to reflect the name of Mr. P. Manda, Leonard Counsel, appearing for respond number 4 in the cost list.
I love this.
39.
38 is there, my lord. 30 is a separate matter, but the advocates are different. My lord. I am also to petitioner.
Same
The
order.
university has not come, my lord. They have filed the affidavit and I have also filed a reply, my lord. My reply was filed on last, my lord.
This is analogous matter,
Analogous, but the issues are different, my lord.
but then it is not analogous.
My lord, this is relating to, my lord, I am for the NOC for applying to the, my lord, Bar Council of, as per the Bar Council of guidelines for opening the LLB course in my institution. And that is second one is regarding, my lord, the recognition for the NCT. For the, I applied for the university.
Come up together later.
All, my lord.
39.
With your lordship. My lord, this petition is against an order of an educational tribunal. The respondent number 5, my lord, he approves the educational tribunal and the order passed. By that, the petitioner is aggrieved. Now, my lord, on the last occasion, my lord, I don't know whether it is recorded in the order sheet. Your lordship, I came up before your lordship. Your lordship perhaps directed the state government to file an affidavit. That affidavit has not come as yet.
Senior election court number 20. Kindly pass over.
I'm not passing over. Who appears for the state?
I am the secondary education department.
Are you filing your affidavit or not?
We have received the instruction, my lord, here. So
Have
we
you-
will file the affidavit.
Respondent number 5 has filed affidavit.
Yes, my lord. Let the government file the affidavit and let it come after the vacation, my lord, any that convenient to your lordship on a hearing day, my lord. Because the matter will take some time, my lord, time otherwise ready.
But Mr. M.K. Chowdhury, Leonard Senior Counsel, assisted by Mr.
You give some, you give
U.K.
some.
Goswami, Leonard Counsel for the petitioners.
Lordship, the seniors are, I'll do lordship. My senior is coming up. He's in like.
Counter is going to be filed. Mr. U. Sharma, Leonard Standing Counsel,
For secondary education.
Secondary Education submits that he has received instructions, correct?
Yes.
And prays for a short time to file counter affidavit. Stop, prayer is allowed. List after 3 weeks,
After the holidays, my.
after the summer vacation.
Date may be fixed.
Obliged.
40.
I'm not passing over. You want
Well,
different?
the matter is very urgent because the students, the petitioners or the students of the college, they have been expelled. So on the last occasion, they were asked to take instruction under what rule we have been expelled. Because prima facie, no so-called was, no inquiry was held. We were not called. And now they have come with an affidavit, with an affidavit saying some inquiry was held, and as per their own statement, we were not called to the inquiry. That's why on the last occasion, this honorable court directed them to get the instruction under what rules we have been expelled. Because here, the consequences are far-reaching. The students have been debarred from sitting in the examinations. There are two petitioners here. For participating in a college farewell function, they were expelled without any inquiry. We were not called to the so-called inquiry held by them.
Yes,
For the university or not?
you're for the university.
They were the college.
You're for the college.
No, from the university.
Who appears for the college?
Oh, no, they have not come today. For the last 3 occasions, they were there.
Why is this?
The matter is very urgent, so far as we are concerned, because the exams are getting
The
approaching.
service has been completed against the respondent because notice was
It is coming up for admission. Obviously, the notice has been completed.
I am appearing for 1 and 2. My Leonard Paint is appearing for university. But the answer has to be come
As
from
college
the-
entered appearance, they filed the affidavit. They filed the affidavit, yes. And on the last occasion, the college council was asked to get instruction.
Who was the council?
A.Y. Chaudhary. His name is there in the cause list.
Yes.
It's reflected in the cause list.
Where is he?
I have not seen him.
You're Mr.
Hemar Adhikari. Well, let it be on Monday, because the matter is very serious, so far we are concerned.
Mr. Emar
Every time the matter comes up,
Adhikari, Learned Council for the petitioner. None appears for respond number 4. 3, 4, and 5 or 4?
yes, 3, 4, and 5.
3, 4, and 5. This the matter again on that Monday. 21st.
Much obliged.
May I please, your lordship. Lordship, there is a matter, your lordship, item 67, lordship. Lordship, it's a matter relates to pension, lordship. Yeah, day before yesterday, the matter was listed, lordship. Lordship, remember Dibrugarh University pension. Lordship, can the matter be taken up at 2 o'clock, your lordship?
Do I fix about 2, 3 cases?
After those cases,
After
lord.
those cases, maybe.
Much obliged, much obliged. There is some urgency, that's why. Much obliged.
My lord, in that Dibrugarh University matter, there is a development, my lord, that item number 67. My lord, there is a difficulty on the part of the Dibrugarh University because there is a ceiling, my lord, which has been fixed by the finance department. The treasury, Dibrugarh treasury cannot release the money, my lord. There's a ceiling of 7.83 crore. I think this is the letter, my lord. Extra.
Who's for the finance?
With regard to the subject and reference cited above, I have the honor to inform you that as per direction to release pension, family pension to eligible employees who retired before so and so, we would like to lay before you the following few details regarding fund position for your kind consideration. Proposal submitted so and so, grant so and so. Actual release by Treasury Dibrugarh per month 9.83. Actual disbursement is 9.30.
So current there is a deficit, total deficit so and so. So my lord, they have said that additional this amount would be required. The important part is in the next page, my lord. It may be pertinent to mention the demand of so and so for the financial year 23-24 as submitted, anticipating additional expenditure to be incurred for filling up the vacant post under salary head, and process of filling up without requisite fund is delayed, which affect the functioning of the university. We are also of the view that Deputy Secretary to the Government of Assam, Higher Education Department, while directing a release of pension from the allocated budget of 94 crore, should direct the Treasury Dibrugarh to release additional fund per month as per actual amount released till that per month 7.83 crore is inadequate even today to pay the salary. Therefore, it would be necessary to issue a revised direction to the Treasury Dibrugarh to release additional fund as per requisition, or Treasury will not release more than 7.83 crore per month as per office memorandum dated so and so. We request you kindly to take necessary steps to request Finance Department, Government of Assam, to give instruction to Treasury Dibrugarh to enhance the monthly allocation so that pension may be paid every month along with the salary. We also take this opportunity to request for supplementary budget allocation as per requisition given earlier, and also so and so. So my lord, now I think the finance will have to issue, initially to the Treasury, and my lord, supplementary budget should be provided.
This was written only yesterday.
Only yesterday? Yesterday.
Oh. What were you doing all this time?
No, Lordship, after the receipt of the instruction dated 13th, the matter had come
Prior
up
to
on-
that also, you could have already written this letter.
So that's Lordship, I may be allowed to explain. The earlier is, it was,
Originally, you knew your difficulty that you have a ceiling limit of 7 point something crore. only.
Lordship, like others, I was unable, 94 crores is available with the university.
That
Only-
we know, that we
That is
know.
no, that they get only a limited amount.
This is the reason
which
why
as
that-
per this
yes.
instruction,
This
they-
is not happening only today. It was happening from before. You could have taken this step.
Lordship, earlier this was not the
Suddenly
case.
you just write this letter
Lordship,
yesterday.
earlier it was
Just-
for strictly for only on 13th, they have made it clear that you can pay it from the salary account also.
Just because this case is coming up today, you issued this letter yesterday, is it?
No, not like that, Lordship. The developments have been like this. On 13th, the government says you can release pension from salary. Earlier it was strictly earmarked for
Chaliya.
salary.
After going to the letter, Lordship may posted the matter after vacation also, both will discuss Lordship, and will ask also Finance Department Lordship to extend the cap Lordship. Filling amount. So Lordship may, if
ठीक है, ठीक है.
not difficult
If
Lordship.
it will let my lord, government issue the inspection to the
Lordship may-
Treasury and
we-
Dibrugarh University.
Lordship may direct to ask Lordship. Commissioner Secretary, Higher Education
But
Department.
Mr.
as well as Finance
Lord-
Department.
Senior Counsel has by Mr. DJ Shah.
Das.
DJ Das. Learned Counsel for the petition. Mr. R. Goswami, Learned Standing Counsel. During the course of hearing of this contempt petition, has produced a letter dated 15/6/2023, written by the registrar in charge, Dibrugarh University. Wherein request is made to the Finance Department of the Government of Assam to give instructions to the Treasury Dibrugarh Assam to enhance the monthly allocation so that pension may be paid every month along with the salary, etc. Stop. It is the case of the Learned Counsel for the Dibrugarh University that the Finance Department has put a ceiling of rupees 7.83 crores for payment of
Whatever it is.
salary oblique pension. However, the said ceiling of 7.83 crores is not sufficient even to pay the monthly pension, salary of the staffs of this Dibrugarh University. Staff. Mr. K. Gogoi, Learned Standing Counsel, or you're the counsel. So it's a contempt petition. Learned Counsel
Representing the Lordship, Higher Education Department, Lordship,
representing the higher education
and my part is for finance, Lordship.
as well as Mr.
Chaliha.
Chalihal and the Standing Council Finance Department is directed to take instructions as to whether, not take, shall have,
They will direct the respective
shall direct the respective departments to take steps for increasing the ceiling
Enhance the cap ceiling,
or oblique enhance the cap,
Lordship.
enhance the ceiling for payment of salaries, oblique pension with regard to the Dibrugarh University stock. When do you want?
Lordship, it will come after vacation, Lordship, in the meantime.
This
Lordship.
matter after.
এবাৰ আগতে আহি লওক নেকি
আগতে নালাগে sir.
এবাৰ 26 তাৰিখে আহি লওক
Vacation of the 26 তাৰিখে লাভ
No, my lord, let it come upon 26, my lord. In the meantime, let them issue the instruction. Once, my lord, for monitoring.
We'll try, Lordship, we'll try, Lordship. There-
No, my lord, only
Don't try if you're confident that you can do it, we'll list it.
Lordship, after vacation, Lordship, in the meantime, we'll do it.
After we'll list it after vacation.
Sir, আগত হৈ যাব sir, চিন্তা কৰক,
Let
আগত-
them-
আগত হৈ যাব।
Let them have some time.
আগত হৈ যাব। আগত হৈ যাব।
List the matter immediately after the summer vacation.
and my lord, there is a request for supplementary budget also, that also finance will consider.
The letter dated 15/6/2023 is placed on record.
My lord, that part also indicates regarding.
On top, you also say
There is a request for supplementary budget.
a further request is made for supplementary budget allocation. As per requisition given earlier by the Dibrugarh University. In as much as the funds allocated to the university will be exhausted within a few months. Para, that's me just going to say so, no? We'll also take instructions with regard to the supplementary budget allocation requested by the Dibrugarh University.
My lord will give a date, my lord, after the vacation.
After vacation, what date do I expect? Yes, Gogoi.
I think, my lord, meanwhile, my friend Mr. Gogoi will issue the instruction that we are taking it.
Lordship, I'll do, in the meantime, I will do.
When can we have it?
Lordship, on 21st to 20.
Okay, 20. হ'ব, হ'ব, বন্ধ পিছত আহিম।
21st.
In the meantime,
Deeply
Lordship,
obliged.
we'll do, Lordship. হ'ব যাব। আমাকে না।
I can follow up. This is. I can. Yes, Google.
Lordship. So when I went last today, Lordship, I am some difficulty regarding my sound, Lordship, some problem is there, so Lordship. I will continue, Lordship. I'll continue.
If you have difficulty, you can have it.
Otherwise, no problem,
You
Lordship.
can have it.
Some-
We have,
No, Lordship, today we will do, Lordship. Today we'll do, Lordship. I will do it, Lordship. Lordship, last occasion, my lord, I have just indicated Lordship has to decide the 4 issues, Lordship. Just I reminded, Lordships are already noted, Lordship. Already-
Yeah, that I've taken note.
Lordship already taken note. Now regarding Lordship, I will advance my argument in respect of first point, Lordship. Whether there is any violation of the ICT's notification, was there any derogation or dilute the ICT norms, Lordship? That part I will, Lordship, address. So my lord, may kindly come to page 22, Lordship.
Of which WBC?
WPC, Lordship, 2286-23, Lordship. Nikhil Soikia and 12 others, Lordship. Page 22, Lordship. My lord, this is the advertisement issued by the Lordship, Assam Engineering Service Recruitment Board, Lordship, It is 21 to 2023 lordship. Where lordship various posts are indicated lordship. Total 18 numbers of vacant post lordship in defined polytechnics government of Assam lordship. So my lord may kindly turn page 23 lordship. Page 23 lordship. Qualification part lordship. Qualification column lordship. A lordship. Level 9A lordship. My lord may kindly mark it. Level 9A lordship. BE, BTech, BS in the relevant discipline with first class to equivalent lordship. Then lordship B level 10. Lordship may kindly mark it. There's a reason so why I am lordship put it. Bachelor or master degrees in relevant discipline with first class in either of the two at the time of application lordship. Then lordship note portion is there. Integrated MTech degree to be considered provided by the candidate secured first class in integrated MTech course in the relevant discipline lordship. Then lordship scale of pay lordship. Level 9A lordship. It starts from 56 to lordship, 56 to 100 to so and so, and level 10 lordship, rupees 57,700 to so and so lordship. We have advertised the post lordship to level 9A and level 10A lordship. Level 9A and level 10 is the entry level. So lordship may kindly peruse the AICTE notification which I have already supplied to lordship. Lordship regarding diploma regulation lordship. It in the English portion is started in from paragraph page 20 lordship, internal page 20. Diploma education lordship. It's a AICTE's regulation on pay scale, service conditions, and minimum qualification for appointment of teachers and other academic staff, such as library and physical education personnel in technical institutions, and measures for maintenance of standards of technical education. Diploma regulation 2019 lordship. So my lord may kindly directly come to lordship, internal page 27 lordship. Lordship. Page 27 lordship. 4.1 lordship. For direct recruitment of lecturer level 9A lordship, NT pay 56,100. Then lordship kindly compare it to page 23 of the writ petition lordship. Page 23 of the writ petition lordship.
Yes.
Page 23 lordship. Qualification part lordship. Level 9A lordship. It's level 9A. Then scale pay lordship level 9A lordship 56,100 lordship. It is consonant with the as it is notification lordship. Then lordship my lord may kindly come to the qualification part. Which qualification is required lordship? Those possessing minimum 4 years bachelor degree shall be placed in the level 9A at the NT pay scale of Iman.
Where is that?
In lordship page 27 of the notification lordship. Page 27 of the notification lordship 4.1 lordship.
Yes.
4.1 lordship. It's direct recruitment lecturers level 9A lordship entry level. Qualification is lordship for engineering and technology. B, BTech, BS relevant discipline with first class or equivalent lordship. This is required in respect of lordship. Our advertisement concern only this engineering and technology. So other part, pharmacy, hotel management, architecture, fine arts, design, and science and humanities not required lordship. So lordship, in diploma engineering for lecturer entry level 9A lordship, the requisite qualification is lordship B, BTech, BS relevant discipline the first class or equivalent lordship. This is the requisite qualification for lordship
entry level 9A lordship. Only educational qualification is required lordship. There is no any additional qualification in respect of lordship, experience lordship. Only that much is required lordship. Only this is the required qualification prescribed by the AICT lordship. Required minimum qualification. Nothing else lordship. We cannot add anything lordship. We cannot lordship dilute it lordship. We can enhance the qualification, but we cannot dilute it lordship. Only required qualification is lordship. The candidate must be lordship BA, BTech or BS in the relevant discipline with first class or equivalent lordship. There is no experience part lordship. There is no requirement of experience lordship. Then my lord may come to next lordship, level 10 lordship. Level 10 lordship. Level 10 is lordship 4.2. Its entry pay is lordship 57,700 lordship. And my lord may kindly compare with the advertisement page 23 lordship. Level 10 lordship. Pay is lordship 57,700 lordship. And lordship regarding the qualification part lordship 4.2.A lordship. Only that is relevant lordship. Bachelor's and master's degrees in relevant discipline is first class in either of the two at the time of selection lordship. This is the only required qualification. Then my lord may kindly compare it with the advertisement lordship. It is level 10 lordship. Bachelor's and master's degrees in relevant discipline with first class in either of the two at the time of application lordship. Exactly the line which was quoted in the ICT, that was lordship done here. There is no deviation from the ICT's required qualification. Only that much is required lordship for entry level 9A and 9K lordship. There is no provisions for experience part. Here lordship, there is not required any experience. We advertise for entry level 9A and 9K lordship. 9A and level 10 lordship. There is no requirement of experience lordship. The UGC ICT prescribed the requirement only the lordship, the degree which should be their lordship. Nothing else lordship. Now lordship, from which stage lordship experience part is required lordship. So my lord may kindly turn to next page lordship. It is lordship 4.3 minimum qualification for lecturer senior scale level 11 lordship. It's an entry pay of 68,900. That particular post was we never lordship advertised lordship. The required qualification is lordship. Qualification is prescribed for the post of lecturers. 3 weeks industrial training in the level of lecturer lordship. Then my lord may kindly come to lordship 4 lordship. Minimum 5 years experience and average of 360-degree feedback score between 8 to 10 scale of the 10 of the cadre of lecturer lordship. The stage lordship, which is starts from lordship level 11 lordship, only that level lordship, the experience part is required for direct recruitment lordship. Our advertisement is lordship for the entry level. Entry level is 9A and 10 lordship. There is no requirement of the experience part lordship. Experience part comes only from stage 11 lordship. Level 11 and subsequently level 12 lordship. Level 12 also 4.4 lordship. It's 4 lordship, minimum 5 years experience is required lordship. Then also lordship 4.5, minimum qualified lecturer selection gate level 13A lordship. Next page also lordship. It's lordship page 29 4 subpara 3 lordship, minimum 6 years of experience lordship. One of the argument advanced by senior sir is that lordship, the AICT's prescribed experienced parties not considered in this particular advertisement lordship. After going through the AICT's notifications, which was adopted by the state of Assam, and lordship, the advertisement issued by the government of Assam, it's clear that lordship, there is no requirement for the past experience part lordship. Only eligibility condition prescribed by the ICT is lordship, that qualification in respect of education lordship, not in respect of lordship experience lordship.
Yes.
So lordship, in the advertisement, there is no violation of the ICT's notification lordship. ICT specifically prescribes certain modes and certain norms that was adopted by the government of Assam, and it was implemented, and it was in the as per ICT's notification in the advertisement lordship. There is no any derogation, there is no any dilution of the ICT's notification lordship. That is in respect of lordship, experience part lordship. In respect of experience part also lordship, although it is not required lordship, just I have explained, because there was a advance, there the argument is there lordship, our experience should be counted lordship. Their experience should be counted in the stage 11 lordship, not in the entry level 9 and 10. In the stage 11 also lordship, their experience part will not be counted lordship. Why it will be not be counted? So lordship may kindly come to the ICT's notification lordship. In internal page 25 lordship. Internal page 25, counting of past service for direct recruitment and promotion lordship.
Page 25.
Page 25 of the internal page of the HT's notification lordship. Counting for past service of direct recruitment and promotion lordship. Although the advertisement was issued for entry level 9 and 10 lordship, the expense is not required. The stage from the 11 expense is required. From that stage also they are not entitled as because lordship, I have to explain it. So lordship may kindly come to F lordship. The previous appointment was not as a guest lecturer of any duration or ad hoc, or in a leave vacancy or less than 1 year duration. Ad hoc or temporary service can be counted, provided that lordship, he should fulfill all the conditions stipulated herein below lordship. Number 1 lordship, the period of service was more than 1 year duration. We have no objection lordship. The incumbent was appointed on the recommendation of the duly constituted selection committee. That was not there lordship. As per the rules which is govern the engineering colleges 1981 service rules, the appropriate authority is the Assam Public Service Commission lordship. At that relevant point of time. Now it was that particular rule was amended. Now that was shifted to the recruitment board lordship. At the relevant point of time, incumbent was appointed on the recommendation of the duly constituted selection committee. That was not there. That is in respect of counting of just I am elaborate lordship why they are not entitled in that stage also lordship. Although it is not required in our case lordship. Incumbent was selected to the permanent post in continuation of the ad hoc or temporary service lordship. He should be selected for a permanent post, then his past service should be counted lordship. It is very clear lordship. An artificial break of service, we are not going through it. 5 not going through it lordship. 6 is lordship also there. 5 is required lordship. The incumbent was doing total gross emolument not less than monthly gross salary at the initial stage of regular appointment of lecturer, head of the department, principal as the case may be lordship. We cannot say that lordship, this part is favorable for us, we can adopt it. This part is against us, we cannot adopt it lordship. Petitioner cannot say that. His past petitioner's past service will be counted, provided that lordship. UGC, AICT never says that either you have fulfilled is either or lordship. Either 1, either 2, or 3, or 4, or 5, or 6. AICT never said that. AICT says that you should fulfill the following conditions. Number 1, number 2, number 3, number 4, number 5, number 6, lordship. If he fulfill all the stipulated conditions, lordship, then his past service should be counted from the level of 11, lordship.
But that we are not concerned with.
Here, lordship, this is not concerned in our case, lordship. Yes, because there is an argument advanced, so I am clarified it, lordship. If suppose entry level 11 also, lordship, they are not entitled, lordship. Our advertisement is, lordship, for the level 9 and 10. Level 9 and 10 required qualification already given by the AICT. There is no any deviation from the AICT's required qualification, lordship. AICT never says that in the entry level you have the experience, lordship. You should count the experience, lordship. Nowhere AICT says that, lordship. And here, even AICT's qualification is also not in respect of, lordship, the experience part. It's an entry level, lordship. Anybody graduated BSc, BTech or BSc, lordship, there he can, lordship. That, lordship, experience part is only applicable from the stage of level 11, lordship. Level 11 also, lordship, he should fulfill all the criteria stipulated by the AICT in 2.22 F, lordship. Then it will be counted for level 11, lordship. From the conjoint reading of the AICT's notification, lordship, and the advertisement issued by the Higher Education Technical Department, lordship, there is no violation of the AICT's required norms, lordship. There is no any criteria stipulated by the AICT that you should count the experience part for entry level 9 and 10, lordship. We cannot override it. We cannot dilute it, lordship. Minimum required qualification we have to follow, lordship. So, lordship, there is no any violation in respect of qualification and experience part, lordship. Now, lordship, first, the first point, lordship, which was I have put, lordship, my submission is that, lordship, there is no any violation of the AICT's notifications. The advertisement which was issued is consonant to the qualification type by the AICT. AICT nowhere prescribed that the past service should be counted in the entry level, lordship. Our advertisement is for entry level 9 and 10, lordship. So, lordship, there is no violation of the AICT's notification, lordship. Then, lordship, next question come to our mind, and we have to decide it, lordship, whether AICT provides any mode or procedure for selection to the post of, lordship, lecturers which was advertised by the Government of Assam, lordship. After going through the AICT's notification, page, first page to last page, lordship, AICT nowhere mentioned, lordship, the appointing authority should adopt such procedure. Appointing authority should prescribe such procedure to formulated and distribution of marks, mode of selection. Nowhere AICT, lordship, mentioned it. AICT only prescribed the minimum required qualification in respect of entry level and respect of, lordship, stage 11. AICT prescribed the minimum qualification as well as how much experience is required, and level 12, 13 and so onwards. And regarding scale of pay, ICT given what kind of scales, what should be the in entry level 9, what should be the 10, what should be the 11, and other things, Lordship. But AICT nowhere stated, Lordship, state should adopt such policy, state should formulate so and so, and ICT has formulated so and so, we have to follow it. ICT nowhere says that. Then what is the, then Lordship, whether state can, Lordship, adopt a policy of its own to select the best of the candidate. Lordship have to decide. As because AICT only given us, provide us, Lordship, only qualification part, and other part is not given by the ICT. So states have to adopt or follow on procedure to select best of the best candidates. There is no bar from the state. AICT is proceed. Nowhere is AICT debarred from the state authority to execute its own power to select the best of the best candidate. As because they have not given any guidelines, not formulated any scheme for selection of the candidate. So, Lordship, I am on the basis of the law laid down by the Honorable Apex Court, I will advance my argument in that particular point. Whether state can adopt its own policy when there is no any provision is given in the statutes or any other OM regarding selection of the candidate. Rajesh Kumar. Ramesh Kumar, no? In that particular point, my submission is before the Honorable Court is that, Lordship, state can adopt its own policy to select best of the best candidate when the act or statute is silent in respect of that particular issue. Lordship. So my Lord may kindly come to paragraphs 11 and 15. The citation is, Lordship, 2010 TSCC 104. Para 11 and 15, Lordship. If Lordship permit, I can read it, Lordship.
Also the page number.
Paragraph 11.
Page number.
Page number. 2010 TSCC 104. Paragraph 11, Lordship. In state of UP versus Rafiquddin, Krishna Chandra Sahu, Doctor, State of Orissa, Manjit Singh versus ESI, K. Siraj versus High Court of Kerala, the court held that the commission board has to satisfy itself that a candidate had obtained such aggregate marks in the written test as a qualify for the interview and obtained sufficient marks in Viva Voce, which would show his suitability for service. Such a course is permissible for adjusting the qualities and capacities of the candidate. My Lord may mark it. It may necessary in view of the fact that it is imperative that only person with prescribed minimum of said qualities and capacities should be selected, as otherwise the standard of judiciary would get diluted and substandard staff may be selected. Interview may also be the best mode of assessing the suitability of a candidate for a particular position, as it brings out the overall intellectual qualities of the candidate, while the written test will testify the candidates in academic knowledge. The oral test can bring out or disclose overall intellectual and personal capacities like alertness, resourcefulness, dependability, capacity or for discussion, ability for take decision, quality of leadership, etc., which are also essential for a judicial officer. Then, Lordship, paragraph 15, Lordship. Thus, the law on the issue can be summarized after discussing all the earlier decision of the Apex Court, Lordship. The Honorable Court finally held that, Lordship. Thus, the law on the issue can be summarized to the effect that In case the statutory rules prescribe a particular mode of selection, it has to be given strict adherence accordingly. Then Lordship, in case no procedure is prescribed by the rules, there is no other impediment in law. The competent authority, while laying down the norms of selection, may prescribe for the test or further specify minimum benchmark for written test as well as viable solutions. This is the ultimate findings of the Honorable Apex Court, where the statutes or rules does not prescribe any particular mode for selection, then state can adopt its own lordship for selecting it. Lordship, state can implement its norms by laying down lordship certain norms. This is the ultimate finding of the Honorable Apex Court. Here also, Lordship, in the writ petitions, petitioner says challenge the page 66, Lordship. Page 66. Before page 66, my lord may kindly come to Lordship. Page 24, then it will be clear, Lordship. Page 24. Page 24, Lordship, process of recruitment. There is a two-stage, Lordship. As because AICT does not prescribe anything regarding recruitment, state has formulated this, Lordship. The two-stage recruitment should be held, Lordship. One stage for OMR and MQ based examination. Other is teaching proficiency test, Lordship. And it says that OMR MQ based question papers booklet shall contain 75 questions carrying 1 mark is correct answer. There will be negative marking so and so marks for answer. Only shortlisted candidate call for teaching proficiency test, Lordship. Necessary guidelines, next page, Lordship. Necessary guidelines, instructions relating to OMR MQ based written examination and teaching proficiency test will be notified in due course on the official website, Lordship. This is in advertisement when it was issued, Lordship. It is specifically mentioned that the necessary guideline instructions relating to OMR MQ based written examination and teaching proficiency test will be notified in due course of time in the official website, Lordship. This is their, Lordship. On the basis of that, Lordship, the page 66 is issued by the Technical Education Department, Lordship. Page 66. In pursuance to the authority, Lordship, derived from the advertisement, Lordship, that was issued by the authority, Lordship. It is not
what the council, senior council was saying is on the syllabus,
Lordship,
on the syllabus.
syllabus. So I am saying that, Lordship, just I am relying that judgment, Lordship. I am
No,
relying the
that
judgment.
is with regard to the mood of selection.
Mood of selection, mood of
That is
select,
fine. That is fine.
Lordship.
That is fine,
Lordship.
but with the syllabus, what he's saying is this syllabus, the intending candidates would not be in a position.
This is a incorrect
From where they
submission.
got the syllabus? From where they got the syllabus?
I will, where they bought the syllabus, it is not concerned for the candidate, Lordship. It is for the employer, not for the, Lordship, the intending candidate to show what should be the qualification, what should be the criteria. It is not permissible for it. It is for the employer to decide what is the best qualification, what is required for select the best of the candidate, not for the intending candidate, Lordship. It is not that all the candidates is coming here, Lordship. The candidates who are already in, Lordship, temporary, Lordship, engaged, Lordship, they are here, Lordship, not the other candidate. Reason behind this, if the recruitment process is not completed, they will continue, Lordship. Ultimate reason is that, Lordship. Although it is not good for saying, Lordship, but ultimate reason is this, Lordship. If the process is delayed, if the process is not complete, they are continuing, Lordship. And we are facing problem from the regulating authority, Lordship. We need regular faculty, Lordship. Regarding the qualification part, Lordship, and other things, which mode we have to select, Lordship, And what should be the qualification? What should be the procedure? What should be the interview? What marks should be given? What marks should not be given? It is not the lordship concern of the intending candidate. It is for the employer lordship. It's very clear from paragraph 15 of that particular judgment lordship. Again, I am read lordship. In case no procedure is prescribed by the rules, there is no other impediment in law. Competent authority, while laying down the norms for selection lordship. This is the norms for selection lordship. May prescribe for the test. This is the test lordship. Further specify the minimum benchmark for the written test as well. This is the test lordship. We have prescribed. This test was lordship never anywhere lordship. We have to source because it's a competitive market lordship. There is a competition lordship. Push this 80. Applicant is more than 1,000 lordship. How we have to source lordship? We have to source best of the best candidate lordship. For selection of the best candidate, there should be a methodology. We cannot pick and source lordship. We cannot source on the basis of the lordship, the educational qualification marks lordship. I may get 50%, my brother may get 90%. In the written examination, my brother may get 40, I may get 90 lordship. Then who will be qualified person lordship? We have to balance it lordship. We have to balance it because we have to source best of the best candidate lordship. So this is prescribed lordship. It is not a bar. It is not a bar lordship. Nowhere says that we cannot adopt a particular procedure to select the best of the best candidate. Now, lordship, my lord may kindly peruse page 66. What is there, lordship? It's not a foreign lordship. It's not a foreign lordship. So, lordship may kindly, I read it, lordship may kindly. Yes. First is lordship, issuing and skill proficiency test to be treated as an integral part of the test to be conducted for the selection. Final merit and selection list will be based on the gross performance of the two tests, written test, issuing and proficiency test lordship. The candidates lordship, the final select will be prepared lordship on the basis of the stage 1 and stage 2 lordship. Stage 1 is written test, both combined lordship, the final merit list will be prepared lordship. All aspiring candidates will appear both the test lordship. If he appeared and succeed in the first round lordship, now the government says that the candidates who have appeared in the written test, all are allowed to appear in the proficiency test lordship. Now lordship, we have to source the candidate from both the marks lordship. Both the marks we combine and select the best of the best candidate lordship. And what is their lordship? The basic syllabus lordship may kindly note it, mark it. Basic syllabus for the innovative writing technology, skill proficiency test will be follows lordship. Ability to articulate and communicate the course objective, learning objective in a manner that attracts the student with effective example and appropriate and real life example lordship. What is the difficulties here lordship? Is it foreign lordship? It is not a foreign concept lordship. They are doing this job. They are already teaching. They are already in the contextual basis. They are only tasked with the student. It should be more benefited to them. It's not a foreign concept lordship. Then lordship, awareness of the candidate about outcome-based education, value-based education, reciprocal relationship of values and domain knowledge, multidisciplinary and holistic education, critical thinking skill, system thinking skill, 21st century skills and skills of sustainability. What is wrong, lordship? It's not a foreign concept. Now, lordship, government of India is going to modernize the whole education system, lordship, in a one roof, lordship. It's not that, lordship, we are going to by crossing any other way, lordship. It's not a new concept, lordship. Ability to organize lesson plans in a structured manner and depicting the logical sequence and relationship of course content in the lesson plans. It is necessary in day-to-day life, lordship. Even when I am standing before honorable court, Lordship, I also fulfill this one, Lordship. Without this, I cannot submit anything before my Lord. It's a day-to-day activity, Lordship. Even our house also, we can follow it, Lordship. Ability to organize a lesson plan. It does not mean that, Lordship, only the books, we have to do certain things, Lordship. In a PPS on the case also, Lordship, we have to, it should be structured. How I am present the case before honorable court, and what kind of things I have to submit before the honorable court. It's a presence of mind, Lordship. It should be required in day-to-day life, Lordship. Ability to connect the previous and future lessons and providing recap of the previous lesson. What is wrong, Lordship? It's a necessary for every student's, Lordship. It's a duty of the teachers, Lordship. What lessons he have taught yesterday, and today what lessons he will be teach, and what is the relationship between the two lessons, and what is the outcome of the two lessons. It's a, Lordship, process for develop the education system, for develop the students community, for develop the teachers community also, Lordship. It will give the best of the best student and best of the best teacher, Lordship. If we can organize all these things, Lordship. In previous day, Lordship says hear it. If Lordship does not note down it, it did not note down it, or we also did not note down the point which was raised by my senior sir, even which query put by the honorable court, then how we can recollect it, Lordship? And why, how we can, Lordship, adjust it, and how we can, Lordship, to the deliver the, Lordship can deliver, Lordship will deliver the judgment. We will advance our argument. It should be connected, Lordship. Yesterday I submit before Lordship other things. Today I submit a different thing. It will be not, Lordship. It will be not homogeneous, Lordship. Equilibrium should be maintained, Lordship. There should be equilibrium, Lordship. What should be the equilibrium, Lordship? Equilibrium, the lessons which was taught earlier day, and the lesson which will be taught in the future day, Lordship. There should be some equilibrium should be maintained, Lordship. It is not a new concept, Lordship. That concept is, Lordship, from the 19th century also, Lord. It's going on. In the earlier days also, when the tool system is there, that system is, in that time also that system is there, Lordship. It's not a new concept, it's not a foreign concept, Lordship. It's a Indian concept, it's a, Lordship, not a new concept. It's necessary, Lordship. Then, Lordship, ability to formulate question, to measure student understanding in ongoing lesson as home assignment, class test, income examination, Lordship. What is wrong, Lordship? Is there any new concept we have inputted? We not inputted any new concept, Lordship. It's to measure student undertaking the ongoing lesson. That teachers who taught the lesson, he should formulate some questions. As Lordship has asked some questions, then what is this? Where is this? Lordship has just pointed out in which space you find it, from where you got it. Exactly the same issue, Lordship. It's the teacher's duty. After he taught the particular lessons, whether the students have followed it or not, whether students are only sitting or sleeping, only listening, it's the duty of the teachers. By way of this, there should be a connection, and they have a bond between the teachers and students, Lordship. It is not a, Lordship, that we are introducing, Lordship, the foreign concept, Lordship. By this, Lordship, the student will be more active, Lordship. The student thought the last night that tomorrow my teacher will ask such type of questions. So he will go to the table, Lordship. He will go to the table and read the book, Lordship. For that purpose, Lordship, that is their, Lordship. What is the difficulty for the Lordship, the prospective candidate? Then, Lordship, ability to evaluate the performance of the students and maintaining equity, Lordship. Teachers have to some quality, Lordship. They have to some quality to upgrade the students, Lordship, who are not in advanced stage, Lordship, who are not equipped with the, Lordship, that technique, modern technique, and other things, Lordship. It is the duty of the teachers, Lordship. We have to evaluate the performance between the teachers, between the students, Lordship, and how they have progressed, Lordship, day to day. It's not a, Lordship, course of, Lordship, general, Lordship. Yes, it's a, Lordship, engineering course, Lordship. It's a polytechnic institution. It's an engineering institution. They are the future builder of our state. They are the future architect of our state, Lordship. So, Lordship, they should be, Lordship, well equipped with all advanced ability to communicate to the teachers as a guide or facilitator and not the main source of knowledge and demonstrating empty of the teacher. What is wrong, Lordship? This is the process. A teachers and students friendly relation, Lordship. They should maintain a relation not as a teacher, as a student. They should as a friend, Lordship. That this student should ask the question without any hesitation. And it is the, Lordship, technique of the teacher, how to, Lordship, maintain that relation, Lordship. It is not that, Lordship, we have introduced anything, Lordship, which is not permissible, Lordship. Anybody can say that, Lordship, this is a, Lordship, wrong concept. Then, Lordship, ability to create an environment where the students are comfortable in his class, is not hesitate for open discussion relating to the topic of real life situation, promoting inclusiveness among the students, Lordship. This is the modern concept, Lordship. Teachers, students relations, and they should have know everything, what is going on surrounding us, Lordship. And without any hesitation, Lordship, they can, Lordship, exchange their views, Lordship. It is not a new concept, Lordship. It's a real life concept. Even our house also, with my children, I can discuss what is the problem he found today and what will be his plan today. This is the discussion, Lordship. Then demonstrating self-assessment, indicating the ownership and control of his own professional goal till that, Lordship. And this is already attained by the petitioners, Lordship. There is not a new concept, it is not a wrong concept, Lordship. Ability to formulate anonymous feedback from students as an opinion about the teacher's performance, Lordship. Today is a modern day, Lordship. We are living in a modern country, Lordship. Earlier days are gone, Lordship. Earlier Gurukul system is there. Now, Lordship, the modern system is there, Lordship. The student also assess the teachers, Lordship, how they are performing. And whether they are performing up to the standards which should be required for the student or not, Lordship. We appoint a teacher, Lordship. If he is not able to teach the student, what is the benefit of the student community? And student can assess his performance, Lordship. Student can say that particular teacher says not doing well. And so someone may be replaced or he should be developing. Performance, today's, Lordship, everyday performance is, Lordship, counted. In even everywhere. Even, Lordship, our judiciary also, Lordship. On the basis of the performance, integrity and other things, Lordship. Everything is done, Lordship. Without proper performance, Lordship, we cannot, Lordship. We can appoint hundreds of teachers, Lordship. If they are not performing well, they are not given the materials, they are not at the desired up-to-date marks, Lordship. What is the benefit of appointing the teachers? Why government invest huge amount of money to appointing the teachers, lecturers in engineering college for production of our future, Lordship? Not destruction of our future, Lordship. For production of our future, Lordship, we need best of the best teachers, Lordship. That's why, Lordship, this is formulated by the government, Lordship. For selecting the best of the best candidate, there is no bar, Lordship. After going through it, Lordship, my Lord may find anything which is adverse to anybody, Lordship. In my view, Lordship, it is not adverse, Lordship. It is not arbitrary, Lordship. It is not illegal, Lordship. These things are needed in day-to-day our life, Lordship, not only teachers, Lordship. So, Lordship, this is formulated by the state to, Lordship, get the best of the best teachers, Lordship. It is not but everywhere, Lordship. AICT does not say that we cannot formulate, you cannot formulate to pick the best of the best candidate, Lordship. It is a competitive market, thousands are applicants there. Say 200 applicants also there, Lordship. We have to choose the best of the best candidate. For choosing the best of the best candidate, we have to formulate certain policies, certain guidelines, Lordship, certain modalities, Lordship.
Yes.
Regarding this, Lordship, state has power, Lordship. There is no any violation of statutory rules, Lordship. There is no any violation of the prescription prescribed by the regulatory authority, that is the AICT, Lordship. So, Lordship, we have not violated any provisions, Lordship, and this prescription, which is for the, Lordship, proficiency test, is a day-to-day life activities. It is not a new concept. It is not a foreign concept. It's required day-to-day life of teachers and students, even our lawyers also, Lordship. Although there is no any proficiency test in respect of lawyers when granting the license, Lordship, it is nowadays it is also required for us also, Lordship. In that respect, Lordship, they have said that we have borrowed it from two institutions, Lordship. In our affidavit, we have regarding this, another judgment also I will place, Lordship.
Yes.
2019 666 362, Lordship. Paragraph 9, Lordship. If my Lord permit, I can read it. Paragraph 9, internal page, Lordship, 366, Lordship. The essential qualification for appointment to a post are for the employer to decide, Lord. My Lord, may kindly mark it. The employer may prescribe additional or desirable qualification, including any grant of preference, Lord. It is the employer who is the best suited to decide the requirements of a candidate, must possess according to the need of the employer and nature of the work. It's sufficient, Lord. I will not advance further, Lord. Last, Honorable Court says that in this paragraph, in no case can the court, in the grave of judicial review, sit in the chair of appointing authority to decide what is the best of the employer to interpret the condition of advertisement contained to the plain language of the same rules. This is the findings of the Honorable Apex Court. This is the law laid down by the Honorable Apex Court. What is Honorable Apex Court says that it is the prerogative of the state, Lordship. It is the prerogative of the employer, Lordship. You have to decide, Lordship. It is the employer who is the best suited to decide the requirements of the candidate, must possess according to the needs of the employer and nature of the work, Lordship. Very specific, Lordship. The findings of the Honorable Court is. The law laid down by the Honorable Court is says that the employer can choose its own method, Lordship, to get the best of the best one, Lordship. Here also we have formulated the scheme for that purpose only, Lordship. in our affidavit, my lord, may regarding that particular annexure 66 in our affidavit, lordship.
Respondent for,
Respondent number 4, lordship. Deponent is 1 Durbojyoti Bora, lordship. My lord, may paragraph 4, 5, 6 to 13 I am relying, lordship. 4, 5, 6 to 13, lordship. Four, 5, 6 already in respect of lordship educational qualifications. Then lordship, finally come to page 4, paragraph 9, lordship. Paragraph 9 deals with this particular page 66, lordship, where the petitioner's contention is that it should be, lordship, from the particular two institute, lordship. That the statement made in paragraph 8 of the writ petition stoutly denied and disputed the deponent. In reply, deponent begs to state that NITTR are the Institute of Continuing Education like IITs, IISCs, and many other institutions. The NITTRs conduct numerous courses on fast-changing and emerging technologies for promotion of excellence in the technical education system and facilitating the in-service research to, my lord, may kindly mark in-service research to keep pace with the latest technological development, lordship. The variety of training of courses conducted by the NITTR Chandigarh is replicated in their calendar 2023-24. NITTRs also impart PG courses in engineering in addition to short-term courses. Next page, lordship. Thus describing the thesis proficiency, teaching proficiency test as the only subject of NTTR is a false and also aim for misleading the context, lordship. Participation in a specific number of any short-term training programs conducted by the NITTRs and other institutions of counting educations are considered for the purpose of movement of higher grade under the career advancement scheme in case of in-service teachers and others also professionals, so that the teachers once appointed keep continue updating themselves. So the mandate of NTTRs and other institutions of continuing education is all encompassing for promotion of excellence in the technical education system, not limited to the training on teaching proficiency as submitted by petitioner. The short-term courses, lordship, which was offered by that particular institute is for upgradation of movement, lordship, under the career advancement scheme, lordship. It is also in the ICT, lordship, for upgrade of stage 1 and stage 2, lordship. They should fulfill certain short-term courses also. Say 8 weeks duration training program is there, lordship. If that particular in-service candidate, lordship, done that short-term courses, lordship, then it's upgrade the moment, lordship. It is not that, lordship, it's a mandatory requirement to, lordship, they have to go there, lordship. It's for own purpose, lordship, not the purpose of the institution, lordship. It's for benefit of the particular teachers, lordship. Say I am appointed as a professor, teachers in the engineering college, lordship. If I have not done that particular short-term courses, lordship, my increment will be not there, my upgradation will be not there, lordship. I cannot go for upward movement, lordship. If I done that particular short-term courses, I will get a certificate that so and so is completed the 8 week short-term courses. When the CS promotion is going on, it will be placed before the DPC. Departmental promotion committee will consider, lordship, whether that particular course is as per the ICT notification or not. The institution from where that particular course is done by the in-service candidate is affiliated to the ICT or not, or recognized by the ICT or not. If all the conditions are fulfilled, lordship, then the short-term courses certificate, which is obtained by the in-service candidate, then it will be helpful for upward movement, lordship. It is not that they conduct proficiency test, lordship. It's a misconception, lordship, and misrepresentation before the Honorable Court also. Paragraph 10, lordship. Paragraph 9 of the writ petition. We stoutly denied the dispute by deponent. In reply, a deponent begs to state that syllabus of the teaching proficiency test as a subject of NBI is again false and misleading as described by the writ petitioner. National Board of Accreditors conduct evaluation of programs such as civil, mechanical, electrical, engineering, etc. based on the SARC self-assessment report of the institution. My lord, may kindly mark it's a self-assessment statement of the institution, lordship. Seeking accreditation of National Board, lordship. Say, lordship, in respect of lordship, general colleges, NEC is there, lordship. And in case of engineering institute, there is an NBA, lordship. They have provide grade, lordship. Grade A plus, grade B, grade C, A plus, lordship. For that purpose, the particular institution has to submit the as per the format prescribed by the NBA, lordship. The teachers and students' performance also they should include it. What is the qualification of the teachers, how they have performed, all the 360-degree evaluation system is there, lordship. The 360-degree evaluation system, the teacher's performance has to be given. Then is the accreditation of the NBA, lordship. They have given the lordship certificate status, say A plus grade, lordship. That is the duty of the NBA, lordship. The writ petitioner have last 5 lines, lordship. The writ petitioners have annexed a format of SAR that includes but not limited to the institutional vision, mission, and objective institutional governance, infrastructural facilities, quality of teaching and learning curriculum, design and review, support like library, laboratory, instrumentation, computer facilities, etc. Therefore, Annexure 5 of the writ petition is not a syllabus of the NBA relating to teaching proficiency test, that the purpose of self-assessment report of an institution is not only focused on the examination on subject like teaching proficiency, but the holistic approach of the concerned institution, lordship. For accreditation of programs of institutions are means but not the ends, lordship. The ends are the quality of education imparted to students for teaching presidency in terms of the attributes as given in the form of syllabus for convenience of the candidates are extremely required and relevant. The examination scheme to measure the relative teaching proficiency of the teachers to be selected can be considered as an innovative way of selection of better teachers, and its implementation will certainly help the imparting quality technical education. That is the object, lordship. That is the object of the proficiency test, lordship. Already lordship has gone for the what should be the condition of proficiency test, lordship. Then lordship 12. The deponent begs to state that the present scheme of examination, OMR MQ-based written examination test has been adopted to avoid the difficulty to select the candidate based on the academic records due to the different marking patterns among various universities, central universities, private universities, government and private engineering college, IITs, NITs, etc. Especially for the entry-level posts like teacher in polytechnic and assistant professor in engineering colleges and senior instructor in polytechnic engineering colleges. Therefore, it has been decided to measure the domain knowledge of the candidate based on written tests on a common syllabus in relevant discipline to bring all the candidates at par and maintaining equality in case of entry-level post of lecturer in polytechnic, assistant professor in engineering colleges, senior instructor in polytechnic and engineering colleges, lordship. That is the main object, lordship. For persons aspiring to take up teaching professions in the elementary level, taking diploma in elementary education, DELED, as a mandatory requirement in addition to the domain knowledge and qualification of senior secondary or equivalent, is also based such principles on the lordship. Why, lordship, BEd degree is required? Why DELED degree is required? It is one kind of lordship. Even lordship, go to the syllabus of the BEd and DELED, lordship. Lordship will get all these things, lordship, which we have included in the proficiency test, lordship. If my lord peruse the syllabus of the BEd and DELED also, everything will be given, lordship. That is the basic, lordship. Then, lordship, similarly, making BTA or BEd is compulsory professional qualification among the educational qualification, such as MA, MSc in domain knowledge for PG teachers in provincial high secondary school justify the scheme of relative measurement of teaching proficiency of the candidate aspiring to become teachers of polytechnic and engineering colleges, Lordship. Therefore, Lordship, a teaching proficiency test criteria include in the above mentioned advertisement as declared in the said advertisement, the modalities of teaching proficiency test were published in notification dated so and so. Lordship, 75% from the test on domain knowledge and 25% teaching proficiency test and no marks for interview, Lordship. It's already there, Lordship. The distribution of marks 75% and 25% of marks. The reason behind this, Lordship, we have to source the best candidate, Lordship. That is the reason. Young Lordship, paragraph 13. The deponent begs to state that it is desirable that an expert or specialist need to be abundantly clear about why the expert knowledge of course are taught, their context in practical life, society, and industry, providing the social, economic, and environmental importance, the values and skill of perspective that the course intend to impart to solve the complex multidisciplinary problems of the society, and producing value-driven expert with attributes of critical thinking and system thinking skill of 21st century skill to promote sustainable development laws. The other targets of teaching proficiency test, such as the ability to maintain logical sequence in relationship of course contents and lesson plans by providing recap of the previous lessons, Lordship, demonstrating empty and prompting in inquisitiveness and participation of students, just evaluation of the performance of students, demonstrating the self-assessment of the teachers, and formulating the anonymous feedback from the students, etc., will promote a system of selection process for the most suitable teachers to promote equity education, which is consistent with the vision of National Education Policy 2020. Lordship. This is the main object, Lordship, why State of Assam has introduced the proficiency test, Lordship. And it is not an arbitrary, Lordship, not an illegal, Lordship. We never deprive anybody, Lordship. It is for all the intending candidates, Lordship. They are in advanced footing because they are already in the teaching job. New entry will face some difficulties, but they will not face difficulties regarding the syllabus which is contained in the teaching proficiency test. So, Lordship, this test is for selecting the best of the best candidate, which is permissible as per Honorable Apex Court judgment of the law. As because, Lordship, there is no indication, there is no guidelines, there is no policy, there is no formulation from the IICT, Lordship, how to select it. So, we can select it by adopting a scientific procedure, Lordship. We have to engage the teachers, engineering and polytechnic colleges, Lordship. So, we have prescribed that particular test should be required to select the candidate list. There is no any violation. It's as per consonant of the judgment provided by the Apex Court. We can do it, Lordship. And by proficiency test, Lordship, we are not deviated, we are not, Lordship, distinguish anybody, Lordship. All are at par, Lordship. The candidates have to, Lordship, appear both the tests. What is the difficulty? If the first test is not appeared, second test is already not permissible, Lordship. And one point is also raised by my senior sir, that, Lordship, we have changed the policies, Lordship. We have never changed it. So, Lordship, may kindly peruse the advertisement once again, Lordship. Page 24, Lordship, relevant portion, Lordship.
Yes.
That is the, Lordship, two parts, OMR based and proficiency test is there, Lordship. Next page is there, Lordship. Necessary guidelines, instructions relating to OMR MQ based examinations and teaching proficiency test will be notified. Website, Lordship. That notification is there, Lordship, in page 66. We are not debating, Lordship. They have only says that all aspiring candidates will have to appear both the test day. They have said that it's a saints lordship. It is not a saints lordship. If lordship the first one you not qualified, then you cannot appear it lordship. And we have to select the candidate from the marks they obtained the both of the test. We are not saying that in the advertisement. We are nowhere says that the marks which was written in the first 75% of marks lordship, we will not edit the final select list. Nowhere we have stated. Nowhere we have said lordship. It's as per the advertisement lordship. They have participated, they have filled up their form as per the advertisement. They are bound by the conditions and guidelines laid down in the advertisement. The golden law principles laid down by the Nasir Ahmed case lordship, that will applicable here. Nasir Ahmed case lordship. There is no deviation lordship. They have only says that we have said that the candidates, shortlisted candidate will be called. We says that lordship will now determine from both the tested lordship. Shortlisted candidate will call, it does not mean that lordship we are not to add the marks lordship. Nowhere says that lordship. It is not a change of game lordship. Even also lordship, Honorable Apex Court says that in the midterm also the procedure for interview can change by the authority lordship. If they are not changing the minimum required qualification marks, then it is not to be treated as lordship, change of rule of game lordship. It is the recent one judgment of the Honorable Apex Court. Honorable Apex Court clarified that if the procedure for the interview changes, then it will not amount the change of game lordship. If authority change the qualification, then it will be among the change of game. Here there is nothing is there lordship. Suppose lordship for a timing lordship assume that we have changed the procedure. Then also it's not amount to change of game. Then also it's not amount to violation of the advertisement lordship. It's a monopatra lordship, mono SC, mono SC 15992022 lordship. The state of Uttar Pradesh versus Purnesh Kumar and others lordship.
Yes.
It is reported lordship. It is reported in reported. It is reported in AR 2023 SC 52 lordship. It is reported judgment lordship. Paragraph 32 lordship. The respondents have also placed reliance on the decision of the court in the case of K. Manzoor. However, in our considered view, the fact of the approach decision are quite different from the present case. As change was introduced for the first time after the entire process was over, based on the decision made by the full court for the cutoff. Secondly, it is not as if the private respondents were non-suited from participating in the recruitment process. The principle governing changing the rule of game would not have any application when the change is in respect to the selection process, but not the qualification of eligibility lot. Here lordship, in our advertisement lordship, in our proficiency test also lordship, there is no change in the qualification part lordship. Even other things also not changes lordship. We are allowed all the candidates to appear at proficiency test. What is wrong lordship? Earlier says that only shortlisted candidate will be called. All the candidates are qualified, Lordship. All the candidates are shortlisted. Lord. All the candidates are qualified in the written exam, Lordship. So all will participate. Even, Lordship, suppose, Lordship, in the midway we says that so and so part will be taken for procedure. Procedural aspect, Lordship. Then also it not amount to change of the game, Lordship. We have never changed the qualification part, Lordship. We have never diluted the ICT specified qualification, Lordship. Everything is there, Lordship. We not add anything also. Experience is not required as per the ICT notification. So that was not in the prescription of our advertisement, Lordship. If ICT says that in entry level experience part is required, then it is bound by the state authority to follow the ICT. ICT minimum qualification is very specific. Only the educational qualification, not the experience. Experience is required, Lordship, only from the stage of 11, level 11, Lordship. It's a level 9 and 10, Lordship. There is no any sense, even procedural also, Lordship. Even, Lordship, suppose that procedural sense is also there, Lordship. Then it's not amount to sense of the game, Lordship. It is the law laid down by the Honorable Apex Court. It is the law of the land, Lordship. And one judgment was, Lordship, order was placed before my Lord in respect of WPC 1490/23. Petitioner has placed one judgment death till one order death Lordship. Regarding experience part, Lordship. Dara, itu. Yes. There was 6 Kashyap and 6 others, Lordship. My seniors are say given, Lordship, last 2 days. You can, Lordship, may take it. I can just. Dara, correct, Lord.
I think I have.
One paragraph, Lordship, may kindly take it.
Yes, 1493.
1490. That is not applicable here, Lordship. Regarding the experience part, other things, Lordship. In internal page, Lordship 6, paragraph 3, Lordship. It's, Lordship, in respect of provincialized colleges, Lordship. Already that notification, various occasions, Lordship has gone through it. It is not in respect of, Lordship, engineering colleges. That prescription is there in the UGC itself, Lordship. UGC itself, there is an experience part, Lordship. UGC itself, there is a district that is there, Lordship. In consonant to the UGC's notification, Lordship, the government office memorandum was issued, Lordship. That was, Lordship, in respect of general colleges, Lordship. Yes, that prescription was there in the UGC, Lordship. Here, AICT nowhere prescribed that particular prescription, that entry level, one of the required qualification should be counting of past service. So, Lordship, this is not applicable. Even the honorable, that particular order was also considered by the authority and it was negated by the authority, Lordship. Just another 2 judgment regarding state power to quality of excellence of education. I have placed it. Next. I'll conclude. Lordship. Another within 5 minutes, I will conclude. Lordship. This is 2004 for SCC 51C, Lordship. Paragraph 9 and 10, Lordship, I am relying.
Yes.
Paragraph 9, Lordship. From middle, Lordship, line 8 line from middle, I will start just relevant portion, Lordship. It start from therefore, Lordship. Therefore, what is to be seen in the present case is whether the prescription of standards made by the state government is in any way adverse to or lower than the standard fixed by the ICT. It is no doubt true that ICT prescribed 2 modes of admission. In one is merely dependent on the qualifying examination, and other depends upon the marks obtained in the common entrance test. The application of the present case prescribed the qualification of having secured certain percentage of marks in the related subject, which is higher than the minimum the qualifying maximum examination in other the eligible admission. In higher minimum is prescribed by the state government, then what has been prescribed by the ICT, can it be said that it is any manner adverse the standards fixed by the ICT, reduce the standard fixed by the ICT? That was the moot question posed by the Honorable Apex Court while deciding the issue, Lordship, where state has, Lordship, some additional criteria is given in that regard. Then, Lordship, the view of the Honorable Apex Court is, in our opinion, it does not, Lordship. On the other hand, if we proceed on the basis of the norms fixed by the ICT, would allow admission only on the basis of the marks obtained in the qualifying examination, additional tests made by applicable the common entrance test by the state government. If we proceed to take the standard fixed by the ICT to be common entrance test, then the prescription made by state having obtained certain marks higher than the minimum of the qualifying examination in order to eligible participate in the common entrance test in the addition to the common entrance test. In either event, the stream proposed by ICT are not battled in any manner, Lordship. So, Lordship, even if state can add, Lordship, something more than what is prescribed by the ICT, then as per the opinion of the Honorable Court, that it does not violate, it does not derogate, it does not lower the prescription prescribed by the ICT, Lordship. Here in our case, Lordship, the ICT, Lordship, given certain norms, and we have already adopted that norms. We have prescribed that prescription, Lordship. In addition, while selecting the candidate, as there is no mode given by the ICT, Lordship, we have innovative idea, Lordship, for selecting best of the best candidate, Lordship. It's not a violation of the ICT's notification. Then also there, I will not go through it, Lordship. Then another judgment is there, Lordship. 2021 to SCC 564, Lordship.
Yes.
Paragraph 47, Lordship. Paragraph 47, Lordship. Internal page 586, Lordship. I will just reiterate it in the last 3 lines, Lordship. It is a, Lordship, findings of the quotation of the findings of the Honorable Apex Court in Visweswar Technology University's case, Lordship, which was included here, Lordship. It is there, Lordship, prescribing higher standards for admission by laying down qualification in addition to the higher than those prescribed by the ICT, consistent to the object of promoting higher standards of excellence in higher education, will not be considered as adversely affecting the standards laid down by the central body ICT, Lordship. Then, Lordship, next page. Roman 3, Lordship. The fact that there are unfilled seats in the particular year does not mean that in that year the eligibility criteria fixed by the state university would cease to apply, or that the minimum eligibility criteria suggested by the ICT alone would apply. Unless and until the state or university suggests to modify the eligibility criteria fixed by them, they will continue to apply in spite of the fact that there are vacancies or unfilled seats in the air. The main object for prescribing eligibility criteria is not to ensure that all seats of the college are filled. Malama, kindly mark that line. But to ensure the excellence of standards of higher education is maintained. Here is also our objective, Lordship, to select best of the best candidate for excellence and standards of the educational institution, more particularly the Polytechnic Institution and Engineering College in the state of Assam. Lord. Then Lordship 58.
Para.
Para 58 Lordship, last page Lordship 590.
Yes.
In such circumstances, we are of the considered view that the view taken by the Kerala High Court in paras so and so to imping judgment on the issue is unsustainable at the cost of repetition. My lord may kindly mark it. We point out that while universities cannot dilute the standards prescribed by the ICT, they certainly have the power to stipulate enhanced norm and standards. Lordship. Here, Lordship, we are not diluting the prescription prescribed by the ICT, Lordship. We are at par ICT, Lordship. Nowhere we have violated the prescription prescribed by the regulatory authority, Lordship. The post is for entry level 9A and 910. Sorry, 9A and Lordship level 10, Lordship. 9A specific qualification is prescribed by the ICT. We have given them. And 10 also specific qualification that is their Lordship. Nowhere experienced parties there, Lordship. Nowhere they have stipulated certain conditions to formulating certain procedure for recruitment, Lordship. It is left to the employer, Lordship. And employer has the authority, Lordship, to select best of the best one by adopting the scientific procedure. And the Lordship proficiency skill test, which was, it's a day-to-day life activities, Lordship. It is very much needed to the teachers. Who should be teachers? Who will be the teachers? So, Lordship, I sum up with that, Lordship. There is no any violation of the AICT's regulations. Experience is not required. AICT never prescribe anywhere. An entry-level experience is required, Lordship. And Lordship, we are not diluted. We are not deviated from that, Lordship. There is no sense of the game, Lordship. Even Honorable Apex Court permitted that in the midway we can change the procedure also. That was also not changed. If procedure also changes, it is not amount to change of the game. Only if we change the qualification, that is amount to change of the game, Lordship. So, Lordship, the annexures which was included here is, Lordship, not violation of the any notification guidelines issued by the ICT. It is for the employer to decide, Lordship, as because there is no procedure was given by the ICT. This is my submission, Lordship. Oblige, Lordship.
I have to give a reply. My lord, I think all my learned friends are sitting.
Yes.
There are some motions, so I do not have trouble. So it will take about 30 minutes, 35, because some judgments he has cited. I have gone through the judgment. I have to distinguish the judgment is not at all applicable in this case. I am thankful to my learned friend that he has shown entry level 9, 10, 11. Now I found what is 11 and what is 12. There's nothing to do with that. It is a promotion. I'll tell you, I'll submit, but my learned friends are waiting. So, Your Lordship, I'll humbly request Your Lordship, let it be on Tuesday at 2 o'clock because that's a hearing day, my lord. Motion day always finds it difficult for Your Lordship. At 2 o'clock, if it is not inconvenient, my lord. Tuesday is a hearing day.
Who appears for the state? Government?
I can do it on Monday, my lord, but I think again they have to. Oh, huh? Tuesday, 2 o'clock. Huh? Aso. Well, the judgment I have seen, my lord, but it will take some time. In the meantime, it will be 4:30. All my learned friends are waiting. So on Tuesday at 2 o'clock. 2 p.m. Deeply, no more.
My lord, I am obliged to my learned friend, Mr. Das. That I have an unlisted matter, if your lordship can take it. My lord, I'll just take 5 minutes time.
Yes.
Your lordship will find your petitioner was appointed way back on 1994 as a demonstrator in the biology on ad hoc basis. Ultimately, my lord, it was done all through process of selection and all that. My lord, even after 30 years, her services has not been regularized. Now what happened? They are trying to give this particular job of teachers to the contractor. My lord, I will take your lordship to that. Your lordship may kindly come to page 53.
Yes.
This is the letter from the authority for administrative conveyance. Now, she has been, my lord, given the charge of principal in charge. Your lordship may skip this. Then page 54. This is the letter to the principal from the management. Engagement of teachers of so-and-so higher secondary school. Dear madam, as per management direction and discussion with your good self, it is to inform you that the following teachers working on ad hoc contractual basis has been engaged under DJ engineering with effect from so-and-so by superseding the engagement orders issued earlier to the respective teachers. Now, your lordship, kindly see the next page at page 56. 56 and 57. These are the 27 teachers, those someone is ad hoc basis and contractual basis. Now they are trying to give it to the, my lord, these teachers to the hand of the contractor.
What is this? I don't understand.
My lord, these teachers were appointed from 1994
That I got it.
and different dates. Now your lordship will find
They were appointed by whom?
appointed by the school authority. This, my lord, Brahmaputra Valley Fertilizer Corporation Limited Higher Secondary School. Now they appointed them after the proper selection. Now, instead of, my lord, we have been trying to get our services to be regularized, but they're avoiding. Now, all of a sudden, my lord, your lordship has seen this letter 24/5/2023 at page 54. Addressed to the principal. They are saying engagement of teachers by so-and-so as per management direction and discussion with your good self. It is to inform you that the following teachers working on ad hoc contractual basis has been engaged under Messrs. DJ Engineering. My lord, these are the contractors. My lord, now they will take they will engage these teachers through contractual basis, through the contractor. Now, this can be done those laborers only. Those skilled labor, unskilled labor, manual labor, all these things. Now, the appeals court, I'll take your lordship to that decision. Time and again, I say the teachers cannot be construed to be unskilled or semi-skilled, whatever it is. They are doing the special job. They are doing the huge task to the society. So, therefore, they cannot be construed to be a workman. Now, your lordship will find at page 56 and 57. They are the 27 these teachers. Then, my lord, I will take your lordship to page 60.
Yes.
The dated 25/2023. Engagement of 35 numbers, skill, then some semi-skill, so and so, so and so. This one also your lordship can skip. Then I will take your lordship to the NIT at page 67. Notice inviting tender dated 29/5/2023. Online tender under 2-bid system, technochemical bid and price bid are invited from the reputed agencies, companies, contractors, firm for the supply of 200 numbers of unskilled, 123 numbers listed unskilled, 19 numbers semi-skilled, and 51 numbers skilled laborer. Now, these 51 skilled laborer your lordship will get at page 86. The chart given by them. Page 86, your lordship will find a list. I'll take your lordship to column 18, serial number 18. Your lordship will find school. Now there they are showing unskilled workers 7 and semi-skilled 28.
Skilled.
My lord. Skilled worker, yes, skilled worker 28. Now the total for with taking into different department, it comes 51. Now I will take your lordship to what the appeals court has said.
Oh, this NIT is for supply of workers.
Supply of workers, including teachers. Now, whether teachers come under this, that's the question before your lordship. Our, my lord, prayer would be, your lordship will find there are different department at page 86. MH, HR, electrical, instrumental, we are not for all those. We're only serial number 18 in regard to school teachers marked as skilled worker. Now, whether skilled worker comes within the purview of workmen, your lordship will find in a decision of appeals court. My lord, I will read just paragraph 10 and 11. Paragraph 10, your lordship, pennies. The court held that the employee Mukherjee involved in that case was not a workman under section 2S of the Industrial Dispute Act because he was not mainly employed to do any skilled or unskilled manual or clerical for hire or reward, which were the only two classes of employees who qualified for being treated as workmen under the definition of the expression workmen in the Act. Then your lordship come in the middle part. Imparting of education from there. Imparting of education, which is the main function of teachers, cannot be considered as skilled or unskilled manual work or supervisory work or technical work or clerical work. Imparting of education is in the nature of a mission or a novel vocation. A teacher educates children, he molds their character, builds up their personality and makes them fit to become responsible citizens. Children grow under the care of teachers. The clerical work, if any, they may do is only incidental to their principal work of teaching. We agree with the reasons given by the High Court for taking the view that teachers cannot be treated as workmen as defined under the Act. It is not possible to accept the suggestion that having regard to the object of the Act, all employees in an industry except those falling under the 4 exception 1 to 4 of section 2S of the Act should be treated as workmen. The acceptance of this argument will render the words to do any skilled or unskilled manual, supervisory, technical or clerical work meaningless. A liberal construction as suggested would have been possible only in the absence of these words. The decision is Man Baker India Limited versus Workmen precludes us from taking such a view. We therefore hold that the High Court was right in holding the appellant was not a workman, though the school was an industry in view of the definition of workman as it now stands. Therefore, my lord, so far, supply of workmen, supply of labor, that will be in regard to the industry. Now, the departments, they are having different departments, but not so far school is concerned. Because if they can be constituted to be workmen, you can supply. The teachers cannot be constituted to be workmen. And how the contractor is, my lord, efficient to supply the eligible teachers. So therefore, to that extent also, my lord, my prayer would be to stay this NIT. So far, serial number 18 is concerned, where it is reflected that they want skilled worker at page 86. instead of regulation of our services, they are trying
It's a
to.
continuation of this NIT, page 86.
Yes, continuation, my lord. Dated, Your Lordship will find dated 29/5/2023.
Yes. Who appears? No one.
My lord, I don't think they have any standing counsel.
You'll have to take.
Yes.
Union of India is there.
Union of India is there, but we have sought the copy. None appears to be there.
Gogoi. You can appear for the Union of India.
I can.
Appear who you?
Number one.
I can.
Department of Fertilizers, Ministry of Chemical and Fertilizers.
I can.
But Mr. S. Datta. Then the senior counsel assisted by,
As the
he also has Datta. S. Datta. Then the counsel-
Legacy.
the counsel for the petitioners. Is it petitioners or petitioner
Petitioner, my lord.
for the petition? Issue notice. Mr. K. Google and the CGC. Appears on behalf of respond number 1. Petitioner to take steps for service of notice on the respondents 2 to
My
Seven.
lord. Yes, 2 to 7.
by registered post ID within a period of 1 week,
My lord.
1 week from today. List the matter up to 4 weeks. In the interim, comma, the notice inviting tender issued by dated 29/5/2023. Issued by Brahmaputra Valley Fertilizer Corporation Limited, correct?
Yes,
Is it Namrup or Kamrup?
Namrup. My lord.
Namrup shall remain suspended. And so far as it concerns serial number 8 within bracket school. That should do.
So for school,
Serial number
under
8
skill level worker,
Serial number 18 within bracket school.
in regard to skilled worker. It
How about,
28,
how about unskilled?
28 skilled worker.
And so far shall remain suspended with regard to serial number 18 within bracket school. Insofar as it relates to 28 skilled workers.
Right.
Till the next written.
I pay for a copy of the petition.
Yes, yes. definitely.
You have not been served. I think you have been served a copy.
Yes, already we have served that. Possibly my learned friend is.
It is a unlisted Is a unlisted matter, so let's say officers not.
Well, at my lord, I'll give it to him. Much obliged.
14, motion.
Lordship. UGC Council, University Council has come, Lordship. It may have taken 18, 19, 20 time being.
It will be difficult now. There's no time. I have a lot of other cases. We can fix a different date. Fukan, where were you?
Milord. UGC Council has come, Lordship, now. Lordship already heard the matter, Lordship. Only Lordship, his presence is required. Lordship has already heard the matter and make it harder. Regarding B.Ed degree, Lordship, the inspector of schools report and the
This is item. 1 minute. Item 14.
report.
14,
May I please, your lordship, the engaged counsel, Miss K Devi, is left the court earlier, some personal difficulties, so matter may be adjourned for the day, lordship.
On request made on behalf of the council for petition, Miss Dr. 1 week.
Deeply obliged.
18, 19, 20.
Lordship, kindly, see, WPC number 1026, Lordship. 1026, Lordship, remember everything. WPC number 1026.
Milord. Milord, regarding that attendance aspect, Milord. Milord, the college concerned, Tihu B.Ed College. Milord, they have normally, Milord, in the deciding, Milord, the authority regarding 80% or 70% like that, Milord. Milord, and degree has been awarded by the university. That part and the attendance part. Two separate aspects, Milord. We are not responsible for any, Milord, that 80% or 70%. If any doubtful attendance, Milord.
So far, the petitioners,
The private respondent is concerned.
Lordship will remember that he is a regular teacher of Boroma High Secondary School and he has undergone the B.Ed course. And as per order of this honorable court, inspector report was sought for by the Director of Education. Page 22 is the inspector's report. WPC number 1026, Lordship.
that I've seen.
Lordship. The inspector has specifically reported that as seen in the application, page 22, Lordship. That is, Lordship, in connection to the report submitted in connection to WPC number 337 of 2021, Srimati Anupama Devi, State of Assam. With reference to the subject cited above, I have the honor to furnish here with the detailed report along with the necessary document regarding B.Ed degree obtained by Bharat Chandra Talukdar for compliance of the Honorable High Court's order dated 12/3/2021, passed in the above brief petition number Iman. In this connection, it is mentionable that related documents in support of the obtaining B.Ed degree of SDP College of Teachers Education TU are seen and verified meticulously in addition to accepting statement in his presence in person at his office on Iman. In connection with the application dated Iman for permission for study higher education, it may be stated that no record is available receiving such application in this office as now, copy enclosed, Annexure 1. However, no forwarding letter from the school authority of such application regarding permission for B.Ed study was receiving by this office. As also seen, the application dated Iman enclosed Annexure 2 here, it was applied alone to the principal of Boroma High Secondary School, praying for permission to attend the practice teaching classes
I
of
think Inspector of Schools has to clarify this issue.
clarified, Lordship. And now,
Who
Lordship, is
appears for the,
He's already appeared, Lordship. He's on leave for now 7, Lordship, right now.
he has been hard, Lordship. He has already agreed that the speaking order may be set aside.
So he's on leave for now 7 right now.
Speaking order is page 23, Lordship. Speaking order said that the B.Ed degree obtained in evening classes. As per Lordship, the information by the college, it is a day shift college. Page 24.
yes.
Lordship want to set aside the order because they have said that it is evening classes. Again, Lordship, I am taking to page 22, Lordship.
Mr. Goswami, I think today we don't have time. I don't want to keep it CAV. I want to dictate in the courtroom. We'll fix a date next week and then we'll.
Tuesday.
Next Tuesday.
Next Tuesday.
Heard Mr. S.S. Goswami and the council. Also heard PG Fukan and the standing council Guwahati University. So, Mr. Matter, hanging on. Okay, 20 June.
Most probably. 22. Lordship, Tuesday, Lordship.
Yes.
Tuesday.
20.
20, Lordship. 20.
Follow.
66 of supplementary list.
May I please, my lord, the matter was, my lord, considered by my lord on the last day. But my friend, Mr. Gogoi, was not there. It's with regard to that pharmacy college. My lord. that we were given a.
My lord, on Tuesday or Thursday, it will take time.
Actually,
If possible, my lord, if he agrees, otherwise he can argue. Tuesday, hearing the, otherwise now it will take time.
Because my lord will have to
Yes,
pass an order, my lord. That's why it might take not much
because
time.
all the pleadings are complete, my lord, additional instructions have come.
Because
It is
my
ready
lord,
for
only
hearing.
urgency here is.
Additional instructions have come.
Oh, yeah.
Yes, here.
Pharmacy Council of India have received instruction, Lordship. As per my lord's direction, Pharmacy Council of India provided instruction, Lordship. I will place it the instruction, Lordship.
And the pharmacy council, my lord, has renewed my this permission, my lord, approval, my lord, for the current year, my lord.
On Thursday, my lord, but Tuesday or any day, my lord.
On a hearing day, my lord, if possible.
Thursday.
Or Tuesday, my lord, if not. other something.
Just check out how many cases are there on Tuesday. First, Mr. You can hire the senior counsel as to the.
MJ Kadir.
Also, Mr. B. Go. That's standing counsel.
Health department.
Is the matter on 20.
20, my lord.
Publish.
My lord, can I have the liberty to make a mention in the morning, my lord, in this matter? Provided, my lord, it's not inconvenient, my lord.
We'll see.
Lordship, much obliged.
41.
Lordship, here by order 2623. Planet Standing Council Secondary Education was directed to obtain instruction, my lord. Simple issue, my lord, here.
Maybe it's simple, but there's no time.
But my lord, this man since 2013, he is depriving from provincialization.
Who appears for secretary? There's nobody.
Lord, this man is now since 30 years he has served, my lord. The other have been provincialized in 2013. Only same ground again and again rejection, my lord. That is, my lord, page 89, 88, my lord, last rejection.
But Mr.
On Tuesday, my lord.
M.R. Kandahar.
My friend connected.
Chisti, you have any instructions in this matter? You asked to take instruction.
Yes, my friend informed me he has received, my lord.
Oh, you go, Sharma. Oh, Paul Sharma has received, I think.
He has received, my lord.
Let it come next week, Lordship. I'll inform him, Lordship.
Okay, on request made on behalf of U Sharma, then the standing council, secondary education. This is the matter after 1 week.
Yes.
My lord, any date, my lord, before date.
I can't take the date now, there's absolutely no time.
No time.
42.
It will observe that. In the meantime, my lord, may affidavit may file, my lord.
Yes.
Affidavit may file.
My lord, in this case, as per direction of the government, meeting was held for constitution new SMDC. Accordingly, a meeting was held and name of the petitioner and one other person has been recommended. But instead of doing so, my lord,
That order has been suspended.
suspended, but the loss of page 30 suspended, but they have been allowed to work, my lord.
Then you file a contempt.
It is, my lord, that may be observed and the loss
I'm
of
not observing anything. That is up to you.
but that notification not given to us, this is the problem.
Which-
We are file RTA applications, they are not furnishing any documents.
What
Yeah.
notification? What notification?
Another notification issued for allowing them to, that the full body has been formed. Including the respondent number 7 as a president and another person as vice president, as per page 33, my lord, and as a 5. They have been allowed to work.
That is up to you. You can, but Mr.
Jai Ahmed.
J. Ahmad, Learned Council for Petition. Chisti, you have any?
For secondary education, Lordship.
My APR. For the respondent 7, private APR.
Are
my
you
lord.
filing a counter?
Yes, I will file, Lordship. We have not received any instruction till that, Lordship.
On request made by SMT Chisti, Learned Council for the secondary education.
After vacation, Lordship.
This is the matter after 2 weeks. They never will file counter.
We have filed Okalatnama on
Question number 7.
on behalf of respondent number 6 and 7. But after
Mr.
No, he want to withdraw his Wakalatnama lawsuit,
I
that's
want
why.
to do my Wakalatnama.
You have to first give notice.
Yes, notice दी बिलत में हम petition file को बोलेगा.
Because that is why they are, instead of interim order, they are,
It's a matter of entry.
that may be given. Well.
No, I can't give a date.
43.
Wonderful.
Forty-two, no?
3.
Punyan,
My lord,
My lord, I am sorry, my lord, interim order may continue.
interim order is until further order.
My lord, time is very short, my lord. Only thing, my lord, is that this is a matter of provincialization, my lord. District committee has recommended me, but the director of secondary has not considered the, my lord, recommendation of the district level committee and refused my provincialization, my lord. My lord may take up on next week, my lord, can be disposed of, my lord, for a reconsideration of the district scrutiny committee's report, and they can pass a fresh order, my lord.
Well, the problem, I can't give a fixed date. Next week is all full.
Lord, I am without any salary, no, my lord, that's why, my lord.
We'll have it on the last week then.
My lord, after 26, my lord.
Start A.R. Buyan, learned counsel for the petitioner, also heard the assistant Chishti, learned standing counsel, secondary education. This matter, you know. 26.
My lord.
44.
Lord, in this petition, what has happened, my lord, the petitioner has been, my lord, charged with a criminal case. And while he was working as a, my lord, under the Sarva Shiksha Abhijan mission, and my lord, as a district program officer, Dhubri, an allegation has been brought, my lord, that I have charged some bribe from one of the teacher, and following which, my lord, I had also been arrested. Subsequently, I was enlarged on bail. And my lord, till date, the authorities neither placed me under suspension nor I have been allowed to continue. As a, my lord, my appointment is a contractual appointment. That is an admitted fact. Now, my lord, they have said that the rule of the Assam Service Discipline and Appeal Rules of 1964 is applicable for these categories of employees. Now, my lord, I was now without any salary, no payment is made to me, my lord. Though, my lord, I had been placed under, not under suspension, but deemed to be suspended, my lord. So, my lord,
SSA.
SSA is, my lord, Mr. B. Chaudhary last time appears, my lord. Mr. Bikram Chaudhary, my lord. My lord, may I pray that my subsistence allowance may kindly be given by the authorities, my lord, for my survival.
But you have not been suspended, isn't it?
No, my lord, I have not been suspended, but
Now,
as
how
I have,
can you direct,
my lord, under,
directing them to pay subsistence allowance or indirectly this court will be suspending
my
you?
lord, with my limited understanding, my lord, as I have been arrested, my lord, under Rule 6, Sub-Rule 2, deemed suspended, my lord. Though they have not issued any.
They have to issue an order.
Yes, my lord.
Who is supposed to issue the order?
My lord,
SSA.
the mission director, SSA, my lord.
Who is the mission director?
Bikram.
Yes, wherever he is.
Matter may be taken any other day, my lord.
Some urgency is there on next week, my lord. I have-
Monday, my lord.
But
That-
yeah,
my-
Buyan, then the counsel for the petitioner on request made on behalf of Mr. B. Chowdhury, then the standing counsel SSA. This matter on. Okay, 23rd.
My lord. Applies, my lord.
45.
My lord, in this case, there is an order regarding consideration of the interim play of the petitioner, my lord, on filing the affidavit by the respondent university, my lord. Since already, my lord, respondent university has already filed the affidavit, my lord, and since today is not possible, so let the matter come on Monday, my lord, regarding consideration of the interim order.
You have filed your,
On Monday, my lord.
On Monday, my lord.
we'll have it on Monday. Is quite. On request made of my Mr. K. Sinha.
Yes, my lord.
General Counsel.
I would have set out in the press.
19.
My lord, along with this, my lord, another repetition is there, my lord. That may be come along with this repetition, my lord. WPC number, I would ask now. My lord, WPC 411-2022. That may be along with this repetition.
Don't make it Monday. Monday, I don't think.
My lord, Monday, I think, my lord, my senior will not be available, my lord.
Let it be on Monday, my lord. We'll have
Monday,
a,
Monday will be difficult to get the first list. Already late.
otherwise, my
We'll
lord,
have it on 20.
20 তারিখ হবে না?
Hmm?
20 তারিখ,
this day.
20
Yeah, I think. Tuesday, for
Tuesday to 20 তারিখ হয়।
over there.
মানে 20 মেলো।
46 order
46 losses, we have complied with the order. I have given that just now the email. I think
Have you got
I have not aware, I'm not aware of it, madam. A copy to the,
solution or copy?
no, communication that order losses. Second phase losses.
Yes, you have been appointed.
Malad, I'm not aware, Malad, maybe Malad, since
It is
Malad is
very-
not placed in
only-
Malad.
Only on 9th June losses. That's why further he may not get the order losses, but.
Yes,
because
My
order-
client has not received, Malad, just half an hour I spoke to him, Malad, he has not received the order so far, Malad.
Because it was issued on 9th June only.
Oh, Malad, he has received, just inform he has received. Malad.
That's why Losses, he has
We'll
received.
proceed.
You can close.
Losses make plan close it.
Third, Mr. M. Dattal, Learned Counsel for the petition.
Okay.
Mr. SMT Chisti, Learned Counsel appearing for
1,
respondent,
3 and 5.
3 and 5,
1, 3 and 5.
as furnished an order dated 9 June 2023. Issued by the Director Elementary Education, Assam, whereby the petitioner has been appointed as a grade 4 within bracket Chowkidar and posted at Sai Bond MES under Hailakandi district. Stop. Considering the order
2 and
dated
3,
9
2 and 3, huh? 2 and 3, 2 and 4.
this court is of the considered opinion that
2 and 4.
respondents have already have complied with the orders passed by this court. Accordingly, contempt petition is
Look,
closed.
my friend, he is appeared for 2 and 4 losses
The
for
order-
finance.
Order dated 9 June.
Yes, only have for 2 and 4.
is placed on the court.
7
Mr. A. Chaliar, Learned Counsel, respondent.
2 and 4, Lordship.
Out of
Deeply Lordship.
47 lawsuit may kindly fix it on next week lawsuit. Is speaking order is almost about to issue lawsuit. That is the information that I did just few minutes back lawsuit. They are about to issue the speaking
order
order.
for all Learned Counsel with the petitioner.
Wednesday next lawsuit.
Made by Mr. SMT Chisti, Learned Counsel appearing on behalf of respondents. 1 and 2. Please connect on.
Madam, fix a date, my lord.
21st.
Fix a date, my lord.
Did
25
you hear what I said? Dutta? What this?
20, oblige.
48
48.
May please, my lords. As I appear for the contempt petitioners, my lords. This matter pertains to willful non-compliance of the order dated 17/11/2021. Notices were issued, my lords, 1 and 2 are
Here, Mr. Anjay Khatunia, he has received the call number today lawsuit. So earlier, my friend P. Sokopati was there, he has resigned, therefore, my lord, Khatunia will appear. Lawsuit may can fix it on next day. Let him file an call and take the instruction lawsuit. Mr. Anjay Khatunia, he will appear lawsuit.
prior to the vacations, my lords, if possible.
Heard, Mr.
B. Chaudhary, my lords.
E. Chowdhury, Learned Counsel. Request made on behalf of NG Khatania, Learned Counsel appearing for the
That respond number, I don't know, lawsuit, but he will appear lawsuit. I think. Huh? Hmm. I think for 2 lawsuits. Director.
Pritum Saikia.
Pritam Saikia, he is already retired lawsuit.
His respondent number 4 has been raised as a respondent.
For whom, huh?
Dr. Bijoya Chaudhary, my lord. There is an order, my lords, to that effect of
Sir,
6.
let it fix on next week, let him file a call number, then I will submit lawsuit.
Okay.
Yes.
On the request made on behalf of NG Khatania. Learned Counsel to the respondents.
Yes.
Wish the matter up to 1 week.
As may I pray for a date, my lords?
26th.
I'm deeply obliged.
49
Wait, legal lordship. Petitioner is a Hindi language teacher in upper primary school lordship. As per rule, at least three teacher from each subject from science, social studies, and language should liable to be provincialized. But by impugned order dated 4/2/2021, petitioner was not provincialized, but junior to petitioner are provincialized by impugned order dated 4/2/2021.
Then you'll have to file an appeal.
My lord,
Lord.
section 14 of the 17 Act, the petitioner may prefer appeal to the government, my lord.
Yes.
As per section 14, it can be disposed of like that.
Heard Mr. MS
Are
R. Deka, learned counsel for the petitioner. Also heard Mr.
And J. Supriya for response number 3 and 4. Standing counsel.
I'm for lordship 6 and 7.
1 minute. MS Sukan for standing counsel, elementary education for respondent, 1, 2,
1, 2, and 4, my lord.
4 more.
1, 2, and 4.
Yes, 1, my lord.
1 and 2, and Mr. J. Chutiel, then
Standing counsel, Karbi Anglong Autonomous Council for response number 3 and 4.
C for respondents, 3 and 4, and Mr.
PJ Dutta,
PJ Tatta, learned counsel for the respondents,
6 and 7.
6 and 7. Stop. Paragraph, okay, para. Where's your appointment order?
Lordship, Annexure 1, page 18 is joining report. Annexure 1, page 18.
The petitioner on being appointed as assistant teacher within brackets Hindi of Ujan Telehor MA School on 12/5/1994, joined to the said post on the same date. Stop. Then the respondent number 6 and 7.
Lordship,
Respondent 6 and 7.
Respond number 6 and 7 are.
Lordship assistant teacher, Lordship. I'm science and social studies, Lordship.
Respondent number 6.
Page 25 shows the date of joining of respond number 6 and 7, Lordship. Page number 25.
Respondent number 6.
Respondent number 6, date of joining is 13/5/94, Lordship. And respond number 7,
Was
7.
also appointed as. Respondent number 6 was appointed as
Science teachers, Lordship.
science
One is
teacher
science and one is social studies.
on 13/5/1994. And respondent number 7
Social studies.
was appointed as social studies teacher.
On 17/1/1999.
Night in the same school.
Then there's stop it right there.
They were regularized under, provincialized under which act?
Copy
Assam Education Provincialization of
on
Services, Teachers and Reorganization of
4/2/2021.
Act 17.
Provincialization order is at 4/2/2021 also.
Where?
It's Annexure 5, page number 28. Relevant portion is Lordship, page number 30. Serial number 41 and 42.
The provincialization of the services of the teaching and non-teaching staffs of the set, which school was it?
Same skill, Lordship, Ujan Telehor, ME School.
Ujan Telehor MA School was taken up in terms of the Assam Education within the provincialization of services of teachers and reorganization of educational institutions Act 2017. Within bracket, the Act of 2017 which order. Stop. The District Scrutiny Committee recommended the case of the respondent 6 and 7. Correct?
And also petitioner name is also sent to state.
Recommended the case of the petitioner as well as the respondent 6 and 7 for provincialization of the services. However, the state level scrutiny committee rejected the case of the petitioner and provincialized the services of the respondents 6 and 7 by order dated, by notification dated 4th February 2021, correct?
Lordship.
Issued by the Director, Elementary Education. Stop. Para. It is the case of the petitioner that he is senior
Lordship.
to the petition respondents 6 and 7. And therefore, his case should have been considered and provincialized by the state level scrutiny committee as already recommended by the district level scrutiny committee. Stop. Para. No, considering the issue involved, comma, the petitioner is directed to file an appeal under section 14 of the Act of 2017 before the secretary, school education department, is it? School education department. Within the period of
15 days, Lordship.
within the period of 15 days with effect from today. So, after the Secretary School Education Department on receipt of the appeal shall consider the same and after giving an opportunity of hearing to the petitioner as well as the respondent 6 and 7 shall dispose of the same in accordance with law within a period of 2 months from the date of receipt of a copy of the with the aforesaid observation.
Obliged, Lordship.
50.
At least your lordships, lordship, on the last occasion, an order dated 29/5/2023, respondents were supposed to file an affidavit. Secondary education has already filed, but the private respondent number 7 has not filed yet.
Who appears for private respondent?
Private respondent, no, nobody is.
Senior counsel M.K. Chaudhary appears on behalf of respondent number 7. Lordship, since sufficient amount of time has passed, lordship may take up after vacation for final disposal, lordship.
Heard, Mr.
Yes, Gautam, lordship.
Yes, Gautam. Let me counsel for the petition. Stop. The secondary.
I am for the
education
secondary education department, Bill Sharma.
has filed counter affidavit. However, respondent number 7 is yet to file counter. Stop. 3 weeks further time is allowed to the respondent number 7 to file its counter affidavit. List the matter after the immediately after the summer.
Lordship, a date may be given.
After summer vacation, I'm not giving dates. You have to mention.
Lordship, in the meanwhile, we can file our reply also.
Yes, yeah.
51.
In this transfer method, or in this case, Honorable Justice Malad, to pass order Malad on 12/4/23 to comply the order. Transfer My lord, visa, before that, subject. we have already complied with this order, lordship. If he has any grievance that he has to challenge this order, lordship. Because we have in a compliance order, lordship, we have written that the daughter of the petitioner has filed a petition on 18/12/2022, lordship, 20. But before that, lordship, the Assam Elementary and
Compliance
Yes,
order.
yes, my lord. In spite of that, my lord, Honorable Chief Justice heard this letter, seen this letter, thereafter passed this letter, you comply with this order. In this way, that order was passed. Now, if it was, my lord, passed on 12/4, my lord, 23. That was there, I think, already, lordship.
3rd February.
Yes, that we deduct.
Yes.
Yes, 3rd of February, yes, lordship. Lordship, there is a, for transfer of the employee, lordship, there is an act. Lordship, the government of Assam has enacted an act, lordships.
Where's the order?
Lordship,
Chief Justice order, my lord, 12-4, my lord.
I'm asking about.
Chief Justice has directed to
This
compliance
court
only. He is
order.
already harping on the Chief Justice or Honorable Chief Justice order. Let us to comply. We have already complied.
Who is the order passed by this court?
Oh, yes, my lord. That order was, my lord, passed on page. That is starts from 14 and direction page 17, my lord.
This is not compliance, Mr. Chief.
No, no problem. Lordship, can you peruse the order, Lordship, that the transfer, Lordship, the government has enacted and rule of act, Lordships. This is Assam Elementary Secondary Teacher Regulation of Posting and Transfer Act 2020. The act came into force, Lordships. That particular act, Lordship, came into force on 26 May 2020. 26 May. And the petitioner, in terms of this particular act, they have to apply for online, Lordship. And the petitioner daughter has submitted on 18/12, that is after the enactment of this act. Instead of applying online, she has made a physical application, Lordship, before the authority. Let her make an online application that
Already done, my lord. Even online application also done. my
that
lord.
will consider, Lordship.
Have you done it?
Yes, my lord. Even after, in spite of this honorable court's order, my lord, I have applied for the online. That has not been considered.
Let him challenge that, bring all this tag in a repetition, Lordship. after
5 years, my lord. After my death of my husband, my lord, both my son and daughters are here in the college in Guwahati, my lord.
We cannot bypass the act,
In
Lordship.
Kasar, after the death, my husband was the first person, my lord, who expired in Corona.
That is all right.
That's why I need, my lord.
In order, it is stated, let her make an online that department will
You want to
consider.
challenge this order?
Yes, Lordship.
Or
And bring all
continue
these
with the
facts.
contempt?
But would the your lordship may allow
let
to
him-
run this contempt case, my lord, because my lord,
So I'll close this contempt.
Yes, Lordship. And let him file a
my lord,
repetition, Lordship,
honorable court,
challenging.
my lord, earlier occasion, my lord, honorable chief justice, my lord, seen that letter, but you have not complied. So you comply it within 10 days.
Order
That order was
nothing,
passed.
Lordship.
Okay, we'll take up some other
Yes,
day.
my lord.
If you're not-
12-4, my lord.
Lordship, unnecessarily this case has been pending, Lordship. Let him file a repetition, challenging this order. That will be that will be the appropriate
There's no
question. Man,
time
he's
asked.
harping on the honorable chief justice, that order, Lordship, there's nothing, only to comply, Lordship.
Yes, does.
He'll not get anything, Lordship. He's doing injustice with petitioner.
If your
himself.
lordship directives, then
He has to
with
challenge this and
that
step
liberty,
fully.
my lord.
But as it does, when the council for SMT chief, when it's standing, council appearing for respondent.
And for all respondents, 1.3.
Appearing on behalf of all the respondents has permission ordered at the 3rd February 2023. Issued by the Secretary of the Government of some Department of School Education. Wherein it is decided that after completion of ongoing process of submission of applications through online portal, the transfer and posting of teachers shall be done in the online mode, provided that the applicant fulfills the criteria as laid down in the transfer rule 2022 and subject to registration and submission of application in the online portal. Stop.
I have already,
Proposal of the order dated 3rd February 2023. This court is of the considered opinion that the order passed by this court has been complied with substantially. So accordingly, this contempt petition is closed, however, giving liberty to the petitioner.
I have already applied for online.
However, giving liberty to the petitioner to challenge the order dated 3rd February 2023.
Oblige, your lord.
It's right, please.
52.
See the order dated 2023, my lord.
And last is on Mr. Yeah, so let it come next week. Mr. NJ Khatna, he has received the Okalnama lawsuit. I think he's supposed to file it today.
Mr.
Let it come next week lawsuit or after vacation lawsuit.
AK Azhar, then the council.
Let it come after vacation lawsuit. After vacation lawsuit.
List the matter after.
Maybe
Summer
mind a date.
After summer vacation, I'm not giving date.
53,
53 method. Vijay.
My lord, last occasion, my learned friend asked to take the instruction, my lord. My lord, so far the hearing is concerned, my lord, persons to the honorable court. Hearing also completed long back, November 2022. Order passed this honorable court more than 1 year, my lord.
Only thing is that Vijay Sori lost it. He has already seen all the suffering from.
My lord, it is a recent case, my lord, long back, 1 year back, my lord, what the respondent are doing, my lord.
Who is?
My lord, always
who is
time
in-
taking
who
this
is in-
type of
Who is in
style
charge
will
now?
not do, my lord.
And now Narayanpur. Narayanpur Secretary School Education.
That also you have to implement. also.
That is why your lordship last occasion passed the order instead of, my lord, these are the all technical, since the hearing been completed, my lord, order can be passed.
Yes.
As per my lord, when the writ came, my lord, the respondent of
Secretary.
Minister. Your good name? AK
AK
Hussain. Learned Council on request Ms. by Assembly Trustee. Learned Council for the respondents. List the matter after 2 weeks to enable him to receive instructions.
P4,
By 2 weeks, you come with instructions listed.
highly.
Tata, what is it? Yes.
My lord, in this case, we have been granted salary, monthly salary, my lord, and pursuant to the interim order, we have been given benefit, my lord. And only the limited gap period of my service, I was on leave, that has to be regularized by the authority. That may be done and disposed of, my lord, by this order.
What is it?
This is the compliance of the interim order. They have issued the order, my lord.
What interim order was passed?
Interim orders are allowed to continue in service, my lord. It's interim order.
Service or
I was on the leave.
Where is the order?
Interim order is there, my lord.
Seven cents. Let us see the order. Yes, what do you want?
But this order may made absolute, and my only the period of leave that they have not paid the salary that is pending due to pendency of the case, my lord. This may be directed to by the block officer, may be paid, my lord, and may closed.
I need to get our inspector. I have not received the instruction.
Okay, but Mr. B, put that as well, then we council proposition. Mr.
That's Barlow. For SSA.
London Standing Council, SSA. Is allowed, how much time?
Let it come after vacation only.
This for 3 weeks time for this thing, that this is allowed, this time it after.
Any date in the month of August, my lord, by fixed.
Maybe come over the next.
55.
Lordship, may kindly peruse the office note dated 13/6/2023, Lordship. Notices were issued to respondent number 1 and 2, but neither answer notice nor ID card has been received back. Notice was issued on 28/2/2023, Lord.
Respondent 2 is sick. Someone is taking charge.
Lordship. I shall.
Chishti?
Yes, Lordship.
This Bijua Chaudhary, she's the,
Vijay Soro, yes, she is on long leave, Lordship.
that's the reason why.
Oh, Vijay Soro now, particularly.
Lordship, I shall take steps for implement of the.
Mr.
I am MP Shamal.
MP Shamal and the council for petitioner prays for 3 weeks time.
Lordship.
To take steps to file an appropriate application for implement of necessary parties. Praise allowed. List of 3 weeks.
Lord.
56. May I please your lordship, this is first time listed lordship, notice to go.
Where's the order?
Order is page 18, page 12 lordships. Order dated 1/11/2022. The relevant part is page 17.
What is your grievance?
Grievance salary not been paid, lordship. Area as well as current also.
But Mr. Have you Barwell and the council for the petitioner, issue notice. Petitioner takes steps for service of notice on the sole respondent when registered post AD within 1 week, list of the 6 weeks.
Obliged. 57.
This is for non-compliance of the order dated 35/2022. Order starts from page 17 onward, 11 part, your lordship will find. Page 22, your lordship. Paragraph 13, 14, your lordship. Page 22, your lordship. Last paragraph. And direction was paragraph 14, your lordship. Direction was given to the secretary, Department of Secondary Education here, your lordship, to take a decision regarding the prayer of the petitioner regarding condonation of the your lordship. Here, your lordship, secretary, the Secondary Education Department was directed for, and petitioners are the.
Where's the operative portion?
Page 24, page point number 16, your lordship. Secretary may pass a reasoned order on the individual application being filed. It is requested that the individual application be submitted forthwith and the secretary to pass respective reasoned order within a period of 2 months from the date of the receipt of the individual application.
Have you submitted your application?
Yes, your lordship. What happened, your lordship? Here, your lordship, the secretary, Secondary Education Department was directed, and the petitioner are the person under the elementary education, your lord, for which they filed a repair application, your lordship. And your lord, this honorable court by order dated 14/9/2022, page 37, your lordship. The review petition was allowed, your lordship.
Yes.
Page 37, Point number 5, your lordship. Accordingly, paragraph 14 of the judgment order is the 35/2022 in WPC 4177. May I read to your lordship? In respect of the present review petition, namely, here the petitioner's number reflected, your lordship. To be read to the secretary to the government of Assam in the elementary education department, your lordship. Thereafter, petitioner submitted application and your lordship kindly peruse page
Mr.
K. Mira, your lordship.
Cameron and the council for petition issue notice. Petition takes this proceedings of notice on the sole respondent by registered post ID within 1 week, list up to 6 weeks.
58.
My lord, refusals.
Yes.
May I, Lordship, I appeal on behalf of the 8 for respondent number 5 and 6. He already left the court due to his personal difficulty for Pasavada matter for that day, my lord.
In fact, my lord, this matter was listed Friday last, my lord, and my lord. And my lord was
My
pleased
lord, due to
to
his personal
observe
difficulties already he left
that
the
in
court.
this Friday, today, my
Over the
lord,
day.
the matter can be disposed of. Only, and matter is relating to the constitution of the SMDC. Earlier SMDC has expired. And thereafter, my lord, by the impugned communication, my lord, the president and the vice president has been nominated.
But Mr.
M.H. Chaudhary, my lord.
Kevin Chowdhury, learned counsel for the petition. On request made on behalf of A. Deka.
My lord,
Learned
for
counsel
respondent number 5 and 6.
will respond 5 and 6. List the matter again on
For in next week.
26th.
Highly blessed.
59.
Yes, your lordship. The page 42, your lordship. This page 42, this letter has been issued, forwarded by principal, Assam Engineering College for fixation is pay to onward submission of PRU. But Director of Technical Education from 26/7/2022, in spite of having speaking order, withhold my file. And this file should be released promptly in view of the letter dated page 36, your lordship kindly see.
You are on the IA?
Yes.
Yes,
Why is holding up this letter?
Lordship, the prayer in the IA as well as the petition is same and we'll reply. in the
No, that is not a.
We'll reply in the petition. This is for the second time the matter has been listed. For long, it was not listed. It was not in our notice. Immediately.
No, I am asking to release my file within time bound manner.
It is not known, Lordship, why it has been kept, Lordship.
let him take some instructions and
How
come
can we
back.
say-
File the specific affidavit, my lord.
Yeah, Mr. G. Bata.
B Sharma.
Heard Mr. B. Sharma, learned counsel.
Within time bound manner, my lord.
Applicant. Mr. A.R. Tabilta, learned standing counsel.
Higher education department.
Higher education shall receive instructions. for the
IIT?
matter. This the matter after 1 week, I'll give you.
Lordship.
1 week.
Particular date may be fixed, otherwise it's very difficult to list the matter, my lord. Date may kindly be fixed, my lord.
After vacation, Lordship, it is not possible.
Allow 2 weeks. time.
It is very urgent since 2011, no pay has been fixed
This-
in spite of speaking
after
order.
the Summer vacation.
Particular date might.
You can mention it after the summer vacation. After
All
summer
right,
vacation, I will.
May it please, Lord. My lord, in this case, I filed an IA for clarification. There was no interim order as such, but then I wanted some clarification. I understand as filed an affidavit yesterday, by which he has sought to take time for filing a reply. I have no objection to filing the reply. But my lord, because of this confusing order, the salaries the staffs are not getting. So my prayer is, since I filed it on 2nd of June, long back, but I understand doesn't file. She can file, I have no problem. But lordship will kindly, because this matter is extremely urgent on reopening day, if lordship fix the matter, because the staffs are not getting
But,
salary.
Mr. PK Roy,
Your lordship.
the senior counsel assisted by
SK Chakraborty.
SK Chakraborty, the counsel for the applicant.
Yes, Lord.
On request made by MS Burma.
Chakraborty.
P Chakraborty. Then the standing counsel, no.
No, my lord,
Standing counsel for the-
appealing for the
standing counsel
petition.
For the
Read petitioner.
writ petitioner oblique opposite party number 1, I think,
Opposite party number 1.
correct?
Yes.
Yes, in this IA, she is opposite party number 1.
You want to file objections?
Yes, my lord, I want.
2 weeks time is allowed to file objections. List the matter immediately.
On 17th, my lord. Lordship is extremely hard. These people are not getting salary. Grateful.
18th.
18th, Lordship, that's
Fine.
right. Deeply obliged.
61.
Last three.
May I please your lordship, lordship, in this,
Yes.
this matter, lordship, record was called for from the tribunal, lordship, but it was not received, lordship. So that matter may be posted after vacation, lord.
Heard, Mr.
MS Majumdar.
MS Majumdar, then counsel for petitioner, list this matter on request made by SMT Chisti, then it's standing counsel,
Elementary.
elementary education list after the summer vacation.
Obliged.
62.
Met please, your lordship.
Yes.
Lordship, what happened, lordship? The name of the petitioner is wrongly quoted by the state level committee, for which I am suffering for last 3 years, lordship.
Yes.
Lordship will kindly get page 42, lordship, for a moment.
Today we have no time.
Lordship,
I'll just fix a date.
Lordship. Kindly.
I am appearing for response number 6.
Service is also.
Mr. R Islam,
Lordship.
then counsel for petitioner on request made by SMT Chisti. Then it's standing counsel.
Secondary.
This after the summer.
Lordship, service is complete. Respondent number 6.
Mr.
MZ Shah.
MZ Shah, then the counsel appears on behalf of the.
Respondent number 6.
Response number 6.
Respond number,
6.
Both are case 62, 63.
same order,
Lordship, a date may kindly be fixed, lordship.
not after.
Not
summer
after
vacation.
vacation.
After summer
After
vacation, you'll have-
vacation, a date may kindly be fixed, lordship.
You
I am
can-
suffering from last 3 years, lordship.
you can make your mention, mention.
Obliged.
68 of supplementary.
In the meantime, secondary education shall file affidavit.
Yes.
Yeah.
68, lordships, they have to implement the new incumbent, the disaster is on leave,
Yes.
a long leave.
Yes, lordship.
You have to file implement.
Mr.
We have to, ALMSK, lordship.
A Alim Sheikh, learned counsel for the petitioner prays for 3 weeks time to enable him to file an appropriate application for improvement of parties. Praise
Obliged.
the Lord, list after 3 weeks.
59.
May I please, lordship?
In
this case, I am appearing for the respondent number 9, but we have not received a copy, my lord. One copy may be provided.
Secondary, okay?
Yeah, put it on behalf of respondent number 9.
Yes, lordship. He has come to know from some other source the case is filed, so he has filed.
How about 7, 8,
Rest of the respondents,
4, 5, 6, 7, 8? Anybody?
The service complete from BTC. They do BTC. He's from BTC lordship. Their private respondents, I think they have not yet appeared.
We have been promoted,
1 minute.
এটা আর নেকবি আছে তারপর 5টা বাজে বলবে
You'll have to take fresh steps.
yes sir.
Also, earlier we have taken a step and met the party, we have sending the letter on the care of the director of secondary division.
Do you want to take a dusty service?
Earlier we have sending register post.
Do you want to take dusty service or not?
Yes,
Or you want to proceed with again registered post?
just a service, my God.
Mister, And Islam. And Islam, then counsel for petitioner praised for taking first steps for service of notice on respondents 4, 5, 6, and 7, 4 to 8 by trustee service. Praise allowed petitioner is permitted, shall take first steps for service of notice on respondents 4 to 8 by justice service to the registrar of this court within a period of 1 week, 2 weeks. 2 weeks from the day. Thereafter, petitioner shall file an affidavit with the court. List after 3 weeks. Mr. B. Purkayasta, Leonard's counsel enters appearance on behalf of this one number 1.
Nine.
You furnish one copy. to-
One copy I need.
70.
Yes.
Contempt matter, my lord, order, my lord, at page 17, my lord. Page 17, my lord, it is order dated, my lord, 8/8/2022, my lord, almost 1 year, my lord.
Who is the direction?
My lord, direction, my lord, next page, my lord, it was directed to the DLC, my lord,
Page.
my lord, 18, my lord. And my lord, I immediately submitted, my lord, the order, my forwarding, my lord, application, my lord, page 37, my lord.
No time period was given.
Yes, my lord, maybe, my lord, but it is long time, my lord. Lordship passed order, lordship kindly will look page 17, my lord. Page 17, my lord, it was order was passed, my lord, on my lord, 8/8/2021.
But no time period was
My lord,
given.
time
so
period is there, my lord, because in the main judgment, my lord, the Achyutan Das, my lord, I have annexed, my lord, two months, in each 2 months, my lord.
Oof, I'm talking about this judgment. This court did not give you any, did not give any time period to the DLC.
Maybe this was how the giving, my lord, time, my lord, 2 months time. My lord. Or
By this contempt petition, heard Mr. M. Barwell and counsel for the petitioner. Stop. By this contempt petition, the petitioner is alleging non-compliance of the order dated 8/8/2022 passed by this court in the WBC number 5003 of 2022. Stop. Operative portion of the order dated 8/8/2022 reads as under. Stop. 8 to 8, page 18. Stop. A consideration of the direction passed by this court in the order dated, sorry, in the order the 8/8/2022. Cancel it. A perusal of the direction passed by this court by the order dated 8/8/2022 in the WBC 5003 of 2022 indicates that no time frame was given to the DLC to consider the matter of, to consider the case of the petitioner. Accordingly, this contempt petition is disposed of, directing DLC to consider the case of the petitioner in terms of the order dated 8/8/2022 passed in WBC number 5003 of 2022 in its next immediate sitting.
or my lord, before 2 months or next meeting. my lord.
In its next immediate sitting.
Next meeting, my lord, they may take at that time, my lord.
What is the point now? How can I direct them to sit?
My
They will sit when they, when.
My lord, in the Achyutan, my lord, it is already provided, my lord, DLC to be taken in each 2 months, my lord, and SLC within each 3 months. my lord.
In its next immediate sitting.
In a contempt petition, there will be another direction. How can it be adopted?
Yes, in its next immediate sitting. Accordingly, contempt petition is with the above directions, contempt petitions.
Obliged.